ಕೇಳ್ತಿಲ್ಲ
ಮೇಡಮ್ ಯಾವತ್ತಿ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡ್ತಿಲ್ಲ.
ಇವತ್ತು ಯಾವ ವಾರ?
ಬುಧವಾರ.
ಬುಧವಾರ. ನೆಕ್ಸ್ಟ್ ಬುಧವಾರಕ್ಕೆ
ಮೂವ್ ಮಾಡಿ ಮೇಡಮ್.
ನೋಟಿಸ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಗೊತ್ತಲ್ಲ ಅಲ್ಲಿ 18 ಏನ್ ಸತೀಶ
ಭಟ್ರೆ ಸತೀಶ್ ಏನೋ ಭಟ್ರನ್ ಕರ್ಸ್ಬಿಟ್ಟಿದ್ದೀರ. ನೀರ್ ಕೊಡ್ಬೇಕು.
ಯಾವತ್ತಿಗೆ ಬೇಕು? ನಾಳೆ
ಹೇಳ್ಬೇಕಾ? ಹೇಳ್ಬೇಕಾ?
ನಾಳೆ ಹೇಳ್ಬೇಕು.
ಹೇಳ್ಬೇಕು.
ಒಂದೇನಾಗಿದೆ
ಬೇಕಾಗಿದೆ. ಸರಿ ಇದು
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಆದ್ರೆ ಮೆನ್ಷನಿಂಗ್ ಇದ್ರೆ ಅಲ್ಲಿ ಕೊಟ್ಟರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಎಷ್ಟು ಮಾಡ್ತೀವಿ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರಲ್ಲ ಸರ್.
ಎಸ್
ಒಂದು 10 ದಿನದಲ್ಲಿ ಬರುತ್ತೆ.
ವಿತಿನ್ 10 days. ವಿತಿನ್ 10 days ಮೆನ್ಷನಿಂಗ್ ಮಾಡ್ಬೇಕಿದೆ ಮಾಡಿ. ಈ ಮ್ಯಾಟ್ರ್ ಸರ್ ಏಜ್ ಅವರೇ ಮೂವ್ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ ಏನಾಯ್ತು?
ಹೀಗೆ ಬರೋದು ಗೊತ್ತಾ? ನನಗೆ ನೋಡಿ ಆ ಸೈಡಿಂದ ಈ ಸೈಡ್
Repatriation. Matter is repatriation.
ಎಂತದು?
Repatriation.
ಹಾ,
Not completed the minimum 10-year blood, I have been repatriated.
ರಿಪ್ಯಾಟ್ರಿಯೇಟೆಡ್.
Please, Lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ? ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್.
Lord, if I am relieved, Lord,
ಏನ್ ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್? You don't have any right. You see 77 Supreme Court. You have no right to
I have
continue.
not completed the minimum 10-year at all, Lord.
Huh?
Still, Lord, I have completed only 1 year, Lord.
Next.
Tomorrow, Lord.
Tomorrow ಸರ್ವಿಸ್ ಡೇ ನಾಳೆನೂ ಇದೆ.
ನಾಳೆ.
ಇದೆಯಾ?
ನಾಳೆ ಇದೆ.
ಹಾಕಿ, ನಾಳೆ ಹಾಕಿ.
But fresh matter for tomorrow, my lord. Similar request.
ಹಾ,
My lord, against rejection of interim order, writ petition is filed.
ಏನು ಎಂಟ್ರಿ ಮಾಡು?
My lord, suspension matter based on a registration of criminal case. Criminal case, my lord, stayed by this honorable court. My lord, on 28/2, my lord, my interim prayer is rejected. My request for service date tomorrow, my lord.
ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಸ್ಟೇಡ್.
State.
ತೊಳಿ, ನಾಳೆ ಹಾಕೊಳ್ಳಿ. ಅದು ಸುಳ್ಳಿದ್ರೆ ಮತ್ತೆ ನಾಳೆ ಹೋಲ್ ಮೇನ್ ಮ್ಯಾಟರ್.
ಆಯ್ತು ಸ್ವಾಮಿ. ಆಯ್ತು.
21 matter. There is an interim order since 2024. Seniority list announced Vicharದಲ್ಲಿ. There is an interim order in operation since 24.
Since 2024.
Yes, my lord.
Correct.
Final
Next.
seniority list need to be.
All next week.
DM consumer.
Ah.
My application was rejected in the section 47 of CPC.
47 of CPC execution. ಇಲ್ಲ ಹೆಂಗ್ ಬರ್ತದೆ?
ಅಲ್ಲ 7th.
Not assigned to.
7th.
11th ಅಲ್ಲಿ ಯಾವತ್ತಿದೆ?
ಅಲ್ಲಿ 13th ಇದೆ ಸರ್. 7th.
13/7.
ಅಲ್ಲ 13/3 ಇದೆ.
13/3.
7th.
Okay, 11th. ಮೆಮೊ ನೋಡಿ. ಹಾ, ಅದೇ ಇದನ್ನ ಮಾಡ್ಕೊಳ್ಳಿ, ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಇದನ್ನ. ನೀವು ಮಾತಾಡೋದು ನಮಗ್ ಕೇಳ್ಬೇಕು, ನಾವು ಮಾತಾಡೋದು ನಿಮಗ್ ಕೇಳ್ಬೇಕು.
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್
ಟುಮಾರೋ.
ಆಮೇಲೆ ನೀವು ಮಾತಾಡೋದು ಅದನ್ನ ಹಿಂಗ್ ಕೋಟಿ ಕೇಳಬಾರ್ದು. ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್ ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಎಷ್ಟು ವರ್ಷ ಇದ್ರಿ ಅಲ್ಲಿ ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್? ಯು ಆರ್ ರಿಟೈರಿಂಗ್. ನಾಳೆ ಹಾಕೊಳ್ಳಿ.
Fresh matter. Classification is GM con in state consumer matter, the roster before this bench.
ನಾಳೆಗೆ.
I cleared all the office objections. We posted for final disposal this month. Next week, any day will be.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ.
Still,
Ah.
for 20 minutes, I have to frame additional substantial questions of law.
20.
20 minutes.
All.
I am paid for the respondent. It's a covered issue.
Number 30, my lord.
Serial number
2
20
weeks
is covered by Flipkart's decision.
Serial number
Covered.
13.
It's covered.
Even otherwise not before me. Even otherwise not before me. Yes. Not before the bench comprising of KSDJ.
Serial number 30, my lord.
Achha.
30, my lord.
13.
30, my lord. 30,
30.
my lord. 2 weeks, my lord.
30. 2019 matter. Anamala ಏನಿದು?
Yes, my lord. Get ready and argue, my lord. 2 weeks. Time.
All. 2 weeks finally at the request of Anamala.
Much of.
Serial number 27, my lord.
27.
Week's time, my lord. Any day next week, my lord.
The matter where I'm instructed. This could be finished in no time. It's a covered case. My learned friend wants it on 12th. It could be taken on 12th.
Next week ಹಾಕೋ.
12th.
My lord, serial number 34, my lords.
30.
34, my lords. STA 18. My lords, it is to be listed along with 2 more connected petitions, my lord.
Kodi.
STA 19 of
ಬರ್ಕೊಡಿ
2022.
ನೋಡಮ್ಮ, ಬರ್ದಿಸ್ಕೊಳ್ಳಿ. ಅವ್ರಿಗೆ ಚೀಟಿ ಕೊಡಿ ಅವ್ರು.
Yes, my lord.
My lords, may I mention item number 28?
My lords, one more submission. Can it be taken up on 19th, my lord? Senior counsel is engaged.
19.
Yes.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲಿಯವರ ಹೊರಗಿನವರ?
B. Raghuraman.
ಹಾ?
B. Raghuraman.
ರಘುರಾಮನ್ ಮತ್ತೆ ಇಲ್ಲಿಯವರಲ್ಲ. ಎನಿವೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಷ್ಟೇ ಟೈಮ್ ಡೇಟ್ ಕೊಡದಿದ್ರು ಹೊರಗಿನ ಕೌನ್ಸಿಲ್ ಇರಬೇಕು. Yes.
My lords, may I mention item 28? I am seeking 2 weeks time, my lords.
28.
Yes, my lords.
This we have already read the file again.
My lords, on the last occasion also we,
This was posted.
my lords, on the last occasion also, I had informed my lords that we have approved under Vivad Se Vishwas scheme and the applications are still pending, my lords. We are anticipating a final closure in the next 2 weeks.
Wait. 2019 matter. Twice you have already taken. Yes, next. Yes. Memo reads as under. There is no objection from the panel council appearing for the revenue to grant leave to withdraw. First up, in view of the above, appeal is disposed of as having been withdrawn.
My lords, one humble submission. Liberty may be given to.
In terms of memo.
Achha.
Okay. Cost made easy. ಇದು ಎರಡೂನಾ?
Yes, my lords.
Okay. ಸಪರೇಟ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಎರಡು. Yes, serial number 2. Why withdrawing? Not happy with the court or what? That's a bad thing. If somebody withdraws case, one judge should not be happy. Why? Relief is granted. No. Same order.
Dispute has been resolved in the.
Resolved. Okay, ನೋಡಮ್ಮ.
You
Same order. Memo read signs. Resolved ಇದ್ರೆ ಅಡ್ಡಿಲ್ಲ. ಆದ್ರೆ ಸುಳ್ಳೆ ನೀವು ಇಲ್ಲೇನು ಸಿಗಲ್ಲ ಅನ್ಕೊಂಡು ನೀವು ವಿಡ್ರಾ ಮಾಡ್ಬೇಡ್ರಿ. Yes. Same. ಎಲ್ಲ separate ಮಾಡ್ಬೇಕು.
My lord,
5 also same.
Sri Aditya is on leave today, my lord. He has requested that it may be taken up.
Withdrawal. Okay. ಇದೇನು ಅಂದ್ರೆ ಈ ಆರ್ಡರ್ ಬರೆದ ಮೇಲೆ ನಾನು ಜಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ವಿ. ಬಿಕಾಸ್ ಹೆವಿ 20 crores ಏನೋ ಇತ್ತು ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡಿದ್ವಿ, ನಿಮ್ಮಿಬ್ಬರನ್ನು ಇವರ ಚಿರಂಜೀವಿ ಹ್ಯಾಡ್ ಕಮ್ ಅಲಾಂಗ್ ವಿತ್ ಮಿಸ್ಟರ್ ನಾಯಕ್, ಇಬ್ರು ಅಪೋನೆಂಟ್ಸ್ ಕರೆಸಿ ನಾವು ಬರೆದ ಆರ್ಡರ್ ಡ್ರಾಫ್ಟ್ ಸರಿ ಇದೆಯಾ, ಯಾಕಂದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಇವ್ರನ್ನೆಲ್ಲ ಕೇಳ್ಕೊಂಡು ಅದ್ ನಾವೇಲೆ ಫೈನಲೈಸ್ ಮಾಡೇವಿ ನಾವು.
ಬಟ್ ಅದ್ರೊಳಗೆ ತೊಂದರೆ ಆಗ್ಲಿಲ್ಲ. ಅದ್ರೊಳಗೆ ತೊಂದರೆ ಆಗ್ಲಿಲ್ಲ. ನಾವು
ಒಂದು your lordship were fully very well aware that there could be difficulty which arises.
Of course.
ಅದಕ್ಕೆ ನೀವು ಆರ್ಡರ್ ಬರ್ದಾಗ ಏನ್ ಬರೆದ್ರಿ, it is also necessary to bring to the notice of this honorable court that possibly anticipating that there may be some problems. This honorable court made it very clear that if any difficulty arises in implementing the order in letter and spirit,
ಹಾಗಾಗಿ
parties should move this honorable court to appropriate
ಏನೀಗ
application.
ಡಿಫಿಕಲ್ಟಿ ಏನಿದೆ ಹೇಳಿ.
ಅದಕ್ಕೆ ಈಗೇನಾಗಿದೆ, ಇವರೊಂದು ಲಿಸ್ಟ್ ಕೊಟ್ರು.
ಇದು ಇನ್ಫ್ಯಾಕ್ಟ್ ಸೋಮಶೇಖರ್ ನೋಡಿದ್ರು ಆರ್ಡರ್.
Your lordship said,
ಆರ್ಡರ್ ತೊಂದರೆ ಇಲ್ಲ.
your lordship said 20 crores ಕೊಟ್ರೋ ಇಲ್ವೋ, Mr. Naik was told ಅಂತ ತಾವ್ ಹೇಳಿರಿ. Your lordship said once money is paid, Murthy has nothing to do. ಅದು ಇವ್ರೇನ್ ಮಾಡಿದ್ರು, ಅದನ್ನ ಲೆಟರ್ ಅಂಡ್ ಸ್ಪಿರಿಟ್ ಅಲ್ಲಿ ತಗೊಂಡು ಯಾರ್ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿ ಅಪ್ರೂವಲ್ ತಗೊಂಡ್ರು ಕೋರ್ಟ್ ಇಂದ.
ಅಲ್ಲ, ನೀವು 2 ಶಬ್ದ ಉಪೇಕ್ಷಿದ್ ಒಳ್ಳೇದ್ ಮಾಡಿದ್ರಿ, ಲೆಟರ್ ಅಂಡ್ ಸ್ಪಿರಿಟ್ ಅಂತ. ಒಂದೇ ಉಪೇಕ್ಷಿದ್ರೆ ಸ್ವಲ್ಪ ಸಮಸ್ಯೆ ಆಗ್ತಿತ್ತು.
ಸ್ಪಿರಿಟ್ ಸ್ಪೆಲ್ಲಿಂಗ್ ಗೊತ್ತಷ್ಟೇ ನಂಗೆ. ಅದರಿಂದ ಏನಾಗಿದೆ, this a matter for last 40 years. It became.
ಈಗ ನಾವ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ.
ಏನಿಲ್ಲ, ಇಷ್ಟೇ ಒಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ವಿ, ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಎ ಅಂತ. Some mistakes have been pointed out by the management. ನೀವು ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಕೆಲವ್ರನ್ನ, ಅವ್ರು ಬಂದು ನಮ್ಮನ್ನು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ. Then we said we'll not pay if your list is not proper. Go and get the list rectified and
ರೆಕ್ಟಿಫೈಡ್ ಲಿಸ್ಟ್
ಮಾಡಿ. ರೆಕ್ಟಿಫೈಡ್ ಅನೆಕ್ಷರ್ A1 ಕೋರ್ಟ್ ಆಫ್
ಈ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇರೋರಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ?
ಎಲ್ಲರಿಗೂ ಕೊಡಕ್ ರೆಡಿ ಇದೀವಿ.
ಅಷ್ಟೇ.
ಒನ್ ಸಬ್ಮಿಷನ್. ಈ ಲಿಸ್ಟ್ ಪ್ರಕಾರ ನಾವು ವಿತಿನ್ 3-4 days ಕೊಟ್ಬಿಡ್ತೀವಿ ದುಡ್ಡು, ಎಲ್ಲ ರೆಡಿ ಇಟ್ಟಿದೀವಿ. ಆಮೇಲೆ ಯಾರು ಬಂದು ದೇ ಶುಡ್ ಟೇಕ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ.
ಹೌದು,
Your lordship may make it clear.
Take responsibility.
ಯಾಕಂದ್ರೆ ಇದು ಎಂಡ್ಲೆಸ್ಲಿ.
He will take responsibility.
ಈಗ ಹಾಸ್ಪಿಟಲ್ ತಮ್ಮ ಪೇಷಂಟ್ಸ್ ಅನ್ನು ಟ್ರೀಟ್ ಮಾಡೋ ಬದ್ಲಿ ಈ ಕೇಸ್ ನಡೆಸೋದ್ ಕುತ್ಕೊಂಡ್ರು ಅಂದ್ರೆ ಮುಂದೆ ಅದು ಸಮಸ್ಯೆ ಆಗ್ತದೆ.
ಆಗ್ಬಾರ್ದು. ಅದಕ್ಕೆ ನಾವು ರೆಡಿ.
ಆಮೇಲೆ ಆ ಅಮೌಂಟ್ ಎಲ್ಲ ಬೇರೆ ಪೇಷಂಟ್ ಮೇಲೆ ಹಾಕ್ತಾರೆ ಅವರು. ಹೌದು,
ಹಾಕೋದ್ ಬೇಡ. ನಮ್ಮಲ್ಲಿ ಒಂದು ಚೂರು ಉಳಿಯುತ್ತಲ್ಲ, ಅದ್ರೊಳಗೆ ಕೊಟ್ಟು ನಾವು ಮುಗಿಸ್ಬಿಡ್ತೀವಿ. That's our undertaking. Because what happened, last week I appreciate your lordship passed an order on the last occasion. 20 crores ಜೊತೆಗೆ ಆ 20 crores is the money belonging to the union. ಅದ್ರದ್ದು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಬೇಕು. ಆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡೋದು ಕವರ್ ಆಗ್ಬಿಡುತ್ತೆ. ಇಂಟ್ರೆಸ್ಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ತಮ್ಮಿಂದ. That's why that is not
heard Learned Senior Advocate Mr. S.N. Murthy, assisted by Mr. Somashek, and Learned Counsel Mr. V.S. Naik, representing the union and the workmen. ನಿಮ್ಮ ಯೂನಿಯನ್ ಲೀಡರ್ ಇದಾರೆ ಇಲ್ಲಿ,
ಬಂದ್ಯಾ
ಕರೀರಿ.
ಸೇಮ್ ಪರ್ಸನ್
ಇಲ್ಲಿ ಕಾಣಂಗ್ ನಿಂತ್ಕೊಂಡ್ರಿ ಫೋಟೋ ಅವ್ರದ್ದೆಲ್ಲ ಇದು ವಿಡಿಯೋದಲ್ಲಿ ಬರ್ಬೇಕು. ಆಮೇಲೆ ನಾವು ಹಂಗೆ ಹೇಳಿರ್ಲಿಲ್ಲ, ಹಿಂಗೆ ಹೇಳಿರ್ಲಿಲ್ಲ ಅಂತ
ಅವ್ರು ಸೈನು ಹಾಕ್ತಿದ್ದೀನಿ ಇದಕ್ಕೆಲ್ಲ.
ಇದ್ರಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ, ನಿಮ್ ಇದರಲ್ಲಿ ವಿಡಿಯೋದಲ್ಲಿ ಬರಂಗ್ ನಿಂತ್ಕೊಳ್ಳಿ, ಒಂದ್ ಕಡೆ ನಿಮ್ ಕಡೆ ನಿಲ್ಸ್ಕೊಳ್ಳಿ.
ಆಯ್ತು.
ಬಂದಿಲ್ಲ
ನೋಡಿ, ಅವ್ರದ್ದು ಯೂನಿಯನ್ ಲೀಡರ್ ಇಲ್ಲಿ ಫುಲ್ ಅಪಿಯರ್ ಆಗ್ಬೇಕು. ನಾಳೆ ಏನಾರ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆದ್ರೆ ಅದನ್ನ ನಾವು ವಿಡಿಯೋ ಮತ್ತೆ ರೀಪ್ಲೇ ಮಾಡಂಗಿರ್ಬೇಕು ವರ್ಕರ್ಸಿಗೆ.
A memo with annexure A1 list is filed today. ಎರಡು ಸೆಟ್
both the sides. ಒಂದು ನಿಮಿಷ. The union leader, Mr. Bolegowda, son of Rangegowda, is present before the court. Kannada, English ಎರಡು ಬರ್ತದೆ. ಇವ್ರೇನು ವಾದ ಮಾಡಿದ್ರೆ ಅರ್ಥ ಆಗ್ತದ? ಈ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇರುವಂತಹ ಎಲ್ಲಾ ಜನರಿಗೂ ಅವ್ರೇನ್ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದಾರಲ್ಲ ಅದನ್ನ ಹಂಚ್ಬೇಕು ಅಂತ, ಕರೆಕ್ಟಾ? ಬೇರೆ ಯಾರ ಇದಾರ ಇದಕ್ಕ ಈ ದುಡ್ಡು ಹಂಚುವಂತರು?
ಎರಡು ಕಡೆನೂ ಅದು ಕುತ್ಕೊಂಡು ಅದನ್ನ ನೋಡಿದೀವಿ,
ನೋಡ್ಕೊಂಡು ಈ ಲಿಸ್ಟ್ ತಯಾರಿ ಮಾಡಿದ್ರಿ. ಎಸ್, ವಿ ಹ್ಯಾವ್ ಏನ್ ಬರ್ದಮ್ಮ? ಕುತ್ಕೊಂಡೆ ಓದು. Present before the court and participated in the proceeding. First stop. We explained the gist of the matter in Kannada. Full stop. He says that he understands both English and Kannada, and therefore he has understood the submissions of the bar, at the bar. Full stop. Next paragraph. Both the sides agree that both the sides and the union leader agree that the new list of persons now furnished
A1 A1 ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದೀವಿ
as annexure A1 ನಿಮ್ಮ application ಗೆ.
ಹೌದು.
To the subject application
Having 2274 employees.
Containing names of 2274 workmen to be operated for the purpose of granting benefit under the order dated 22/11/2024, whereby the writ appeal came to be disposed of. Full stop. Next paragraph. The union leader and Mr. V.S. Naik, representing the respondents, as also the union, submits that if any other claims hereafter arise, that would not be the lookout of the management at all, and that that would be the lookout of the union and the office of union and the office bearers of the union. First off, we also agree with this. First off, in effect, the liability of the management stands absolutely discharged qua all claims arising under the order in question. First, next paragraph. Ordered accordingly and the application is disposed of.
Your Lordship may say one thing, but in the light of this order, annexure A becomes redundant.
And
The other
A1
order.
In view of new list being furnished, the earlier one fails into insignificance.
And he's out of station. We have also in the application made a request for permission, my lord, in case small discrepancy irutte, date bit hogirutte aa tarattu. In such cases, 2 executives from the management, 2 office bearers from the union should sit and sort out anta ಒಂದು permission ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ವಿ. ಇದರ ಎಲ್ಲ ಟೈಮ್ಗೂ ತಮ್ಮ ಮುಂದೆ ಬರೋಕ್ಕಾಗಲ್ಲ. ಚಿಕ್ಕ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಡೇಟ್ ಆಫ್ ಜಾಯ್ನಿಂಗ್ ತಪ್ಪಿರುತ್ತೆ, ಅದಕ್ಕೆಲ್ಲ ತಮ್ಮ ಮುಂದೆ ಬಂದು ನಿಂತ್ಕೋಬೇಕು ಬೇಡ ಅಂತ.
First,
ಅದು ಕೇಳಿದ್ವಿ, INR ಕೇಳಿದ್ವಿ.
it is made clear that any minor discrepancies such as date of appointment, date of promotion,
Date of exit,
rates of wages,
exit,
retirement,
yes,
death, or determination of service shall be sorted out by the union with the assistance of the management officials.
Yes.
Officials. Full stop. However, if any error in that regard creeps in, comma, the management shall not be liable. ಯಾಕಂದ್ರೆ ಒಂದ್ಸರಿ ಮಾಡಿದ್ಮೇಲೆ ಇಲ್ಲ ಅವರು ಪಾರ್ಟಿ ಇದ್ರು ಹಂಗಾಗಿ
ಇಲ್ಲ, ಹಾಗೇನಿಲ್ಲ.
ಇಂಥವೆಲ್ಲ ಮಾಡ್ಬಾರ್ದು.
ಇನ್ನ ಮೈನರ್ ಎಲ್ಲ ಬಂದ್ರೆ ಬರ್ಬೋದು ಇಲ್ಲೇ.
ಅಲ್ಲ
And within 10 days they are prepared to
ಅಲ್ಲ ಈಗ
pay the entire amount.
ಇದನ್ನ ನಾವು ಡ್ರಾಪ್ ಮಾಡಿದ್ಮೇಲೆ in the open court we are telling you come to our chamber. ಇಬ್ರು ಎರಡು ಸೈಡ್ ನೋಡಿ ಚೇಂಬರಿಗೆ ಬರಬೇಕು. ಇದನ್ನ ಇನ್ನೊಂದ್ಸರಿ ಓದ್ಬೇಕು. ಇದ್ರ ಮೇಲೆ ಮತ್ತೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳಂಗಿಲ್ಲ. ಆಗ್ಬೋದು. ಬಂದು ನೋಡ್ಕೊಂಡು ಇದನ್ನ ನೀವು ಡ್ರಾಫ್ಟ್ ನೀವು ಇಬ್ರು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟು ದಿಸ್ ಕನ್ಸೆನ್ಸುವಲ್ ಆರ್ಡರ್ ಇದು. ಹಂಗಾಗಿ ಇಬ್ರು ಸೈಡ್ ಬಂದ್ಕೊಂಡು ನಮ್ಗೆ ಸ್ವಲ್ಪ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು.
Sorry, my lord, we have to trouble.
ಇಲ್ಲ ಸಾರಿ ಇದನ್ನ ಆಗ್ತಾವ ಮತ್ತೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ನೋಡಿದ್ವಿ ಆದ್ರೂ ತಪ್ಪಂತು.
ಇದು ಹೊಸ ಥಿಂಗ್ಸ್ ಹ್ಯಾಪನ್. ಓನ್ಲಿ ಥಿಂಗ್ ಈಸ್ ಅವರೆಲ್ಲರೂ ಸಾಯೋದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ ದುಡ್ಡು ಸಿಗ
ಈ 10 days ನೊಳಗೆ ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ದಾರೆ. ವಿತಿನ್ 10 days
ಎಷ್ಟೋ ಜನ ಸತ್ ಹೋಗ್ಬಿಟ್ಟಾರೆ.
ಎಲ್ಲ ರೆಡಿ.
ಅದೆಲ್ಲ ಪಾಪ ನಮ್ ಜಡ್ಜ್ಗಳ ಮೇಲೆ ಮೋಸ್ಟ್ಲಿ ನಿಮ್ ಮೇಲೆ ಬರ್ತಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನಮಗೆ. ಜಡ್ಜ್ಗಳ ಮೇಲೆ ಹೆಂಗೂ ಬರ್ತದೆ ಯಾಕಂದ್ರೆ ನಾವು ಇಟ್ಕೊಂಡ್ ಕೂತೇವೆ ಅಷ್ಟು ವರ್ಷ.
The director of the institute, the hospital is upset that the payment has not been made so far because ಇವ್ರು ಅದು ಮಾಡಬೇಡಿ ಇದು ಮಾಡಬೇಡಿ ಅಂತ ಕೈ ಕಟ್ ಕೂತಿದ್ರು.
ಆಯ್ತು
Obliged.
ಆಲ್ yes next Sidmalappa.
My lord. Yesterday your lordship asked me on the point regarding the
Honorary teacher, guest lecturers, honorary teachers, temporary teachers.
Unfortunately, my lord, we could not get any dictionary meaning. We about 7 lawyers we tried. But one meaning from the Wikipedia I have been able to take. Guest lecturers are expert educators who work in higher education institution. They often have experience in specific subjects or specialize.
ನಿಮ್ಮ ಗ್ರೀವೆನ್ಸ್ ಈಗ ಗವರ್ಮೆಂಟ್ ಮೇಲೆ.
Nam grievance government.
ನೀವೇನ್ ತಿಳ್ಕೊಂಡ್ರಿ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಅಂದ್ರೆ ಏನು?
Specifically in this particular case, it was a stopgap arrangement to meet the shortfall of teaching staff, my lord, in ITI institutions which are run by the government, because direct recruitments are not held often.
Stopgap 91 or 92 Supreme Court
1992.
Lakshmi Narayana 1992. AR 1992 677. Yes.
So in this particular case, they were appointed only to meet the shortfall of teaching staff during this particular
How long
period.
how long they have worked?
Since 1999.
1997 till date, my lord.
What ಬೇರೆ ಡೇಟ್ಸ್ ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಇರ್ತದೆ.
ಹೌದು.
ಒಂದೇ
ಬೇರೆ ಡೇಟ್ಸ್ ಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. My lord, such appointments are still in vogue, my lord. The need remains because a lot of people retire. Nearly 100 institutions were established, my lord, in the recent past. Suddenly, to meet that exigency, these arrangements are made.
One judgment which Lakshmi Narayana had argued, Hussain Aira Begum versus State Mysore University by Justice Bharuka bench. Bharuka bench, ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು ತೆಗಿರಿ ILR ಸೋಯಿಂಡ್ಸ್. ಅದು ಹುಸೇನ್ ಆರಾ ಅಂತಿಲ್ಲ, ಆರಾ ಬೇಗಂ ವರ್ಸಸ್ ಮೈಸೂರು ಯೂನಿವರ್ಸಿಟಿ. There, what is meant by guest lecturer, all these things are discussed.
In this case, what is relevant is can be noticed in annexure A3, my lord. Why they were appointed as guest lecturers is mentioned.
All aspects and consider ಮಾಡಿ. Division bench comprising of Justice Bharuka and another judge, who I don't remember. Those are our initial days which he had argued. Therefore, take out that judgment. That was under the Karnataka Universities Act 1976, earlier act. Take out. There, they have decided how the state should decide the fate of ದಿ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ಅನ್ಕೊಂಡು ಅದರಲ್ಲಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತೆಗೆದ್ರೆ ಸಿಗತ್ತೆ ಈಗ ಇಮಿಡಿಯೇಟ್ಲಿ ತಕೋಬೇಕು. ಅದು ನೀವು ಬೇರೆ ಕಡೆ ಹೋಗಿ ಅಲ್ಲೇ ಪೈನಾಪಲ್ ಬೇಕು ಅನ್ನೋರು ನೀವು ಅಲ್ಲಿ ಸೈಬೀರಿಯಾಕ್ಕೆ ಹೋಗಿ ನೋಡಕ್ಕಾಗಲ್ಲ, ಇಲ್ಲೇ ಸಿಗ್ತದೆ. ಕೊಡಿ, ಹಾ ಕೊಡಿ, ಫೌಂಡೇಶನಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಕೊಡಿ. ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ಸ್ ವರ್ಕ್ ಲೋಡ್ ಏನಿರ್ತದೆ?
Per hour, they were paid 50 rupees in 1999. Then it was increased per hour 100 rupees.
How many hours ಅದು?
Minimum 4 hours to 6 hours. Work was
per day.
per day.
ಅದಕ್ಕೊಂದು ಜೀವೋ ಇತ್ತಲ್ಲ?
ಇದೆ ಸ್ವಾಮಿ. Annexure A2.
ಕೊಡಿ.
A1 is the notification, C&R, my lord. A2 is the notification.
ಅದು ಹುಸೇನ್ ಬೇಗಂ ಜಡ್ಜ್ಮೆಂಟ್ ತೆಗೆದು ಅರಾ ಬೇಗಂ ಅಥವಾ ಹುಸೇನ್ ಬೇಗಂ, something like that.
47. In the first of the writ petitions, my lord, connected writ petition.
First
47967 of 2018.
your friends can go for a coffee round for half an hour. This will take some minimum half an hour. So you can have a round and come back. ಮತ್ತ ಹಿಂಗ್ ಹೇಳಿ ನಿಂತ ಆ ಕಡೆನೇ ಹೋಗ್ಬಿಟ್ರಿ.
2022 ಮನೀಶ್ ಕುಮಾರ್ ಗುಪ್ತಾ
ಹಾ
ಜಸ್ಟಿಸ್ ನಾಗೇಶ್
ಕೊಡಿ ಮನೀಶ್.
2012
ಅವ್ರ ಹತ್ರ ಇದೆ ನಿಮಗೆ.
12
ಮನೀಶ್ ಕುಮಾರ್ ಗುಪ್ತಾ
2012
ಈಗ ಇತ್ತಲ್ಲ
22
ಎಸ್
22 SC. ಹಾ
ಎಲ್.ಎನ್. ರಾವ್ ಅಂಡ್ ಜಸ್ಟಿಸ್ ಗವಾಯ್
ತಂದಿರಾ? ಕೊಡಿ. ನಮ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಕೆಲವು ಎನ್ಸೈಕ್ಲೋಪೀಡಿಯಾಗಳಿರ್ತಾವು, ವಾಕಿಂಗ್ ಎನ್ಸೈಕ್ಲೋಪೀಡಿಯಾಸ್. ಕೊಡಿ.
ಸೈಟೇಷನ್ ಇದೆ.
ಹಾ
ಸಂಜಯ್ ಕಿಶನ್ ಕೋಲ್ ಹೈಕೋರ್ಟ್
ಲೇಟೆಸ್ಟ್
ಇಲ್ಲ, ಅದು 2022.
ಇದ್ರಾಗ ರೆಫರ್ ಆಗಿಲ್ಲನು?
ಇದು ಕೃಷ್ಣ, ಇದು ಹುಸೇನ್ ಅವರಲ್ಲ.
Come to para 12.
Please, ma'am.
Let us see the law now. Read para 12.
Yeah, only. 1 minute.
This only says till regular appointments are made, you cannot be disturbed. Beyond that, there is no other ratio. ಇವ್ರನ್ನ ಡಿಸ್ಪ್ಲೇಸ್ ಮಾಡಿ ಬೇರೆಯವ್ರನ್ನ ತುಂಬರ್ತಾ ಇದ್ದೀರಾ? How long they have been? You said they have been working since
1999.
1997, 99, 97 till date. 97 ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷ ಆಗ್ತದೆ?
28 ವರ್ಷ ಆಯ್ತು.
28 ವರ್ಷ ಇದ್ರೆ 20 ವರ್ಷ ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡಿದಂಥವ್ರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇದರಲ್ಲಿ?
ಸಾಧಾರಣ 70% ಅವರೇ ಇರೋದು.
100% ನಂಬರ್ ಹೇಳ್ಬೇಕು. 70% ಜೋಳದ ರಾಶಿ ಅಲ್ಲ. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ನಂಬರ್ ಹೇಳಿ.
ಆಫೀಸ್ಗೆ ಬರ್ಬೇಕು, ಸುಮ್ಮನೆ ಬರಲ್ಲ. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಅಲ್ಲ, ನಮ್ಮಲ್ಲಿ 17 ಮೆಂಬರ್ಸ್. In writ petition number 47967, my lord, 17 members.
ಇದರಲ್ಲಿ 17 ಇದಾರಾ?
17 ಇದ್ದಾರೆ.
ಇಪ್ಪತ್ತು ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ
ಇದ್ದಾರೆ.
20 more than 20 years they have served.
More than 20.
More than 10 to 12 years.
Minimum.
Yes.
ಯಾವ ಈ ಕೇಸ್ನಲ್ಲ
Oh, you connected ಮಾಡ್ಕೊಂಡು 5 zeros.
ಅಲ್ಲ ಕಾಮತ್ ಕೇಸ್ನಲ್ಲಿ
ನನ್ನ ಕೇಸಲ್ಲಿ 17 members ಇದ್ದಾರೆ.
ಒಂದೇ ನಿಮಿಷ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 47967. ಟೋಟಲ್ ಎಷ್ಟು ಜನ ಇದರಲ್ಲಿ WP ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಈ WP ಅಲ್ಲಿ ಟೋಟಲಿ 17 ಜನ ಇದ್ದಾರೆ.
ಟೋಟಲಿ 7.
All 17 are about 20 years.
All
70.
ಹೌದಾ?
In the first writ petition.
Just verify ಮಾಡ್ಕೊಳ್ಳಿ. Total 17. All have worked. All put in 20 years. Factual verification ಮಾಡಿಕೊಳ್ಳಿ. First assertion more than 20 years work ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಅಲ್ಲ ಅವ್ರದ್ದು ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನೇನು? They have qualification.
Diploma or the ITI certificate in that particular subject, and they should have 2 years experience.
ನೀವು ಆನ್ ಮಾಡಿಕೊಳ್ಳಿ ಇದನ್ನ. ಹಾ. Repeat now.
SSLC.
ಅಲ್ಲ our question is are they all qualified, eligible?
My lord, on the question of experience, there may be some may have, some may not have it, my lord.
So far
as educational qualification is concerned, there is no dispute. They have ITI certificate based on instructions I am submitting, my lord. They should possess ITI certificate in the respective trade or diploma in the particular subject.
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಮ್ಮ.
It's annexure A1 is the notification, C&R rules, my lord.
Learned senior advocate Mr. Kamath appearing for the petitioner submits. All his clients have put in more than 20 years of service as guest lecturers, and that all they do possess the requisite educational qualification. Full stop. This is not controverted by the learned AGA. First, however, AGA adds that in the case of few, requisite experience is lacking. ಯಾರು few ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. Experience ಯಾರಿಗಿಲ್ಲ ಅಂತ ನೋಟಿಫೈ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. Second question, whether your appointment or engagement as guest lecturer, was it preceded by some formal selection process?
Initially, there was a selection process as on the date of publication of the notification. Subsequently,
ನಿಮ್ WP ಅದು.
Production process. Approval to the principal was given by the government. By the government, and the principal selected them.
What is the selection process? What is the selection process? Lodi, in WP 27132 of 2018, ಎಷ್ಟು ಜನ petitioners? 27132 ಯಾರು? 96 petitioners. ಎಲ್ಲರೂ ಕ್ವಾಲಿಫೈಡಾ? ಫಸ್ಟ್ ಎಲ್ಲರೂ 20 ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಆಗಿದೆಯಾ? ಎಷ್ಟು ಜನ 20 ಇಯರ್ಸ್ಗಿಂತ ಜಾಸ್ತಿ ಆಗಿದೆ ಮಾಡಿ? Totally 90. First stop. In WP so and so there are 96 petitioners. Semicolon. all they have got qualifying, all they have got requisite qualification and experience also. And experience. Full stop. Yes, jana more than 20 years madida. Council to furnish information as to how many of them have completed 20 or more years of service. Whether any selection process was undertaken.
My lord, since 97 till date, my lord, subject to one, it may be 3 or 4, my lord. Because in respect, I believe that I'm still getting clarity on that, my lord. One recruitment process was held in.
Nim officer Maglal Pursholi. Ask him to sit beside you,
Please.
so that he can furnish the material.
One was held in 1999, another in 2003, my lord. Thereafter in 2010, my lord. And then in 2018, my lord, one notification has been issued. And that is still pending completion because litigation is ongoing, my lord. And these are some of the situations in which the government is compelled to appoint on contract basis because they have not been able to appoint
And
those.
were not there.
And my lord, in this very writ petition, the first of the writ petitions, my lord, they have been appointed between 1999 to 2018. There are about 17 petitioners, my lord. They have been appointed between 1999 and 2018. So it's a ongoing process. Even as I mentioned, my lord, even in August 2024,
Continuously they work.
even in August 2024, the situation is such, my lord.
We
that
understand.
They need to make
There were
appointment on
difficulty because of litigation.
My lord, I'm saying this because Uma Devi recognizes the right of the government to appoint on contract basis to meet spurt in work in when there is a exigency.
Exigency. But
And in all cases, the government cannot be compelled to regularize. Is what the
that's your
judgment
stand in every case is all right. Exigency we can't call something as exigency if that continues from the days Babur came to India until date. Exigency should be short living and for a short period. ಆ ರೀತಿ ಇದ್ದಾಗ ಮಾತ್ರ ಎಕ್ಸಿಜೆನ್ಸಿ ಅಂದ್ರೆ 25-30 ವರ್ಷ ಅವ್ರ ಕೈಯಿಂದ ಸರ್ವಿಸ್ ಎಲ್ಲ ತಗೊಂಡು ಅವ್ರ ಎಂಡೋಕ್ರನಾಲಜಿ ಫೇಲ್ ಆಗೋ ಟೈಮ್ನಲ್ಲಿ ನೀವು ಹೋಗ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ವೇರ್ ದೇ ಶುಡ್ ಗೋ. What should happen to the endocrinology of the bodies of these people? That also have to keep in mind. The endocrinology is part of Article 21. ಈಗ ನೀವು ಹೋಗ್ಬಿಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಮುಂದೆ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅವ್ರು? ಕಾಡಿಗೆ ಹೋಗ್ಬೇಕು.
In fact, in
to say
in the Uma Davis judgment itself, the court notices an earlier decision where the same observation is made, my lord.
Yeah.
If it has been continued for a very long time, there may be a need to consider their cases for regularization is also noticed in Uma Devi's case. My lord, the initial entry is.
ಉಮಾದೇವಿ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಒಂದು 3 ಯಾವ ಬಂದಿದಾವ.
Lord, what is
ಕ್ಲಾರಿಫೈ ಮಾಡಿಕೊಂಡು
even in the latest decision,
paragraph 52, 53, something like that. Next ಬರುವಂತದ್ದು ಯಾವುದು ಅದರಲ್ಲಿ Mr. Lakshminarayana, which is that BESCOM that I decided one matter. Which is that judgment?
If you are extracting work for more than 15 to 20 years, then availability of vacant post pales into insignificance.
Correct.
By extracting the judgment of the Supreme Court in the case of Nihal Singh.
Correct. Do you have that? Is it a reported judgment? But it is put in appeal.
my lord, appeal has concluded, my lord, and
Before the division bench confirms your lordship judgment.
Division bench is it is upheld by the division.
no, my lord,
Dismissed.
Appeal, sir.
Dismissed. Now matter before the apex court?
No, man.
No. Then those parameters will be applicable here also.
My lord, in recently, Uma Devi has been explained by my lord Justice Vikram Nath and Justice Varale. 19th of December 2024, my lord, in Jaggo's case.
ಅದೊಂದು ಕಾಪಿ ಅಂತ
Blood where it is held, Uma Devi has been misused by all the governments saying that there shall be a sanction board. If the work is perennial in character. And that is.
then that requirement is dispensed.
Yes, that is.
Therefore, I said from the days of Babur came to India in 1526.
But what your lordships have observed, But in fact, I insisted almost all benches. There should be a formula. They must
should
stop
be
this
some-
anarchism. They should put an end to this. 6 ತಿಂಗಳು 1 ವರ್ಷದ vacancy fill up ಮಾಡ್ಬೇಕು.
Even 5 years, okay. We are someone, generally we are very, very slow and we compete with the snail, all organs of the state, including judiciary. We compete with the snail.
Work at 25 to 30 years. Most of that major portion of the life is gone. ಆವಾಗ ಮನೆಗೆ ಹೋಗ್ತೀವಿ.
ಯಾರ ಮನೆಗೆ ಹೋಗ್ಬೇಕು ಅಂತ?
ನಾವು
ಅಲ್ಲ, ಯಾರ ಮನೆಗೆ?
ಅದೇ ಯಾರ ಮನೆಗೆ ತಾವ್ ಹೇಳ್ದಂಗೆ ಕಾಡು.
Brother, now law is broadly settled.
Please.
Broadly settled. Apex court said in at least half a dozen judgments.
The Jaggu case is straight away defined. One more judgment after Jaggu, Sri Shail, I will listen. Recently.
Thank you. In Bhupen Hazarika versus State of Assam. Mr. AG, you are here in this matter.
I was seeing that light was flowing from different directions.
Yes.
ಸ್ವಲ್ಪ government ಕಡೆಯಿಂದನೂ ಸ್ವಲ್ಪ because I had appeared in some regularization matters, I thought notes.
No, we'll not pass any order without hearing you.
Please.
Because we were bound to hear you.
Please.
3-4 principles.
Please.
Which we have, at least I have employed in matters like this.
Please.
The first one, right to hire and fire, is curtailed even in private employment because of many labor legislations, etc. So naturally that will be applicable to the state because Supreme Court said the state should conduct itself as a model employer. Bhupen Hazarika, number 1.
85 Supreme Court.
85 Supreme. Ratan Lal, correct. That is followed in Bhupen Hazarika. Number 1. Number 2, the jobs in this country are very rarely available to the people. And when you give a job, based upon that, they work out their livelihood. They get married, they construct houses. They believe that government would be fair to us. The right to be treated fairly, which John Rawls said, justice as fairness. That applies to you. Number 2. Number 3, unfortunately, we all become old. And gradually, our endocrinology does not properly work.
Yes.
Is it? It applies to all, including Attorney General, Chief Justice of India, judges, men, women. So, though state is not bound to maintain citizens as such, but it has to ensure that the right to livelihood is not taken away in the light of Olga Tellis. Now, this is the job from which they were eking their livelihood since last 20 years. I'm speaking of those who have put in 20 years. For lesser number of years, we'll have some other yardstick, etc. Because 20 years we adopted in that BESCOM matter, which Mr. Lakshminarayana said now. Therefore, with this, you can't say that Uma Devi, that mantra, of course,
No,
Uma and Devi, they are all adored people. The way we should chant this mantra is one thing. But with that, you cannot silence the heartbeat of the common people because they are qualified. And there is some semblance of selection process. It's not that they went to KR market and brought them. Something, some application was given. They were seen. Then they were made to work. Even absence of proper selection process would pale into insignificance because if they were incompetent, you would not have continued them for 20 years. You would have sent them home. Or you should have held some screening test after 1 or 2 years. ನೋಡಪ್ಪ ನೀನು ನಿನ್ ಲೆಕ್ಚರ್ಸ್ ಎಲ್ಲ ನೋಡಿದ್ವಿ, ಎಲ್ಲ ಹುಡುಗರು ಫೇಲ್ ಆಗ್ತಾ ಇದಾವು, ನಿನ್ ತೊಗೊಂಡು ನಾವು ಬೇರೆ ಹುಡುಗರು ಅನ್ಯಾಯ ಮಾಡಕ್ ಬರಲ್ಲ, ಹಂಗಾಗಿ ಗೋ ಹೋಮ್. Or we'll have some screening test. Or those who pass will continue, who do not pass, we will not continue, because the fate of the children is. These are the parameters with which we want to operate. If you want to say something,
Please.
then you are entitled to, you are.
Let's, if it was a case of contract employment, that would have been, my lords, a case of full-time employment where a person is on contract, but as a substitute for a regular person, regular lecturer or a regular employee.
So your first submission is,
There is a distinction between,
articulate, right? Make your proposition.
please,
Barkam, or dictation 30. Age.
there is a,
Make the articulation.
please, there is a distinction between a contract employee,
Slowly.
contract lecturer,
Slowly, slowly. She is writing that.
and a guest lecturer. A guest lecturer is appointed based on the workload requirement in respect of each academic year for particular number of hours a day, and is paid based on the number of hours. So the concepts which apply
To regular employees.
to regularization of a contract employee will not directly will not apply in respect of regularization of a guest lecturer. That is my first submission.
Number one in this
My
case.
lords, I'll just put it out this way.
How many hours of work they?
Lords, I'm told it is 4 hours a day. lords.
4 hours.
4 hours.
Regular employees, teachers, yes,
8 hours.
8 hours.
8 hours a day. My lords, but I understand if it is for 20 years, my lords, I'll just give context. My lords, this is in the context of ITI, my lords. In respect of collegiate education and other places, we have what is called as concept of guest lecturers, which is permitted in the UGC regulations also. My lords, there are 2 distinct cases. One is where I have sanctioned posts. I keep them vacant. I don't fill them up. I utilize this method of contract employment for the purpose of filling up. Here is a case, my lords. In fact, we have statistics that during the time they were employed, we have had regular recruitments that have taken place. And I'm informed that some of them have participated, also not qualified. But if I had not done regular recruitments during this period, there could be a complaint that sanction posts were kept vacant. My work was taken as against a sanction post by not filling it up. And therefore, the right of regularization flows from it. In terms of para 53 as a one-time measure, at least that is what would be their case. But here is a case, my lords, there have been 4 recruitments that have been held during that time period. So, my lords, statistics also might make a difference, because at the end of the day, maybe not as I understand, my lords, there could be a case. I'm not just saying that because we have to be a model employer, my lords, and I have also faced certain human questions also from the court when I've argued regularization matters before different benches. And my lords, there would be different approaches. Now, therefore, my lords, we will place on record the statistics pertaining to each person. There has been one judgment, my lords, in respect of UGC regulations, where, my lords, every year, based on the workload requirement, we announce how many guest lectures we require. In fact, my lords, under the collegiate, we require 10,000 every year almost, based on the workload in a particular subject. Now, my lords, every year we notify, but we had devised a scheme where a person who has worked will get weightage for the purpose. So this honorable court upheld that policy, stating that the theory where a temporary employee should not be displaced with another temporary employee, based on that concept, giving weightage in fact was challenged by persons who are new. Weightage for number of years worked, so that you can continue further.
In the same status.
In the same status. So every year there is a fresh recruitment that takes place for the purpose of under the collegiate education. Whether in this, my lords, that we have done, I'll verify. Lords, we'll place statistics, how they entered, at what point in time, how many years they have worked. My lords, at the end of the day, my lords, we are before my lords. And insofar as the number of recruitments that have taken place in between, and whether any of them have applied unsuccessfully in those recruitments also, we will be able to place on record. And based on that, my lords may decide whether some persons are entitled to or not. But I understand, my lords, 20 years is too long a period.
20 years is prime. Homer says,
please,
the author of Iliad and Odyssey,
please,
20 years is prime of the life.
Prime, please. I totally agree, my lord. There is there can be no quarrel about those things, my lords. And therefore, my lords, we will place on record those statistics as quickly as possible. Now, my lords have heard it. It is only a further hearing. If my lords may accommodate us by a week, we will just place it on record. And my lords, any other judgment with regard to the guest lecturer regularization?
ಒಂದು ಇನ್ನೊಂದು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ.
Please,
ನಾವು ಏನಾರ ಮಾಡಿ if you go to US,
please,
I believe that you have visited.
not at
In US Supreme Court,
please.
ಅಲ್ಲಿ ಒಂದು ಬೋರ್ಡ್ ಹಾಕಿದ್ದಾರೆ. Whenever citizen succeeds against the federal government rejoices ಅಂತ. ಗೌರ್ಮೆಂಟ್ ವಿರುದ್ಧ ಯಾವ್ದಾದ್ರು ಸಿಟಿಜನ್ಸ್ ಗೆದ್ದ ಅಂದ್ರೆ ಕೇಸ್ನಲ್ಲಿ ಅದನ್ನು ಗೌರ್ಮೆಂಟ್ ಸೆಲೆಬ್ರೇಟ್ ಮಾಡ್ತದಂತೆ, ಯಾಕಂದ್ರೆ ಅವನಿಗೆ ಜಸ್ಟಿಸ್ ಆಯ್ತು ಅಂತ. These are great ideals. We have brought lot from American jurisprudence. Even you have seen B.N. Rao was sent by Dr. Ambedkar sent B.N. Rao to meet Felix Frankfurter. We brought so many provisions from America. So much water flows from Mississippi to Ganga in an invisible form in the lives of people. Okay. Therefore, that also you have to keep. One argument is one thing. Argument ಮಾಡೋದು ನಿಮ್ ಡ್ಯೂಟಿ, ಅದು ಅವ್ರದ್ದು ಡ್ಯೂಟಿ. ನಮ್ ಕೇಳೋದು ನಮ್ ಡ್ಯೂಟಿ. Though it is not said in our warrant, you should hear the case and decide. Now warrant ಅಲ್ಲಿ ಏನು? Do justice, will uphold the law in the constitution and do justice to the people. You can't say some jurisprudential theory itಗೊಂಡು. There is one judgment of Justice Holmes. The constitutions are meant for maintaining the practical rights of the people and not for jurisprudential theories of that. There is one such judgment in before he died in 1937 or so. He wrote that judgment. Very beautiful judgment. That is how constitutional process. Otherwise, most of the people, they will lose faith not only in the government but in the judicial process itself. Hanಗಾಗಿ ಉಮಾದೇವಿ ಅನ್ಕೊಂಡು ಭೂತ ಬಿಟ್ಟಂಗ್ ಮಾಡಬಾರ್ದು. ಉಮಾದೇವಿ is not like an ox in the
chatter.
Not that.
In fact, I wanted to say that courts are in the business of administration of justice, not in the business of administration of law.
Correct.
We apply the law to administer justice. Please.
Therefore, now with that view in mind,
please,
you have to do something.
Please.
See the idea of justice by Amartya Sen, which he wrote in contradistinction to John Rawls' theory of justice.
Please.
How beautifully he has said. ಅವ್ರು ಕೇಳಿದ್ದನ್ನೆಲ್ಲದನ್ನು ಕೊಡಕ್ಕಾಗಲ್ಲ ಅನ್ನೋದು ಪ್ರಾಕ್ಟಿಕಲ್ ಡಿಫಿಕಲ್ಟಿ. ನಾವು ಏನೂ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳುವಂಥದ್ದು ಟ್ರೆಚರಿ ಅಂತ ಬರೀತಾನ ಅವನು. ಸಮ್ ಬ್ಯಾಲೆನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ವರ್ಕ್ಡ್ ಔಟ್ ಅಲ್ವಾ, ಅವಾಗ ಜಸ್ಟಿಸ್ ಆಗ್ತದೆ. ಅವ್ರು ಕೇಳಿದಷ್ಟು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಮಗು ಕೇಳುವಂಥದ್ದು ಎಲ್ಲದನ್ನು ಕೊಡಿಸ್ತೇವೆ, ಜಾತ್ರೆಯಲ್ಲಿರೋ ಎಲ್ಲ ಸಾಮಾನು ಬೇಕು ಅಂತದ್ದು ಮಗು, ಹಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ದೇರ್ ಶುಡ್ ಬಿ ಸಮ್ ಏನು ಅವ್ರ ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ ಲೆವೆಲ್ಲು ಕಡಿಮೆ ಮಾಡ್ಕೋಬೇಕು. ನಿಮ್ಮ ಅಬ್ಲಿಗೇಷನ್ ಲೆವೆಲ್ ಅನ್ನು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಿಕೊಂಡು ಏನ್ ಮಾಡ್ಬೋದು. ಇವ್ರಿಗೆ 20 ವರ್ಷಗಟ್ಲೆ ಎಲ್ಲ ದುಡ್ಸ್ಕೊಂಡು ನೀವು ಹೋಗ್ಬಿಡು ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅವರು? ಯಾವ್ದೋ ಒಂದು ಹತ್ತಿರದಲ್ಲಿರೋ ಕೆರೆಯಲ್ಲಿ ಹಾರ್ಬೇಕು, ಆದ್ರೆ ನೀರಿಲ್ಲ, ಅದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಅವ್ರು ಕೈ ಕಾಲು ಮುರ್ಕೋತಾರ ಅನ್ನೋದು ಹೋಗಲ್ಲ.
In fact, in 2013 we brought out one legislation, welfare legislation.
2012 ಅಲ್ವಾ?
2012. I'll see, my lords, if some principle can be imported there, because there at least we protected their.
ಆಮೇಲೆ ಅಷ್ಟೇ ಅಲ್ಲ, ನಿಮ್ ಸಾಧ್ಯ ಇದ್ರೆ ನಿಮ್ಮಲ್ಲಿರುವಂತ ಹೈಯೆಸ್ಟ್ ಫಂಕ್ಷನರಿ ಆಫ್ ದಿ ಗವರ್ಮೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನೀವು ಒಂದ್ 3-4 ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಅನ್ನು ಕೂರಿಸ್ಕೊಳ್ಳಿ, ಒಂದ್ 2-3 ಜನ ಯೂನಿಯನ್ ಲೀಡರ್ಸ್ ಅನ್ನು ಕೂರಿಸ್ಕೊಳ್ಳಿ. ಅದರಲ್ಲಿ ಒಂದ್ ನೆರಳಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಬೋದು ಇವರಿಗೆ ಆ ರೀತಿನೇ ಪ್ಲೀಸ್, ಅವಾಗ ಸೊಲ್ಯೂಷನ್ ಹೊಳಿತು. ಒಂದು ಒಳ್ಳೆ ಗಿಡದ ನೆರಳಲ್ಲಿ ಕೂತ್ಕೋಬೇಕು. ಹಂಗಾಗಿ ಭಗವಾನ್ ಬುದ್ಧ ಅಲ್ಲಿ ಹೋಗಿದ್ದು ಗಿಡದ ನೆರಳಲ್ಲಿ ಕೂತ್ಕೊಂಡು, ಹಿಮಾಲಯಕ್ಕೆ ಹೋಗ್ಲಿಲ್ಲ, ಕೂತ್ಕೊಂಡು ಅಲ್ಲಿ ಅವನಿಗೆ ಜ್ಞಾನೋದಯ. ಅಂಥದ್ದು ಶಾಂತವಾಗಿ ಕೂತ್ಕೊಂಡು ನಾವು ಹಂಗಾರೆ ಈ ರೀತಿ ಮಾಡೋಣ, ನಿಮ್ಮೆಲ್ಲರನ್ನು ತಗೊಳ್ಳೋದು ಡಿಫಿಕಲ್ಟ್, ನಮಗೆ ಇಷ್ಟು ಜನರನ್ನ ನಾವು ತಗೊಳ್ಬೋದು ಅಲ್ವಾ? ಆ ರೀತಿ ಒಂದು ಪ್ರೊಸೆಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. ಬರೀ ಆರ್ಗ್ಯುಮೆಂಟು ಕಾನೂನು ಅದು ಒನ್ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟರ್ಸ್. ದಿ ಅಡ್ಜುಡಿಕೇಟರಿ ಪ್ರೊಸೆಸ್ ನಲ್ಲಿ law is one of the factors. Really, with experience, I am telling you, I have 8 years, almost more than 7 years experience as a judge. With that experience and little reading also, how they do. ಆ ರೀತಿ ಅವ್ರನ್ನ ಕರೀರಿ ನೀವು. ಅವ್ರನ್ನ ಕರೆದು ಅವ್ರು ನಮ್ಮ ಎನಿಮೀಸ್ ಅಂತ ಅನ್ಕೋಬೇಡಿ. ನಿಮ್ ಗೌರ್ಮೆಂಟ್ my professor used to say, Professor Visheshraya, the first lesson of administrative law is that government is my first enemy. ಹಂಗ ಅನ್ಸ್ಬಾರ್ದು. ಅವಾಗ ಗೌರ್ಮೆಂಟಿಗೆ ಗೌರವ ಸಿಗಲ್ಲ. We should fear the God and obey the king. ಅದೇ ಯಾವಾಗ ಆಗತ್ತೆ? ನೀವು ನಂಬಿಕೆ ಹುಟ್ಟಿಸ್ಬೇಕು. ಹಿಂಗ ನಮ್ಮ ಎಷ್ಟುದ್ದ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅವ್ರಿಗೆ ಅನ್ಸ್ಬಾರ್ದು. ಸೊ ಸಿಟ್, ಒಂದು ಕಮಿಟಿ ಮಾಡ್ಕೊಳ್ಳಿ. ನಿಮ್ಗೆ ಯಾವ ಆರ್ಡರ್ ಮಾಡಲ್ಲ ನಾವು ಇವತ್ತು. ಈ ಡಿಸ್ಕಷನ್ ಅನ್ನೇ ನೀವು ತಗೊಳ್ಬೇಕು. ಆ ಲಾಯರ್ಸ್ನ ಕುಡಿಸ್ಕೊಳ್ಳಿ, ನಿಮ್ ಕಡೆ ಇರುವಂಥವ್ರು ಕುಡಿಸ್ಕೊಳ್ಳಿ. ನಂತರ ನಿಮ್ಮೆಲ್ಲ there is a big gap between bureaucracy and governance. Most of the bureaucrats, this is what Jawaharlal Nehru said. Indian civil service is neither Indian nor service ಅಂತ ಬರೆದ್ರು. This is what Jawaharlal Nehru said, ICS ಬಗ್ಗೆ. No much difference till date. ಯಾವ ಒಬ್ಬ IAS ಆಫೀಸರ್ ಅನ್ನು ನೋಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಕಾಮನ್ ಮ್ಯಾನಿಗೆ. ಅಲ್ಲಿ ಹತ್ತರ ತನಕನೇ ಹೋಗಲ್ಲ. ಅವರಿಗೆ ಒಬ್ಬ PS, PSC ಇನ್ನೊಬ್ಬ PS, ಅವನಿಗೆ ಇನ್ನೊಬ್ಬ PS, ಅಲ್ಲಿಂದ ಹೋಗೋದ್ರಲ್ಲಿ ನೀವು ಸತ್ತೋಗ್ಬಿಡ್ತಾನೆ. ಆ ರೀತಿ ಮಾಡಬೇಡಿ. ಅಲ್ಲಿ ಅವ್ರ ಜೊತೆ ನೀವು ಕುತ್ಕೊಳ್ಳಿ. ಒಬ್ರು ಮಿಡ್ಲ್ ಮನ್ ಅಂತ ಸಾಧ್ಯದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ, ಗೊತ್ತಿರುವಂತ ಲಾ ಎಲ್ಲ ಗೊತ್ತಿರಿಸಿ ಇಟ್ಕೊಂಡು ಒಂದು ಕಮ್ ಔಟ್ ವಿತ್ ಸಮ್ ಫಾರ್ಮುಲಾ. ಅದು ಯಾವುದು ಆಗ್ಲಿದ್ದಾಗ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಅಲ್ವಾ? ನೀವು ಹೋಗಿ ಯಾವತ್ತು
I'll be the point of contact. I'll coordinate.
ನಮ್ಮ ಮುಂದೆ ಹೇಳ್ಬೇಕು. ಹಂಗ ನೀವು ಅಲ್ಲಿ ಅವರು ಗೌರ್ಮೆಂಟ್ ಕೇಳ್ತಾರೆ ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಅಂತ. ಅದಕ್ಕೆ ನಾವು ಸಮಥಿಂಗ್ ವಿ ಹ್ಯಾವ್ ಟು ರೈಟ್ ಅಂಡರ್ ದ ಶಾಡೋ ಆಫ್ ಅವರ್ ಆರ್ಡರ್. ಯು ಶುಡ್ ಸಿಟ್ ದಟ್ ವೇ. ಇದಕ್ಕೆ ಈ ಪ್ರಪೋಸಲ್ಗೆ ಒಪ್ತೀರಾ?
ಎಸ್ ಸರ್,
ಒಪ್ತೀರಿ. ಈ ಪ್ರಪೋಸಲ್ಗೆ ನಿಮ್ ಕಡೆಯಿಂದ ಒಪ್ಪಿಗೆ ಇದೆಯಾ? ನಮ್ಮ ಪ್ರಪೋಸಲ್ ಅರ್ಥ ಆಗಿದೆಯಾ? ಏನ್ ನೀವೆಲ್ಲರೂ ಜೊತೆ ಕೂತ್ಕೊಂಡು ಎಲ್ಲರನ್ನೂ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅದನ್ನ ನಿಮ್ ಕ್ಲೈಂಟಿಗೆ ಹೇಳ್ಬಿಡ್ಬೇಕು. ಎಲ್ಲರಿಗೂ ಆಗಲ್ಲ. ಇದು ಒಂದು ಪ್ಯಾರಾಮೀಟರ್ಸ್ ನ ವರ್ಕ್ ಮಾಡ್ತದೆ ಗೌರ್ಮೆಂಟ್, ಆಯ್ತಾ? ಆ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ನಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ಬರೀ ಉಮಾದೇವಿ ಅಂತ ಹಂಗೆ ಹೇಳ್ಕೊತ ಅಡ್ಡಾಡ್ಬಾರ್ದು. ಎಲ್ಲರಿಗೂ ಗೊತ್ತಿದೆ ಉಮಾದೇವಿ, ಉಮಾ ಮಹೇಶ್ವರ ಎಲ್ಲರೂ ನಮ್ಗೆ ಬೇಕೇ ಬೇಕು. ಅವರೆಲ್ಲ ಯಾವತ್ತ ಕೊಡ್ತಾ ಇದ್ದೀರಿ. ನಾನು ಅದನ್ನೀಗ ಸ್ವಲ್ಪ ಸಣ್ಣಕ್ಕೊಂದು ಸ್ವಲ್ಪ ಏನಾದ್ರು ಬರೀಬೇಕಲ್ಲ ನಾವು.
Next Monday 4:30.
ಮಂಡೇ ಹೌದಾ? ಯಾರ ಲೆವೆಲ್ನಾಗ ಯಾರ್ಯಾರನ್ನ ಇನ್ವಾಲ್ವ್ ಮಾಡ್ತೀರಿ ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ನಲ್ಲಿ? ಯಾವುದೋ ಒಬ್ಬ FDC ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ಅಥಾರಿಟಿ ಇರಬೇಕು. ಟ್ರಾನ್ಸಾಕ್ಷನ್ ರೂಲ್ಸ್ ಕೆಳಗಡೆ ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ಅಥಾರಿಟಿ ಅವ ಬರಬೇಕು.
The principal secretary, my lords, or the ACS, whoever it's there. Because otherwise, I know, otherwise it won't happen.
No,
there's no meaning in that. It's the waste of everybody's time.
British government used to do it. ಆ ರೀತಿ ಮಾಡ್ಬಿಟ್ಟು ನಿಮ್ ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ಪವರ್ ಇರುವಂಥವು ಅವ್ರು ಕುತ್ಕೋಬೇಕು ಇವ್ರ ಜೊತೆ. Both the sides argued the matter very vociferously for a considerable time. First off, now on the suggestion of this court, consistent with a catena of decisions of this court and of the apex court, both the sides graciously agree to have the parley in the presence of the principal secretary, stroke additional chief secretary.
It is the secretary of Department of Skill Development.
Our edition totara?
In some departments we have principal secretaries heading, we have secretaries, and if the ACS cadre person is heads, we call them ACS.
Secretary who would be able to take concrete and enforceable decision in the matter. First, learned AAG submits that. In this meeting, learned advocates appearing for the petitioners with one or two guest lecturers would be permitted to participate, would be entitled to participate in the proceedings scheduled on
Lords, can it be, I suggested next Monday, which is 10.
whatever day you want.
My lords, it is better
10th
if we
of-
have it after the session, my lords, after the 24th. Then
Session is very important, we agree. But
17th.
even this is not less
No, then
important.
17th, during the
17th.
17th,
Yes, continue.
4:30 PM.
4:30. ಸಾಕಾಗಿರ್ತಾರೆ ಅವಾಗ ಏನು ಎದ್ದು ಹೋಗೋ
ಇಲ್ಲ ನಮ್ಗೆ ಇವ್ರು when advocate
ಅವ್ರಿಗೆ ಹೇಳ್ತೇವೆ ನಾವು ಕೋರ್ಟಿಗೆ ಅವತ್ತು ಬರ್ರಿ, ನೀವು ಯಾವ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಮಾಡಲ್ಲ ನಾವು ಅವತ್ತು ಹೋಗ್ರಿ. ವಿಲ್ ರಿಕ್ವೆಸ್ಟ್ ನೀವು ಅವತ್ತು 17th ನೀವು ಲಿಸ್ಟ್ ಕೊಡಿ ನಮಗೆ. ವಿಲ್ ರಿಕ್ವೆಸ್ಟ್ ಅವರ್ ಬ್ರದರ್ ಜಡ್ಜಸ್ ನಾಟ್ ಟು ಡ್ಯಾಮೇಜ್ ಯುವರ್ ಕೇಸಸ್.
then
ಮಾರ್ನಿಂಗ್
8th second Saturday morning 11 o'clock.
second Saturday.
8th second Saturday.
whichever day
11 o'clock will be better.
Lords, then we will have it on 16th itself, lords, the third Saturday, which will be the working Saturday. We'll take it on 6 instead of 17th. We'll take it on 15th.
ಮಾರ್ನಿಂಗ್
Morning itself. We'll
morning
have the entire day because
ಮಾರ್ನಿಂಗ್ ಎದ್ದು ತಗೋಬೇಕು. ಈವ್ನಿಂಗ್ 4 ಗಂಟೆ ಒಳಗೆ ಯಾರು ನಾವು ಜಡ್ಜಸ್ ವರ್ಕ್ ಮಾಡ್ತೇವೆ 4 ಗಂಟೆ ಆದ್ಮೇಲೆ ಅದು ಹಂಗೆ ಆಗ್ತದೆ. ಬೇಗನೆ ಮನೆ ಕಡೆ ಗಮನ ಅವಾಗ ತೊಳಿ. at 10:30
11.
at 11 a.m. on 16
No, 15.
15/3/2025 at 11 p.m.
11
ಎಲ್ಲಿ?
AM.
11 a.m. sorry.
11.
ಎಲ್ಲಿ?
Lords, we will intimate, my lords. I will arrange for it and intimate. I will ensure that it is intimated to them, lords. My lords have said it is a secretary, so it will be his, we'll arrange it in our secretary.
ನಮ್ಮ ಮುಂದೆ ಫೋನ್ ಮಾಡಿ, ನೀವು ಯಾರು ಕೇಳ್ಕೊಳ್ಳಿ ಅವರಿಗೆ. ಏನು ಹೊರಗೆ ಹೋಗೋದು ಬೇಡ, ಇಲ್ಲೇ ಮಾಡಿ, ಇಲ್ಲೇ ಮಾತಾಡಿ, ಎಲ್ಲಿ ಅಂತ ಕೇಳಿ ಹೇಳಿ ಅವ್ರಿಗೆ ಅವತ್ತು ಬಿಡ್ಬೇಕು ಒಳಗಡೆ.
Lords, at MS building in the secretariat, my lords of.
ನೀವು ಹೇಳಿ at
Room number?
ರೂಮ್ ನಂಬರ್
Building 5.
ಬಿಲ್ಡಿಂಗ್ 5 ರೂಮ್ ನಂಬರ್ ಇದೆ ಏನಲ್ಲಿ?
Room number. Lords, building, we'll supply it, my lords, to the court.
ರೂಮ್ ನಂಬರ್ so and so,
Building 5,
ಬಿಲ್ಡಿಂಗ್ 5,
MS multi-storied building.
MS ಬಿಲ್ಡಿಂಗ್, Bangalore 1. Bangalore 1. Full stop. You record the proceedings.
Please, my lords.
We want to know what were the talks.
Please.
Full stop. It is open to both the sides to videograph the proceedings, since they do not involve any secrecy, need not involve any secrecy, and that video would be made available to us so that becomes an input for decision making. First off, all participants would conduct themselves tall and disciplined. And employ chaste language. ಅದು ಹೇಳೋ ಕಾಲ ಬಂದದ ಈಗ. ಒಳ್ಳೆ ಭಾಷೆಯಲ್ಲಿ ಮಾತಾಡ್ಬೇಕಂತ ಹೇಳೋ ಕಾಲ ಬಂದದ ಈಗ. ಬಹಳ ದುರ್ಭಾಷೆ ಬಳಕೆ ಆಗ್ತಾ ಇದೆ ಎಲ್ಲ ಕಡೆ ನಾವು ಬಿಡಿಸಿ ಹೇಳಲ್ಲ. ಎಲ್ಲ ಕಡೆ ಬಹಳ ತುಂಬಾ ಕಳಪೆ ಮತ್ತು ಶಾಂತ ಇದ್ದಲ್ಲೆಲ್ಲ ಬಿರುಗಾಳಿ ಎಬ್ಬಿಸುವ ಭಾಷೆ.
Lords, my lords have used the word the secretary of the department, and we also have a commissionerate. So the secretary and commissioner both.
Secretary and commissioner or such other officers.
Please,
My
and I will
one-
provide
my
the correct designation to the.
My only
one
only
good quote.
request, my lord, Mr. A.S. Pannana is of cabinet rank now.
No,
We can't bring no rank here. Everybody is equal. No, nobody. If you.
2 to 3% was the petitioner. If it is 5 months for this reason, there are 5 petitions.
ಇಲ್ಲ ಅವ್ರು ಅಷ್ಟು ಹೋಗ್ಬೇಕು ಅಂತಿಲ್ಲ.
ಒಂದೊಂದು ಬ್ಯಾಚ್ ಇಂದ ಒಬ್ಬೊಬ್ರು ಇಲ್ಲ.
ಯಾರಾದ್ರೂ ತಿಳ್ಕೊಂಡ್ರೆ ಕಾಮನ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ದವ್ರು ಹೋಗ್ಬೇಕು ಅಷ್ಟೇ. ಅಲ್ಲಿ ಒಪ್ಕೊಂಡು ಬತ್ತಲ್ಲೆಲ್ಲ ದಾನ್ಲಿ ಮಾಡಿದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ?
Representing them.
ಇದ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು, ಪೂರಾ ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡ್ಬೇಕು ನಿಮ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ, ಅದನ್ನ ನಮಗ್ ಕೊಡ್ಬೇಕು. We will make use of that as an input, as a good input for us. Yes. ಯಾವತ್ತು ನಾವು ಮ್ಯಾಟ್ರ್ ಕರಿಬೇಕು.
Lords,
call this matter on
19th.
19th. ಇದರಲ್ಲಿ ಫೈನಾನ್ಷಿಯಲ್ ಇಂಪ್ಲಿಕೇಶನ್ ಇರುತ್ತೇನೋ?
ಹೌದು ಫೈನಾನ್ಷಿಯಲ್.
ಮತ್ತೆ ಆ ಫೈನಾನ್ಸ್ ಕಡೆಯಿಂದ ಯಾರು ಬೇಕು? ನೀವು ಅಲ್ಲಿ ಕಳಿಸ್ತೀರಿ, ಆ ಫೈನಾನ್ಸ್ ಸೆಕ್ರೆಟರಿ ನೋ ಅಂತ ಕಳಿಸ್ತಾರೆ, ಮುಂದೆ ಮಾಡ್ಬೇಕು.
Lords,
ಫೈನಾನ್ಷಿಯಲ್ ಇಂಪ್ಲಿಕೇಶನ್ ಇದ್ರೆ ಅವರು ಬೇಕಲ್ಲ.
financial, we need the concurrence of the finance department before we take it.
ಹಂಗಾಗಿ ಅವ್ರನ್ನೂ ಇಟ್ಕೊಳ್ಳಿ. ಇಲ್ಲಪ್ಪ ನೀವೆಲ್ಲ ಮಾಡಿ
ಎಲ್ಲ ಮಾಡಿ ಕಳಿಸ್ತೀವಿ,
ಈ
ಅವ್ರ
ಕಡೆಯಿಂದ
finance-
ಹೇಳಿ ನಾವೆಲ್ಲ ಮಾಡಿ ಕಳಿಸ್ತೀವಿ, ನೀನು ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಕಳಿಸು ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ.
Please, Lords, can it be both the DPR
No.
and as well as the finance department representative?
Secretaries of finance DPAR and finance department and such other relevant department.
Please.
Department. ಅವ್ರನ್ನೆಲ್ಲ ಇಟ್ಕೊಂಡು
Details, so so that it,
Body.
I'll give to the stenographer.
ಪ್ರಕಾಶನ್ನು ಕರ್ಕೊಳ್ಳಿ.
Please.
Prakash, panel, senior panel counsel of KPSC, Mr. Prakash would also participate in the proceedings. Okay, you take a fair stand there. Okay? All right.
Grateful.
ಮುಕ್ಷಂ ಬರ್ಬೇಕು. ನಮ್ ಕೈಯಿಂದ ಆರ್ಡರ್ ಕೆಟ್ಟ ಆರ್ಡರ್ ಬರ್ಸ್ಬೇಡಿ. ನೀವಾಯ್ತು ಒಂದು ರೀಸನೇಬಲ್ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡ್ ಬನ್ನಿ.
Please. We're grateful.
Posted for.
Let them not remove them from services.
Adide, interim order.
Continue again.
Interim order to
Continue.
interim order wherever in existence shall be continued till next date of hearing.
Yeah. For further hearing.
ನೋಡೋಣ. We do not know. ಈಗ ಎಲ್ಲ ಜಡ್ಜಸ್ ಚಲೋರೇ ಇರ್ತಾರೆ. ಹಂಗೆ ಎಲ್ಲಾ ಲಾಯರ್ಸ್ ಒಳ್ಳೆಯವರೇ ಇರ್ತಾರೆ. ಹಂಗೆ ಎಲ್ಲ ಜಡ್ಜಸ್ ಒಳ್ಳೆಯವರು ಇರ್ತಾರೆ ಅಂತ ಅಜ್ಯೂಮ್ ಮಾಡ್ಬೋದು. ಎಸ್.
Needful done, my lords. I've handed over the book long time back.
ಬುಕ್ಸ್ ಕೊಟ್ಟಾಗಿದೆಯಾ?
Yes, sir.
Needful is done. Yes. Judicial process. Yes, Mr. Joshi.
Petitioners. Interesting question of law, my lord. I had heard on the last occasion partly. I was also led by Mr. Raghavan, if my lord recollects. This is an issue where the petitioner is a purchaser of certain sites formed in a layout. The developer and the landowner are engaged in some dispute. Third-party rights have already been created. The developer has already developed portions of the layout. The sites have been sold. Now the landowner and the developer have some dispute amongst themselves. They are engaged in an arbitration where some declarations are sought, I don't know. Under section 42A of the Arbitration Act, statutorily arbitration proceedings are confidential. So as a third party, I have no access to those arbitration proceedings. I cannot participate. I have no idea what's going on. Now, certain rights will be determined of the developer or the landowner in that private tribunal, which are going to affect me because I am one of the purchasers. Rights have already been created. Once rights have been created, their dispute can no longer be arbitrable. Booz Allen, the Supreme Court has said what is arbitrability has to be seen. They are no longer the sole repository of the rights emanating from the joint development and the power of attorney. If they still had that contract only between themselves, then that could have been resolved. But that agreement of JDA in which the arbitration clause is there, that JDA no longer is the sole repository of rights. Sale deeds have been executed, allotment letters have been given, agreements of sale have been created. We as purchasers wish to further sell. Why I came to know about this is one of the other purchasers, he wanted to sell his site. When he approached the sub-registrar, he was informed that there is some sort of a stay order that has been passed by the arbitral tribunal, which is registered in the revenue records. That is when we came to know. Their dispute, their injunctions are affecting us. So the request before this honorable court is quash this arbitration. If they so wish to, they are always entitled to come before a court of law in a civil court, which under the CPC provides all sorts of protections. In fact, there are two phases to the layout. The other set of landowners have in fact filed a suit, which we are aware of. And if something goes wrong there, under the provisions of the CPC, we are entitled to participate there. This arbitration is creating a lot of prejudice to us.
How various high courts in the country have treated this question?
I have done my best to research, and I have been assisted also by my attorney. no decision on this point.
No
This is
decision.
No decision on
a
this point.
completely new
There,
point.
there have been decisions like Deep Industries and Bhavin where parties to the arbitration themselves on certain orders of the arbitral tribunal approached the High Court. High courts did entertain in the beginning, but the Supreme Court says very clearly that no, within the statutory scheme and framework of the Arbitration Act, parties to the arbitration should not be permitted to approach the High Court. That is where the law stands. What about third parties like us? That the law, there is no decision of the High Court. In
Lord,
fact, although appears for the respondent, counsel can be asked.
Yes,
I have not come across anything.
my lord, I'm not joining issues with the
But
petitioner.
who are you?
I'm for R1 developer. I'm not joining on the question of law.
You are
I am site purchaser.
purchased.
Side purchase. Now, my lord, on the question of law, as I had briefly submitted last time, this is a new area where there is no precedent, and this court is called upon to set a precedent in this matter. What is available, my lord? My lord may see para 25 of the petition. Vidya Drolia is quoted. Can I just read it out? It's his petition, but I'd like to rely on it. Kindly see para 25 where Vidya Drolia is quoted.
Para 25 of
Para 25 of this petition, my lord.
petition.
Petition. And that is the guiding light that we have. The sense of direction today is through Vidya Drolia. Kindly see para 25.
Yes.
The arbitral tribunals are being courts of law, are not being courts of law, or established under the auspices of the state, cannot act judicially so as to affect those who are not bound by the arbitration clause. Arbitration is unsustainable when it has erga omnes effect. That is, it affects the rights and liabilities of persons who are not bound by the arbitration agreement. Equally, arbitration as a decentralized mode of dispute resolution is unsustainable when the subject matter of a dispute unsuitable when the subject matter or a dispute in the factual background requires collective adjudication before one court or forum. Certain disputes as a class, or sometimes the disputes in the given facts, can be effectively resolved only through collective litigation proceedings. Contractual and consensual nature of arbitration underpins its ambit and scope. Authority and power being derived from an agreement cannot bind and is non-effective against non-signatories. An arbitration agreement between two or more parties would be libid and inexpedient in situations where the subject matter or dispute affects the right and interest of third parties, or without the presence of others, an effective and enforceable award is not possible. Prime objective of arbitration is to secure fair and effective resolution of disputes without unnecessary delay and with least expense, is crippled and mutilated when the rights and liabilities of persons who have not consented to arbitration are affected, or collective resolution of disputes by including non-parties is required. Arbitration agreement as an alternative to public fora should be enforced when it's futile, ineffective, should not be enforced when it's futile, ineffective, and would be of no result exercise. Now, my lord, I'll say this.
This language resembles Justice Nariman's language. Who is the judge?
I will figure that. In fact, he has produced that compilation.
At the compilation.
It is a 3-bench. Lordship will know why this came about, why Vidya Drolia came about. Lordship will recollect a phase when we were also faced with the situation where lease dispute could not be arbitrated because of a language in an earlier Supreme Court judgment. The earlier Supreme Court judgment was, however, on the basis of the fact that in Bombay, there is a local legislation which said that lease disputes will have to go to small causes court. Therefore, the Supreme Court in that context said, lease disputes are not arbitrable without qualifying. That's because in Bombay, there is a statute which prescribes a forum for it. But Vidya Drolia stepped in and clarified that lease disputes by its nature is arbitrable, and clarified the earlier judgment, in which context Vidya Drolia has now said that any dispute which involves world at large or more parties than what the arbitration agreement has to go to the default mechanism, which is for collective adjudication. Now, my lord, the principle is this. I will only take 2 minutes to explain the principle as I understand. My lord, the principle is what was set out by Booz Allen.
3 principles emerge from this.
Lordship.
Arguably.
Lordship.
1, the arbitral dispute, if resolved, should not affect others.
Lordship.
That is the basic thing.
Lordship.
Number 2, unless the finality elements can be infused into the disputed fact matrix and resolution,
Lordship.
such disputes are not arbitrable.
Lordship.
These are the two.
Lordship.
Third, injustice to the person who could not be in the fray of arbitral
Lordship. Lordship.
proceedings.
I will
These
say
are the-
something. May I say this, Lord? Sir, if I can just finish. One point I'll finish. Traditionally, there are matters which are arbitrable and non-arbitrable. Booz Allen started that principle as to what is non-arbitrable disputes. While the series of judgments following Booz Allen did not really draw a line, the imaginary line, if we draw, there are two limbs to it. Limb number one is where a statute creates a special forum for adjudication. Let's say family court, DRT, any forum, rent control, it has to go there. It can't
and
be,
Reforms Act.
that's right. Therefore, it can't be abdicated in favor of an arbitrator's power. Secondly, Lordship, it's not about a forum creation. By nature, if a matter is non-arbitrable, classic will be a criminal case. By nature, if a matter is non-arbitrable, that will have to go to a civil court or a criminal court. That is what my learned friend, in fact, my learned friend is not saying there is a special court. Why he is saying it has to go to a civil court is because now the second category, as I mentioned, by nature, traditionally, why we say there is no judgment is because traditionally, if Lordship analyzes this, it is an inherent difficulty. By nature, inherently, right from the start, this subject matter could not have gone for arbitration. He is saying that the arbitration between the both of us inherently was not defective. It was a private arbitration. But by passage of time, one contract led to multiple contracts, leading to multiple stakeholding, leading to multiple public interest. It has acquired non-arbitrability. So it's not inherent, it is acquired. On the question of whether acquired non-arbitrability affects an arbitration, there is no judgment in the country. Inherent there are. Specific courts there are. But whether something which was at the outset an arbitrable dispute.
But in the course of time, it ceases
it ceases to be. And that is where Vidya leads us. And my lord, I'll also add this. The popular misunderstanding is that if something is a proceeding if something is a dispute in rem, it should include world at large. In rem is mistaken to be an expression equivalent to world at large. But if Lordship goes back to the genesis of in rem, I'll show the dictionary actually. In rem says in rem property in the hands of somebody else.
No, not like that. Not like that. In rem in Indian and English jurisdiction is treated in the law of evidence.
Not
under section 43 of our Evidence Act,
Not
43, 44 perhaps.
Not
In rem means what is decided in a particular jurisdiction is a res judicata against the world at large.
absolutely. It's a res judicata.
There are four.
Yes.
We have added one. One is insolvency proceeding.
Lordship.
2 is matrimonial proceeding.
Lordship.
3 is probate proceeding.
Lordship.
4th is admiralty proceeding.
Lordship.
1 I have added by my judgment, where statute is struck down by a constitutional court.
Lordship.
That operates against everybody, whether he is a party or not.
Absolutely.
These are the
Oh,
5.
Lordship.
Not necessarily they should relate to the property at all.
Having said that,
So the
Yes.
judgment which that Booz
Booz Allen.
that used the word rem.
Rem. Can I, having said that, can I only persuade Lordship to look at Black's dictionary? Because this understanding that in rem should be world at large, because a question may come, after all, it's not at world at large. It is against a definite number of people, 50 people maybe, but still not world at large.
No, it's not number.
It's not number.
It's not number.
It can't be.
Rem means res judicata against everybody, whether he's a party or not.
That's right. Lordship,
That way.
kindly see actio in rem in the Black's Law Dictionary. I'm sorry, my lord, the edges of the page are not in the ideal situation. Kindly excuse me for that. The third paragraph.
We need not worry about the edges of the page. If both are on the same page, that's all.
Lordship. The third paragraph is actio in rem. In the civil and common law, an action for a thing, an action for the recovery of a thing possessed by another, an action for the enforcement of a right or for redress for an invasion, which was originally available against all the world and not in any special sense against individual suit until he violated it. So therefore, classically, it is understood to be even if there is one third party. It is not against world number. Lordship, as Lordship said, it's not number.
At least two judgments of two high courts do not agree with this.
Lordship, may I say?
There are two judgments of two high courts.
Lordship.
Which they do not borrow this idea.
Lordship, may I only say one more point before, of course, I will show on the facts that it is not a matter which can be arbitrated. I will demonstrate on the facts. But may I say what today is being contended by the petitioner? Because I'm not joining issues with him.
You are with Mr. Joshi only.
No, Lordship may not.
In the sense.
May not draw that
But,
in from law.
there is not, see, it's not merely because you agree with him, it is not collusion. If I agree with the devil, it can be collusion. Suppose if I agree with the God, can it be collusion?
Well,
It may be
grateful, Lordship.
Collusion is a different thing.
Point of law is interesting. So
That's
we
what,
also
very
got
interesting.
enthusiastic about it.
Lordship may kindly understand this in the context of a regular CPC jurisprudence. I was listing out at least 5 points which are integral to our CPC, which in a way stand attracted to the incident. 1, right of audience. 2, right to be heard by testing each person's case against the another's case. That is joinder of parties under CPC. 3, necessity to set out the whole claim. Various parties necessity to set out the whole claim order to rule 2. Avoidance of multiplicity of matters. Consistency of result, which in any case is our equity.
And being bound by.
Being bound by. Therefore, Lordship, this is not in that sense unknown. The bits and pieces of what my learned friend is arguing is already available in our conscience, emerging from the CPC jurisprudence. Now, today he's raising in the context of arbitration, because arbitration particularly, thanks to 42A, is a secret proceeding. Lordship will kindly see 42A. In fact, the reason why he is not able to, why, Lordship, for instance, I am not filing a reply because in the reply, of course, if I file something before the High Court, nobody can find fault with me. But strictly going by 42A, a pleading from the arbitration cannot be taken out and put in any other proceeding or before anybody, because 42A says only the final award for the execution can be seen by the world at large. Kindly see 42A, Lordship.
In 1940 Act also it was there?
No,
it was not there.
In
Very
fact, it's a
consciously
statutory amendment. That's why 42 capital A. Capital A because it came by an amendment.
Please read.
42A says
This is 2019.
confidentiality, 2019 amendment. Notwithstanding anything contained in any other law for the time being enforced, the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitral proceedings except the award where its disclosure is necessary for the purpose of implementation and enforcement of the award. So strictly speaking, Lordship, even if I here produce a pleading from the arbitration, which I do intend to because it's a High Court and I do believe.
Any expert advice availing to the Parliament as to why this is made?
We are not
meant by this.
The
Object of 42A.
Lordship, the reason is this. I am aware of it from my practical experience. It came to a point till 2019 where all this Financial Express newspapers and all were picking up from arbitration.
If we want to non-suit a person,
Lordship,
you have to produce, there are 2 judgments of the Supreme Court, which says, they say, to say that there is an arbitration clause or that arbitration going on, the party has to produce the pleadings.
That's a confusion that we have. How to do it? It's a
Then how to
complete
implement this 42?
Absolutely.
What is meant by 42?
Absolutely. There's no light guidance there also. There's no leading judgment on this also. In fact, I had a situation, Lordship will bear with me for saying this. I had a situation where the counterparty violated arbitration. There's confidentiality in arbitration. I filed a contempt and the arbitral tribunal said, but consequence is not set out. It's a violation of the act, not violation of my order. So there's no contempt. Now, violation of the act, what is the consequence is strangely not set out by the statute itself.
Okay.
No, that applies to the parties to the arbitration proceeding.
Correct.
The focal point of section 42 capital A is the parties to the arbitration proceedings.
That's right.
Not Mr. Joshi at
No,
all.
parties, tribunal or arbitrator himself. Therefore, it's a secret
Very-
proceeding.
Correct.
Correct.
He is outside the ambit of 42A.
He is arguing that it is a labyrinth into which he can't get in. He does not have light over what's happening
No,
there.
whatever he can produce, he
Not-
can. Only
But he
thing
can't
is-
get access to it.
But unfortunately, unless otherwise directed by a court antanu illa ಇಲ್ಲಿ.
That's also not,
That is also.
that's also not there. That's also the
What is meant by, what is the reason d'etre of this amendment?
reason is
It's
this.
a new thing to
The
me.
reason is this. Large investment arbitrations. Reason is this, Lordship, large investment arbitrations which were inside closed doors started getting picked up by various news media. That point, there were deliberations as to how to maintain confidentiality because sensitive matters, including foreign investment matters, were going into arbitration. Then the legislature came in and stepped in and did this amendment. But there is, in fact, no leading guidance on how to get out of the problems of this. And one problem is typically this: if there is a third party, let alone get into the arbitration, he will not even know about the arbitration.
But but this will not bind you.
No,
Because see
No.
the purpose. The purpose is where its disclosure is necessary for the purpose of implementation and enforcement of award.
then it can be broken. Then the confidentiality can be broken. So
Not broken.
yes, Lordship will kindly see.
No. Please do not use the word broken.
No, Lordship may kindly see.
Then it will not be attractive.
No, Lordship will
That
kindly
is
see.
because the enforcement of the award has to come to a civil court under section
Except-
34.
It starts with except.
When in section 34, before the civil court, the award has to be enforced, then the pleadings and evidence can be disclosed.
Yes.
Until then, it cannot be disclosed.
Until then, it can't be. That's why Lordship may read from except. Except in this circumstance. So that's the only way out.
You are citing 42A.
Lordship.
For what purpose?
No, I am only saying, I am
You are
saying,
disabled from filing any of
no,
the-
I am not. I am
He is
saying,
arguing for me that I am prejudiced by 42A.
I agree.
Because as an outsider,
No, to you, it is not applicable at all.
no, to me, it's not applicable, it's not the point. It affects me, it causes prejudice to me.
That's another point. That you are going to be prejudiced by the arbitral proceedings output.
Correct.
Is
That's
another
the
point.
concern.
That's
the-
your substantive stand.
Correct.
But
That's
that
the
is miles away from 42A.
no,
No,
Lordship,
that,
42A is confined to parties to the arbitral proceedings. For others, no.
that's right. So the reason why 42A comes in my way and causes prejudice to me is I have purchased a site from the developer. Now I have come to know, because of that injunction order that has been registered in the revenue records, that he and the landowner are having some dispute. Even when I approach him and say, hello, what is going on? You have already sold the site to me. Some rights are now being determined in respect of the land of which I am also a co-owner. He will not tell me anything.
in fact, I have written to him saying I can't.
Let's see. What, Professor, what do you say? You appear for whom? Make use of your mic calls.
Sorry, madam. I appear for the second respondent, my lord.
Who is he? Developer or
Land.
you are for developer?
Landowner with whom says he has entered into an agreement, definitive development agreement, which I have cancelled. And their agreement of sale is pursuant to after I have cancelled it. Therefore, they have no locus standi to challenge what is happening between arbitration. They are not even a parties because their claim can only against the first respondent. There is no privity of contract between me and the petitioners.
Suppose if some award is passed,
Your Lordship will kindly,
it will happen to him.
if an award is passed, Your Lordship will kindly see give an example. I enter into an agreement of sale. The owner subsequently sells it to other party. What will be my remedy? To sue for a speaking performance against the person with whom I have entered into an agreement. Therefore, Your Lordship will kindly see if the petitioners have
That because agreement per se will not create interest in the property by
Yes,
virtue of
yes,
section 54
that is why
of the TPA.
in fact, I wanted to bring to Your
54,
Lordship
section
consideration.
54. But here
Under
is a
T-
case where
Your
already
Lordship will
transfer has taken place.
No, under the TPA Act, Your Lordship, section 54 is very clear. Agreement of sale.
Does
will
not
be-
create any interest.
They have got only the agreement holders.
Huh?
They are only the agreement holders, sir. Even according to, even it is not an agreement holder, even assuming that it is an agreement, they don't get any right because not the purchaser by registered deed. Your Lordship will kindly see, sale deed means it has to be registered if it is more than 100 rupees value.
The arrangement between developer and landowner
Yes.
Is what is the nature of arrangement it is?
Joint development
Yeah.
agreement.
That
Joint
is
development
the-
agreement. Does
but
it
the-
create
the power
interest
of
in the property?
Yes,
Your
there
lordship
is
will
a
kindly,
irrevocable power of attorney given to him.
power of attorney is given, he did not do what he was supposed to do, therefore I have cancelled it. After my cancellation, these people enter into an agreement with him after the cancellation. Therefore, that is all the question is before the arbitrator, how this man will be affected. That apart, if my lordship permits, can a matter like this private law can be invoked by Article 226? There
Where
is
he should go?
Your lordship will kindly see, where he should go is, one of the requirement of a person who enters in an agreement of sale is to make necessary inquiries and enter it. And your
No,
lordship,
where is the forum? You are not answering the question.
no,
You are finding fault with he coming to the forum.
I'm not finding. His remedy is against this man. Whatever the remedy he has got against this first respondent, then he has to pay because he has executed this agreement. Therefore, his remedy is that, not that I don't feel sympathy for him. The question is whether this man had a right to give such an agreement of sale after I have cancelled it. Therefore, the bona fides of that is to be considered.
In a public forum.
It is not, your lordship will kindly.
No,
Whatever they want, they can take the matter to civil court, fight it out. But they cannot come in the way of stopping the arbitration, because what happens to me? I may to be deceived by other person. He must become enriched himself on my cost. At what cost?
Therefore, he is arguing multiple interests. Lordship may kindly see one situation.
Your lordship will kindly say, my submission to your lordship is, the petition is not maintainable, your lordship. That is one thing. Whatever the other law remedies they are entitled, either against
He'll
him.
come back within a couple of seconds.
Very well.
Lordship, Lordship.
But he's a bit too enthusiastic in supporting, tell him too enthusiastic. Yes, sir.
There is a judgment on press in Brahma, press. Section 34. Sahib, Section 34 of the Statutory Act. There is a judgment by. What is judgment is the judgment. 34.
Will do.
ಬಹಳ ಚೆನ್ನಾಗಿ ಬರ್ತದೆ.
Town the court can permit him to include in the arbitration. Sir, arbitration act ಬೇಡ ಅಲ್ಲ ಕರೆಸ್ತಾ ಇದೆ negative party ಅಲ್ಲ
I remember reading McDonald's. On that, because McDonald's was a case of, no, McDonald's was a case of. I didn't that. I didn't that.
Rishi, will check for the dates?
Huh? Yes, sir. Laptop doesn't make it. See, it may collapse also in 10 minutes, but definitely not longer. Oh, sorry. Very much. No, no worry. No worry.
Here.
Yeah, also. We can mention the constitution. Yeah. Very well, you say I understand the application in India section to make it. No, very simple. To stop this application, why do you come with something to get? We go to the principles and bring bringing the phrase itself. Because they bring this, you say very well, that makes you have been entertained to stop arbitration. Why are you go before a civil court?
Which is some factual aspects, if I get 2 minutes, which are critical, because only I can present a 360-degree view, he can't. Therefore, some factual aspects I may be heard on. Lordship, some
Yes.
factual aspects,
Yes.
couple of minutes.
We are asking
Lordship.
one small question.
Lordship.
Suppose, Mr. Joshi,
Yes, sir.
you are A,
Yes, madam.
he is B, and C.
See.
Litigation is between B and C. Your apprehension is that the outcome of that litigation would prejudice your right.
That's
We'll assume now it is not an arbitral proceeding, but it is a suit.
Right.
And a decree they obtain in their favor, arguably that is prejudicial to your interest.
Yes.
What will you do?
Well, and as and when they come for execution, under Order 21, Rule 90, I will file objections.
Rule 97, you are entitled to file the objection.
that's-
Is one thing.
That's
Even otherwise, and you can maintain a suit saying that you are not bound by it.
unfortunately not. And that there, Section 5 of the Arbitration Act comes in my way.
Why?
I do not have the protections available to me under the CPC in arbitration jurisprudence.
No,
Even
that's-
once an
Let us
arbitral,
read that section.
Section 5 and
Section
section
5.
34 also.
I have.
Yeah,
Fine.
you know, that all that parties.
5 and 34, Lordship. 5 says,
Let us see. Fine.
Yes.
We do not have, at least I do not have much
Yes, yes.
exposure to.
kindly
this
see 5 and then 34.
5.
No.
Read 5.
One second. Extent of judicial intervention.
Yes.
Nothing, notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part.
No, that is,
What the result of this, the
that
way.
is as between the parties.
No, that's right, my lord, but the manner in which this clause has been interpreted and the manner in which arbitral jurisprudence in this country has evolved.
Let us see the judgments, how they have
So,
interpreted. this.
judgments under section 5 are not right now available with me.
It's on the court. It's
Huh?
not on parties. It's on the court. It's a bar on the courts. It's not a bar for parties.
Court shall not interfere, court shall not interfere, court shall not interfere. Repeatedly judgments have come.
Even against even a non-party.
Yes.
Once an
Meant by that.
the problem is this.
My lord,
In
civil
fact, the
court
words
Are
that are
not
used,
rem.
the words that are used is, once an award is passed, it is treated as something so sacrosanct that nobody can challenge it. That is my worry. If it were a suit, for example, the second set of landowners have filed a suit in Devanalli. I am not so bothered about that because if something happens, I know I have remedies in law, statutory as well as by.
How this is interpreted, brother?
Lordship, it's like this.
How
Section,
this is interpreted by the various high courts in the country?
Lordship, there is no, in fact, practically there is no suit ever filed to interdict an arbitral award.
We are asking you.
No, there
How
is,
this provision is construed by 24 high courts in the country?
Lordship, the difficulty in not having a problem, there is no guidance because suits are not filed for this purpose.
So till date, no decision.
No
on
decision,
this?
no decision that I've been able to find out.
Ah,
Point one. Point two. The remedy against an award is 34 and 34 says it's only restricted to parties. So 5 says,
34, he is miles away from 34.
that's right. That's right. So
34 is for parties to the arbitration.
that's right.
proceeding.
That's right. Therefore,
Don't worry about it.
that's
He is not a party to arbitration proceeding, therefore he cannot be within the fray of 34 at all,
Lordship.
or 37, whichever.
Lordship.
Question is, how 5 is interpreted by the courts? It has to be interpreted consistent with the 69 Supreme Court, Dhulabai versus State of MP. This has to be interpreted consistent with what the apex court said in Dhulabai.
We will, in fact, we
Justice
can
Dai
come-
to last judgment.
we can come back specifically on whether there is, to my research so far, there is no guidance to the contrary to the plain and simple interpretation of 5.
Any ruling on section 5? How you will interpret section 5?
My submission, Your Lordship,
Please read section 5.
I have read,
Now interpret it. Let us read together
yes,
once.
Your
Yes.
Your Lordship will kindly say, the
Notwithstanding,
power of the civil court.
let us
Under,
read.
yes, Your Lordship. Notwithstanding anything contained in any other law for the time being in force. In matters governed by this part, no judicial authority shall intervene except where so provided.
What
in
is this part?
This part is, my lord, as far as the arbitration proceedings are concerned, in between the parties.
Where is that part?
That is, shall intervene except where so.
Part 1.
Part
Yes.
one arbitration.
It is only part 1.
Yes.
That's right.
What are the part 1 ನಲ್ಲಿ ಇರೋದೇನೇನಿದೆ? Definition clause ಇದೆ.
Part 2 is for an arbitral award. Therefore, only
5
part
is
one.
not concerned with part 2.
Yes,
That's-
It
Therefore,
is only part 1.
that's right.
1 to 43.
Let us see. 1 to?
43.
No.
No, section 43 is limitations. After that, part 1A begins. That was by way of an
This
instance.
part means what?
This part means sections.
1, section 1, 2, 3, 4.
No,
That's
no,
all.
no.
6.
That's only the chapter.
That's only
The
the chapter.
part.
Part is given.
Part is
Ah,
given.
That's a longer one.
That's right. Part 1 arbitration, in
Yes.
which chapter 1,
Ah.
then chapter 2 arbitration agreement,
Yes,
chapter 3 composition of arbitral tribunal,
yes,
4 jurisdiction of tribunals,
correct,
5 conduct of arbitral proceedings,
correct.
6 making of arbitral award and termination of arbitration,
Yes,
7 recourse against arbitral award,
correct.
8 finality and enforcement of arbitral awards,
Yes.
9 appeals, 10 miscellaneous.
Let us read finality of arbitral awards.
Section 35.
35.
Subject to.
Finality is qua parties. It
That's
cannot be anything
That's-
else. Or those who
And
claim under the
persons
party.
claiming under them, which would cover me also, because my site, which I purchased, is from them, under the power of attorney executed by the landowner. And
Now, his case is that you have bought that property after rescinding of the power of attorney.
Individual
But-
cases apart, we are on the issue of principle that where sale deeds have been executed. The fact of the matter is that sale deeds have been executed. In a given case, agreements of sale may have been executed. In a given case, improper exercise of power by the developer may be the cause of concern. That may be there. We are with a
On
situation where the joint development agreement has been acted upon, power of attorney has been acted upon, sale deeds have been executed. Then what are these two fighting among themselves? I am also affected.
Kindly come to 35.
35.
Finality of arbitral award.
Subject to this part, an arbitral award shall be final and binding on the parties. and persons.
Parties and persons claiming under them
Respectively.
respectively.
An award being passed and adjudicated and passed in a dispute between them in a private chambers will eventually bind me also.
Is it your case that you claim under parties to the arbitral?
I
process?
have to, no, my lord.
Where have you stated in your
My lord,
petition?
I will take a look at it.
Third party is derived title through the our
Where is
transaction.
the averment? I claim under the parties to arbitral proceeding.
My lord.
And what is meant by claiming under a party? At least there are three judgments.
That's
Claiming under the party, which while interpreting section 11 of CPC.
if my title
Yeah.
flows commonly from the same set of rights, then I am set to
That-
claim under.
that's-
That's
Therefore,
it.
if there is some very weak link which the law will not take cognizance of, it
That's
will not be a party claiming under a party.
That's it.
Yes.
Because, my lord, the landowner.
If your case is that you are under, you are a party person claiming under a party,
That's right.
go to 34.
34, my lord. My lord, give me a minute. Good. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. An arbitral award may be set aside by the court only if there are various grounds, my lord.
Then if you claim to be a party, person claiming under a party, then 34 comes to you.
There is no such judgment ever of any court
We'll tell it now.
which permits a
Otherwise, 34,
non-party.
no, just, otherwise, section 30, yaudadu, you read binds,
See,
whom binds,
35.
whoever is bound, he will have right of appeal. There are judgments.
My lord, the difficulty is this. The scope of intervention under 34 is so restricted.
That happens even to the parties to the arbitration.
That at least if I have had an audience before the tribunal, my arguments are considered by the tribunal and then rejected.
Where have you stated that you are a person claiming under the party?
My lord, I'll come to that.
Where is that ever meant? And where is material to vouch that ever meant?
My lord, the material is this.
Now, where is the ever meant? Let us see the ever.
Para 6. Para 6 facts of the matter.
Read that sentence.
Lordship may see definition of parties in the act itself. Definition of parties
Includes
there
the-
in the- it's only parties to arbitration agreement. Party is defined in the act. It's a defined phrase.
Under 34.
I think there is one amendment. huh?
No,
There is
Lordship
some
will see
amendment has taken place.
2H says
That-
party means party to the arbitration agreement. Kindly see that. And then 34 says a party making an application establishes so and so.
That's right. Which of them?
ಅಕ್ಷಯ್ ಜೈನಿಗೆ ಫೀಸ್ ಕಳ್ಸಿದ್ವ ನಾವು ಥರ್ಡ್ ಕ್ಲಾಸ್ ಸೂಟ್ ಇತ್ತ ಕ್ಯಾಲ್ಕಟಾ ಸೂಟ್
This compilation there.
When some amendment took place,
Claiming through definition is not there in the definition of party. Party is a party. An agreement is under 7.
In fact, my lord, in the compilation of decisions that have been submitted by the petitioner, a Bombay High Court decision says that an outsider who's not covered under 21H cannot lay a challenge to an arbitral award. Mukesh Gala versus Heritage Enterprises.
then you file suit.
But even a suit will not be entertained because of section 5.
Say that we will say that section 5 does not come in your way.
May not, that,
Right now, we will say that.
that may not help us because that will go against the statute.
No,
The-
we'll say statute is what judge says. Law is what judge says. This is what to ask Oliver Wendell Holmes said. Ultimately, therefore, the President Roosevelt used to say, we have a constitution, but it is what our judges will say. That applies to here.
The result will be like this. The result will be like this because all this was considered and therefore the writ court was
So, Joshi,
decided.
our object is that you should get
I know.
some relief. You cannot go injured, all hospitals being closed. We are telling
My
you,
lord has got it.
you can go to this hospital.
That hospital will not give me an admission using the
No,
same,
that will
the
say
same
that.
analogy.
You will get, whether your treatment will result fruitfully or not is another thing.
The operation is
But
successful or
admission,
not.
admission to
Admission.
the hospital
Admission
and to the OT will ensure.
The analogy is very apt. The analogy is
So this
very apt.
five, we do not agree. We do not much know. We can't say will because of parliamentary statutes. Generally, central legislations are more seriously done, subject to some exceptions. Section 5, you read extent of judicial intervention.
That's right.
Notwithstanding anything contained in any other of what I'm being enforced. So provided in this part, this has to be read in the light of various provisions of the act, not an island provision.
But it is treated like
we
in that
can
manner.
come
The
back.
reason is this. In fact, like the Bombay High Court has said in Mukesh Gala's case.
Professor,
My
now-
lord,
now
in fact,
proceedings are
there,
concerned.
yes, sir.
We want to,
Yes, sir.
let us try to reduce the scope of
Yes,
litigation.
sir.
Suppose if he goes to suit,
Fine.
do you invoke section 5?
I will not.
What about you?
My lord, in the suit,
Record that.
in the suit,
My lord, their prayer
You are
itself-
otherwise that.
my lord, in the
Now
suit,
they are saying,
no.
we will say, no court
My
will
lord,
raise, you will close its doors by invoking
But I
section 5.
was just
my lord, that is
asking
his
myself
prayer,
this
your
question.
lordship. He
Huh?
wants a prayer. Declare that all concerned parties are free to approach the civil court of competent jurisdiction to
That's
pursue
not-
any
that's
legal
not my
remedy
prayer.
concerning the
not
subject
my-
dispute. That
That's
is
not-
what your lordship.
My lord, I asked myself this question. Today, if I were to approach a civil court, what would be the relief that I need to ask?
Whatever relief
Yes.
you against the award, if whatever rights.
That suit is bound to fail. As against an award, if my
Mr.
lord is directing me
Mr.
to file a
Joshi,
suit.
Mr. Joshi, though section 5, as your friend said, it's a legislative injunction. Now we don't have original jurisdiction in matters of suit.
That's right.
So all courts,
District.
other courts will do that.
District court.
We are on 227 or supervisory jurisdiction. We will injunct the courts from non-suiting you based upon section 5.
Therefore, then the suit that I will have to file today I'll have to file today, restrain these arbitration proceedings.
We do not.
The same relief that I seek before my lord,
We can.
I will have to seek that relief before in a suit.
We do not.
A civil court will not even entertain me, my lord. If that is the relief.
Then when they do not entertain you, then you should come to this court. Refusal to exercise jurisdiction will be one of the grounds.
But here the law itself, the jurisprudence itself has evolved in such a manner that I've come directly before this honorable court.
Lordship, May
saying
I,
that-
may I say one thing, Lordship?
You are agree.
May I say something, Lordship?
We are non.
That's right, that's right. The Lordship has come to, brought
So
it to
you
what?
want to see that these proceedings are halted.
No, Lordship may not say
Yes,
that.
he's
No, no,
colluding with them.
No, Lordship may not
I
say
want
all
to
this.
see
That conclusion, may I say something, Lordship? That is exactly why I said, may I be permitted to say something on the facts? It is beyond one petitioner. We started from the subject matter being non-arbitrable. It is beyond one petitioner. And that is why may be heard, my difficulty is this, Lordship. End of the day, inconsistent results, and where does the developer go? That's my difficulty. And may I say the facts from my perspective? After that, I leave it to Lordship. May I say some facts? This arbitration comprises 3 properties. Property number 1 is between me and him. Property number 2 is between him and the respondent number 3, which is already in a suit because respondent number 3 has cancelled their inter se JDA, which is already a subject matter of suit.
In a Devanali court.
In Devanali. Property number 3, which is the largest chunk, which is supposed to be make 35 acres is property number 3. Property 1 and 2 are only 6 acres, 7 acres. Out of the total 45, largest is property number 3. My claim against him is that he has not even acquired.
You are not the petitioner.
No, I am in the arbitration.
You can resist his petition if you want. You can sail with him. But where his boat is sinking, obviously, if you are sailing with him, ಅದು ಆಯುಷ್ಯ ತೀರ್ಥರ ಜೊತೆ ದೋಣಿ ಪ್ರವಾಸ ಆಗ್ತದೆ. ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. There are such judgments.
Only such facts I need to point out.
What is the fact? What
The
is
fact
that?
is-
We are now saying,
Yes.
we are telling him that he should get justice in accordance with law. We will say we keep this section 5
Not,
in capsule.
we will come
Okay,
with some
one
judgments on section
Submission,
5.
Lord, from my end, if my lordship permits.
ಹೇಳಿ.
Lord, what has happened in this case is, all that what we have committed before the court as regards going to civil court stands. I'm not going against that.
Okay.
What I am submitting is, kindly appreciate, my lord, that the party before my lord has a contract with my learned friend here, who is learned friend's client, not with us. We are not directly allowed him. Now, in 2017 itself, termination of the joint development agreement between the owner of the property and my professor, our client jotege, it has been done. 2019 an agreement, letter of allotment mele writ petition ಹಾಕೊಂಡಿದ್ದಾರೆ. That is one submission. Arbitration proceedings alli, my lord, my respectful submission is, nothing prevents my learned friends to examine their create that they have executed this document, examine him as a witness, nothing prevents
ಮೆರಿಟ್ಸ್
them.
ಮೇಲೆ ಆಗ್ತದೆ.
ಅಲ್ಲ, ಅದು ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಾದ್ರೆ ಕೇಸು ಈಗ ಸ್ಟೇ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ.
ರಿಟ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಿಮ್ ಸಬ್ಮಿಷನ್ ರಿಟ್ ಜುರಿಸ್ಟಿಕ್ಷನ್ ಇರಬೇಕು.
ಇಲ್ಲಿರೋದ್ ಪಾಯಿಂಟ್ ಇಷ್ಟೇ, ಮಲಾಡ್. He has no first to make out a case that he has got a direct interest in the subject matter of this property. We have not executed a document in his favor. After termination of all powers, they have executed some document, they have set up is our contention. Now setting up this party and filing a writ petition on merits, ಮಲಾಡ್, they have been set up.
ನಿಮ್ಮ ಅವಾರ್ಡ್ ಆಯ್ತು ಅಂದ್ರೆ ಇವ್ರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀರಾ?
ಅವ್ರು ಇರಲ್ವಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಪೊಸಿಷನ್ ಇಲ್ಲ.
Now we are asking you.
ಸೇಲ್ ಡೀಡೇ ಇಲ್ಲ.
Since you are arguing, we want to ask you, if award is passed in your favor, are you going to execute it against Joshi? Answer that question.
As far as we are concerned, my lord, we are owners of a certain area only, as they said,
You
6
are,
acres and odd.
You are,
We have filed a civil suit for termination against the
you are not,
developer.
you have to answer the court question. This question admits binary answers.
This-
There can be
this-
explanation.
Yes, my lord.
First, are you going to, suppose in the event award is passed in your favor,
Obviously, my lord.
you will proceed against Joshi also? Then we'll
They will-
wish
they-
to
they-
rule and stay the proceedings.
They come under that. It is not my area.
No, therefore, we are asking you now.
We will not,
Based
will
upon
not-
that answer fate of this
we
case.
will not execute because it is not our area of land.
What do
which
you
is
say?
per-
Do you execute the award against Joshi?
I go against only the.
Ask your advocates to file memo. We are asking this question.
Not one more aspect.
File reply. Other, we have heard you. We can't go on hearing the matters. We
Kindly-
can do justice otherwise.
Last
Ask-
submission.
Ask your client whether he is agreeable to file a memo that in the event.
We can't
award-
because we don't come under that.
You don't come under that category at all.
Only I am highlighting because I have to support the, my lord, only one
File a
request,
memo.
my lord. Kindly
Two,
see,
two things you have to say. That section 5, you will not invoke, nor you will invoke to non-suit him. Number 1. Number 2, award which you are going to get in your favor, hopefully or hopelessly, that will not be executed against Mr. Joshi. But ಬರ್ಕೊಡಿ. ನಿಮ್ಮ submission right in ಆಗಿ ಅಷ್ಟೇ.
only one request, my lord.
ಹೇಳಿ.
Page 140 ಅಲ್ಲಿ ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡಿದ್ರೆ ತಾವು.
140.
Page 140 ಪ್ಯಾರಾ 30.
ಅವ್ರಿಗೆ ಮೆಮೊ ಕೊಡಿ.
ಅವ್ರ ನಡುವೆ MSK, ದಟ್ ಇಸ್ ಪ್ರೊಫೆಸರ್ ಅವ್ರ ಕಡೆಯಿಂದ ಈ ಅಪ್ಲಿಕೆಂಟ್ ರಿಟ್ ಪೆಟಿಷನರ್ ಜೊತೆಗೆ ಆರ್ಬಿಟ್ರೇಷನ್ ಅಗ್ರಿಮೆಂಟ್ ಪ್ಯಾರಾ 32 ಅಲ್ಲಿ ಉಂಟು. ಇಸ್ ದೇರ್.
Page 140 ಅಲ್ಲಿ ಯಾವ paragraph?
32, my lord.
All or any dispute arising out of it concerning or touching this agreement, including the end. Any party to a sole arbitrator appointed with a developer whose decision shall be binding upon the party. The party is
One
agreed
party.
that no other person shall have the power to appoint the sole arbitrator.
That is between our
developer
client,
and he himself will appoint the
yes.
arbitrator.
Our parties to the arbitration agreement, they are bound by the act, by the sections.
Who appointed the arbitrator? All right, but good. Just
So-
right now. What you said, you right.
View of this
I'll make it
clause-
part, we will make it part of the order.
In view of this clause, my lord, they are bound to not to take any other action against 5 that I'm just
Yeah.
highlighting.
Petition,
My impleading application may be.
petition dismissed on the following grounds. Number one, if there is going to be an adverse award to the interest of the petitioner, comma, he will not be bound by it. And he can have his own recourse under the conventional law, namely the CPC. More particularly, Section 9, as widely construed by the Constitution Bench of Apex Court in Dhulabai versus State of MP, AR 1968, it was 69, Supreme Court, page 79, 78. First up, learned, you are appearing for learned counsel, owner. Second, learned
Not
counsel.
owner of
To the property.
Learned counsel appearing for the second respondent, owner of the land in question, property in question, has filed a memo voluntarily and knowledgeably to the effect that petitioner's suit against adverse award, if any, shall not be negatived by invoking Section 5 of 1996 Act. Full stop. We also injunct the courts that may be approached by the petitioners with a lawful cause not to non-suit him by invoking Section 5 in respect of subject matter of the petition.
my lord.
All contentions of the parties are kept open.
May be made
But
clear.
just one request. This is perfect justice.
Perfect.
This suits the petitioner perfectly.
It may,
Only one request.
it may be
lord
observed
has said
that
in
in
the
the
event-
event he goes against the owners of directly,
My lord, I have
under
only
the
one-
provisions
only one
of the
request.
Arbitration Act,
My lord,
the clause there.
my lord, only one protection.
This order shall not come in the way of petitioner working out his remedy, even under the 1996 Act, provided
To the
the
extent
same
available.
is
To the
admissible.
extent admissible.
Yeah.
My lord, only one request. My lord has said, in the event of the petitioner filing a suit to challenge the adverse arbitral award or challenging the arbitral proceedings.
Award stroke proceeding.
Proceedings.
Right.
Grateful. Great. That gives protection.
This photo, yes. Very good.
Obliged.
The application for implementing does not survive for consideration since the main matter itself is dismissed. Dismissed or not better, disposed of.
One last indulgence. One last. There is already an interim order prevailing in my favor in this petition, staying the continuation of the arbitration proceedings. In the light of this order, now, my lord, within a week or 10 days, I will file a suit.
Interim
Till
order
then,
stands.
let the interim order.
No. Interim order stands dissolved. Okay. Next.
What's
Was to discussion.
For the petition in this case.
Yes.
Lords, in serial number 10.
Ah.
Appear for the Public Service Commission, respond number 2, my lords. As against non-granting of an, this is as against non-granting of an interim order, my lords, in original proceedings out of them. My lords, may kindly peruse, my lords, what was their interim prayer there?
Our earlier, so
Please.
that might, will come to you. Will not pass any adverse order against the state without hearing their counsel.
Please.
But
3/9/2022.
ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿಲ್ವಾ ಪಿಟಿಷನ್ಗೆ? KIT ಮುಂದೆ ಯಾರಿದ್ದಾರೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದೆ.
ಮತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅವ್ರ ನೇಮ್ ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ, ನಾವ್ ಹಾಕಿದೆ ನಿಮಗೆ. ACT issued certified copy of the order. It has omitted to give the name of the respondent. I have produced as it is. But we have made them party. And this is certified copy. Then ಮಾಡಿದ್ದಾರೆ page 30 33 ಅಲ್ಲಿ 34 ನೋಡಿ ಏನಾಗಿದೆ, 33 ನಂತರ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೇಮ್ ಕೊಡ್ಲಿಲ್ಲ. But we have filed made them all respondent because we have filed application in Exhibit B, whatever filed before the terminal. There are 2 respondents.
Yes, ಏನಿದೆ? ಅಲ್ಲಿ ಇನ್ನೊಬ್ಬ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ರಾ?
ಇಲ್ಲ,
ಇಬ್ರೇನಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮತ್ತೆ ಇನ್ಯಾರಿಗೆ ಅಪ್ಲೈ?
ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಟ್ಟಿದ್ದೇವೆ, ಕೋರ್ಟ್ ಫೀಸ್ ಇತ್ತು ಕೊಟ್ಟಿದ್ದೇವೆ. ಕೇವಿಯೇಟರು ಈ ಆರ್ಡರ್ ಮೇಲೆ ಕೇವಿಯೇಟ್ ಹಾಕಿಲ್ಲ, ಅದ್ಯಾವುದು ಬೇರೆ ಆರ್ಡರ್ ಮೇಲೆ ಕೇವಿಯೇಟ್ ಹಾಕಿಲ್ಲ.
ಕೇವಿಯೇಟ್ ಹಾಕ್ಲಿ ಬಿಡ್ಲಿ, ಪಾರ್ಟಿನ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಮಾಡಿದ್ದೇವೆ. KPSC is part.
Name of respondents in SKT order copy not forthcoming. SK order copy ಬನ್ನಿ, ಯಾರ್ಯಾರಿದ್ದಾರೆ ಹೆಸರು?
SK ಆರ್ಡರ್ ಕಾಪಿಯಲ್ಲಿ ಬರೀ ಅಪ್ಲಿಕೆಂಟ್ ನೇಮ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮೇನ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಯಾರ್ದಿದೆ?
ಮೇನ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಅವರೆಲ್ಲರನ್ನು ಮಾಡಿದ್ದೇವೆ ಎಲ್ರನ್ನು.
What the office
ಇವ್ರು ಹೇಳೋದು ಇಲ್ಲೇ
order ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ.
Office objection is unsustainable and therefore removed. Okay. Connected maternal petitioner is not a party.
I don't know.
This case, since the interim order is rejected, 9 applicants have come directly.
ಹೆಂಗೆ ನೀವು ಡೈರೆಕ್ಟ್ ಹಾಕ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಈ ನಂಬರ್ 10, there are total 10 applicants, 9 applicants.
He is also applicant only. You are also applicant only.
ಅಲ್ವಾ?
ಅಲ್ಲ,
You were not before the KIT at all. Then how can you maintain the petition directly?
So far as the interim order is concerned.
Correct.
It has been already turned down because cause of action.
That's interim order is not the cause of action. It is here petitioning ಅವರಿಗೆ. ನಿಮ್ಗೆ ಎಲ್ಲಿದೆ cause of action?
If I go there, my lord.
Why do you think that same order will be repeated? Court may change its opinion. No, that's not. That petition is not maintainable.
We are all selectives and working on that.
Mr. Lakshmi Narayana, you know the law. You were not before the tribunal at all.
Even if I go there,
Same thing will happen.
same thing will happen.
But you have to file a suit. Even if decree is going to be, only then you can come in appeal.
Especially if the judgment of the apex court is similarly situated order, person may not be a party, is permitted to challenge the judgment. Therefore, even in case also is not a judgment.
It runs counter to G97 Supreme Court.
Chandrakumar, L. Chandrakumar.
Court
of first instance, they have to go there and subsequently clarified. Even review, my lords, was held to be direct writ petition. Now there's one more judgment which says that you have to go before a party who is aggrieved by an order of the final order of the KIT has to go exhaust the review remedy and then come.
That's what we have held.
In case the separate application is filed, suppose any interim order is granted here, that will be read over and same order will be passed.
That's what. So that's no ground to cut short that procedure.
Cut short. And the order that they have challenged is
not that. Mr. Bhagwat, yes. Our petition maintain agala nimdu.
3/9/2022.
3/9/2022. What was challenged before the KIT?
Not condition of putting the, my lord, our appointment, after appointment, KPSC
Condition of appointment.
appointment.
ಏನ್ condition ಅದು?
On the basis of the letter issued by the KPSC which prepared a final list, sent it to the government, we are appointed. One condition was put, my lord, that communication was questioned.
ಏನದು condition?
Communication is, my lord, we are holding inquiry, please don't issue appointment order. Is it permissible, my lord, KPSC once
ಏನ್ enquiry ಅದು?
ಅದೇನೋ irregularity ಆಗಿದೆ ಅಂತ inquiry, after final list is published, send it to the government. Government appointed.
Suppose ineligibility enquiry ಆದ್ಮೇಲೆ ineligibility ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ.
Government has to take action. I have no objection. If government says, my lord, our appointment is illegal, we have nothing to do it. Can a government lord say that subject to that we are appointed? No, that can't be, because once finally it is published, send it to the government, the KPSC becomes functions of issue. It cannot.
ಅದು ಲೆಟರ್ ಇದೆ, ಏನು ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಅವರು.
ಅಲ್ಲಲ್ಲ,
ಈ ರೀತಿ
enquiry ಸ್ವಾಮಿ,
enquiry ಆಗ್ತಾ ಇದೆಯಾ?
enquiry ಆಗ್ತಾ ಇದೆ.
There is enquiry.
It is completed, my lords. My lords,
But enquiry is completed.
The final select list was dated 31/1/2024. In respect, my lords, of 24 posts of AEE, my lords, in the Department of Water Resource Department, in Rural Drinking Water and Sanitation Department. My lords, before the provisional select list, before the final select list was acted upon by the state government, the Public Service Commission, my lords, wrote a letter on 22nd of February 2024, stating that there are some complaints regarding the irregularities in the OMR with regard to OMR tampering in respect of the main examination that was held. So therefore, appointment orders may not be issued and the communication was issued. But government, my lords, took a decision on 25/6/24.
Appoint them subject to condition
A provisional
that
appointment order was issued, subject to the condition that it will be based on the further recommendation made by the KPSC. So it was a provisional.
the enquiry at the hands of whom it is going on?
Inquiry, my lords, the Public Service Commission received complaints with regard to, my lords, certain irregularities in the exam that was committed regarding OMR fraud. Thereafter, my lords, there was 24 selected candidates. Commission constituted a subcommittee of the members of the committee to hold an inquiry. And thereafter, the subcommittee has given a report.
Where is the power to hold inquiry once you send the
No, my lords, it is,
select list?
that is always available.
Read section.
My lord, kindly see the-
20, my lords.
1 second, Mr. Bhagwat, we'll come back to you.
Sir. ಆ decision ಹಾಕಿದ್ದೇನೆ.
Take out your act.
Please.
Which
Lords,
is that act, which
Lords,
gives you
we-
the power?
Lords,
You are a statutory function, a constitutional.
No, I'm a
functionary.
constitutional functionary. My lords,
So you have to operate within
Under-
the constitutional
within the
framework.
constitution. My lords, I'm straight away covered by a judgment of the court. My lords, may I just pass it on?
Okay.
My lords, the right, my lords, flows under Article 320 itself.
Okay. So they want to hold the inquiry.
My lords, paragraph 12. Paragraph 12, my lords, next page. My lords, may kindly come to the next page, my lords. ಅದರಲ್ಲಿ my lords, ಮೇಲಿನ ಒಂದು 10 ಲೈನ್, therefore under Article 323A ಅಂತ ಇದೆ. ಮೇಲಿನ ಒಂದು 10 lines.
Correct. They are under
Therefore,
323,
under Article 323A
B.
and B, it is a duty of the Public Service Commission to consider and to get itself satisfied as to which of the candidates has fulfilled the requisite qualifications specified in the advertisement. The commission in this particular case has got duly verified the certificates. This is after, my lords, the final select list was sent of Dr. Bindal in respect of his experience of 5 years in drug testing by Deputy Secretary of the Commission. And after considering his report as well as the certificates, came to the conclusion that the appellant, though fulfilled educational qualifications, lacked in the requisite experience of 5 years in drug testing. The commission therefore revised its earlier decision and withdrew the candidature of the appellant and also cancelled its recommendation earlier given in favor of the appellant. This decision of the Public Service Commission, in our considered opinion, cannot be faulted. It is the constitutional requirement envisaged in Article 320 that the Commission will have to perform the duty of recommending the candidate, fulfilling all the requisite qualifications for the post to the government for being considered for appointment to the post concerned. It is, of course, a well-settled legal position that the duty to consult the Commission in the matters of appointment to civil post by the government is not mandatory, but directory. And as such, the absence of consultation with the State Public Service Commission does not render any appointment made by the government in civil post invalid or illegal. It cannot also be contended that since the duty to consult the Public Service Commission in the matter of making appointments to civil service is directory and not mandatory.
When you sent the final select list,
31/1/2024.
ಏನ್ ಪೋಸ್ಟ್ ಇದು?
Assistant Executive Engineer,
Grade 1.
grade 1. Rural Drinking Water and Sanitation Department,
Final select list dated,
31st of January 24.
when did you send it to government?
My lords, the next day itself.
How it was sent?
My lords, through a letter. It will be sent to a letter.
That letter, number, date,
My lords, will furnish it, my lords. It's not available, but it was sent
sent very next day.
very next day.
When did you receive the complaint
My lords,
and from whom?
lords, from the unsuccessful candidates. Report on
How many complaints?
When Reddy, who became unsuccessful in the examination, Lord has filed a complaint.
Suppose if something which the complaint says it has happened, where?
But once the government has power, Lord, they can annul the appointment. I am not saying that.
No, but they can point out, this mistake has happened like this. Therefore, government should take the decision. Government has said that.
No, government has never said.
Huh? No, government has stipulated the condition.
Correct. That condition we have questioned, the communication we have questioned. That's all.
Lords,
On
25/9.
grounds, because this court examining the very question held by Lord.
Complaints for how many complaints
Lords,
came?
one complaint was received on 25/9/23.
25,
9/23.
but you sent it on 31/1/24.
Please, my lords, on 31/1/24, we had already sent the list. The complaint was
31/1/24. You are not, don't use the word already. Complaint is dated 25/9/23.
Please, my lords.
Huh.
Complaint was received earlier.
Correct.
Thereafter, selection was finalized. Then, my lords, in the meantime, my lords, with regard to the complaint, when we found out, my lords, that there was, the commission found out that it requires further probing in the matter.
Why, when you had complaint on 25/9/23,
Please.
why did you finalize the list without looking into that? We are not inferring anything from the discussion taking place in other quarters about the conduct of KPSC.
Please, please,
We are not saying anything about that.
please.
But on the basis of material on record, we are telling you,
Please.
31/1/2024 is the final select list. You sent it next day before the ink had dried up. And you had the complaint on 25/9/23. Why did you not look into the complaint? Why did you send the final list?
Please. 8/12/2023, subcommittee was constituted.
8/12. 1 second. Who are the members of the subcommittee?
Lords, 3 members of the commission.
Huh?
Subcommittee of the commission comprising of 3 members of the commission.
Give their names.
Please, my lords. Can I, Shanta Hosmani,
Number 2.
Geeta BV,
3.
Mustafa Hussain.
What did they do?
Lords, it was, the committee was reconstituted.
1 second.
Please, my lords.
25/9/2023 ಗೆ ಕಂಪ್ಲೇಂಟ್ ಬಂತು.
Please, my lords.
ಇದರಲ್ಲಿ ಅಪರಾಧ ತಪರ ಆಗಿದೆ ನೋಡಿ ಅಂತ. Where is that copy of the complaint?
Lords, it is not part of the proceedings. I'll place it on record. We have the report itself. I have the entire report in them.
ಅಲ್ಲ ಅದಕ್ಕೆ 2.5 ತಿಂಗಳು ಯಾಕೆ ಬೇಕಾತು ಅಂತ ಕಮಿಟಿ ಮಾಡ್ಲಿಕ್ಕೆ.
ಅವ್ರವ್ರು ಜಗಳ ಮಾಡಿ tell you, one committee.
Just we want to know.
Committee.
Because a lot of discussion in public domain is taking place about the regularity of the proceedings. We are not saying anything more than that.
Certainly.
Because we are in a forum now. Therefore, we will not say.
Yes.
But the constitutional bodies, somewhere people are gradually losing faith in the constitutional bodies. Courts are also maybe constitutional bodies only. But everywhere, now people are doubting the constitutional organs.
This, Millards,
Ah.
this,
Karnataka Public Service Commission, constitutional body. The members, my lord, you get the other members to be one complaint. Complainant does not prosecute the case. They raise OMR discrepancy. A test conducted in 2023. And nobody has.
Let us see. Committee is constituted.
please, Millards,
You felt it's a serious complaint.
please.
Therefore, you constituted the committee.
Please.
Why did you finalize the list?
Please.
What the committee said?
Millards, the committee, I'll just.
Buddy.
Furnish a copy to me also.
No,
Once
this is
I look
the
at
report of
first.
the subcommittee. Millards.
Subcommittee report.
Committee report is
Yes.
what it said in the
Millards,
end.
it is, Millards, it was found, Millards, out of 24 selected candidates, there is OMR tampering, Millards, in respect of 10 candidates.
One second,
Please,
one second. Where
Millards,
is the finding ellide?
finding, Millards. 88, top of the, page numbers at the top of the page, Millards.
88.
Page 88.
Ade yavat bantu?
Millards, this was in the month of January 2025. For 6 months, they keep quiet. After this report is out, still we have not taken action on the basis of this report. They go and file a petition before the KIT challenging only the condition in the appointment order. And there is no interim order here not to precipitate. Either we have to initiate criminal prosecution, my lords, and also take steps with regard to cancelling their candidature. My lords, have page 88, my lords. Please, my lords. Recommendations.
The commission shall cancel the selection of tainted candidates as shown in para 66. Commission shall authorize secretary to initiate criminal action against the tainted. This is dated?
This is dated, my lords, 23rd. 23/1/25.
23/1/25. So 31/1/24 you had sent already. You sent it on 31/1/24.
Please, my lords.
Why did you not wait when you had appointed a committee?
Please.
Committee is looking into the aspects.
Please.
All third rate things happening in the KPSC. Why before committee said something about the third rate things?
Please.
Why did you send the select list?
That is narrated in para 4 onwards. Para 4. Page 2. Lords, committee was subsequently reconstituted. I'll take my lords to that. Page 2. Para 4, my lords, bottom of the page. On
Commission invited objections, if any, from aggrieved candidates to be submitted within 7 days.
from the date of publication of provisional select list.
Correct. That was published on which date?
Lords, provisional 22/9/23.
22/9/23.
Please, my lords.
Only thereafter you appointed the committee.
Please, my lords. The committee narration comes here. Idralage ide paragraph alle. Para 4 notice. Para 4.
Para 4.
On 25/9/23.
So and so.
Forwarded
Forwarded objections to the Secretary Commission through email which was received in the office of 7 PM. The allegation in nutshell or as under candidates number so and so.
and
From
candidates.
RPC candidates anyone from HK in provisional list have scored very less marks in various examinations conducted during 2022 and 23, but did not succeed in tampering OMR sheets. But however, they succeeded in tampering of OMR sheets in AEE RDPLS examination conducted by the commission on 2 July 23 and requested to cross-check the OMR sheets and CCTV footage of respective examination centers and to take immediate action.
Para 5. This complaint was discussed
in the
in the
commission meeting held on 3/10/23.
Please, my lords.
3/10/23 ಆಗಿದೆ 8/10/8/12 ಗೆ 3/10/23 discussion was there.
Discussion was there. The commission was cognizant of the fact, and then, my lords, what had happened is narrated.
Commission resolved request secretary to secure all the relevant information from so and so 10/10. You said so and so. Information from the batch along with CCTV footage, some link to the notice of so and so. The Secretary also informed to the commission that the provisional selection list was published about 2 months back and she is receiving complaint from the candidates. And so again, this issue came up for discussion 28/11/23. 23 under in ಮುಂದಿನ ಪೇಜ್ ಅಲ್ಲಿ ಹೋಯ್ತಿದ್ರು
Please,
ಪೇಜ್ 4-5 ಕಂಟಿನ್ಯೂಟಿ ಇದೆಯಾ
please. Again discussed on 10.10, my lords. Then again on 23.11, my lords, it came up for discussion. Para 8 ಅಲ್ಲಿ. The secretary also informed the commission the provisional select list was published about 2 months back and she is receiving complaints from candidates and there is no meaning in withholding the finalist and insisted the commission to.
Please come to come to page 7.
7, please.
Item number 1, Sharavadi.
In page 7, my lords.
ಹಾ
ಅಮರ್ ನಾಯ್ಕ ಅಭ್ಯರ್ಥಿ ಸಲ್ಲಿಸಲು ಆನ್ಲೈನ್ ಅರ್ಜಿ ಮತ್ತು
ಜೋರಾಗಿ ಓದಿ ಎಲ್ಲರಿಗೂ ಕೇಳಿ ಇದರಲ್ಲೆಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತಿರ್ತದೆ ಲೆಟ್ ಪೀಪಲ್ ಸಿ ಅವರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಪ್ಲೀಸ್
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಓದ್ಬೇಕು ಜನ ಎಲ್ಲ ನೋಡ್ಬೇಕು ಪಬ್ಲಿಕ್ ಇಡೀ ಸ್ಟೇಟ್ ಜನ ನೋಡ್ಬೇಕು ಇದನ್ನೆಲ್ಲ ನಾವು ಕೆಲಸ ಮಾಡೋದು ನೀವು ಕೆಲಸ ಮಾಡೋದು ಬೇರೆ ಕಮಿಷನ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತದೆ ಗವರ್ಮೆಂಟ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತದೆ ಆಲ್ ಪೀಪಲ್ ಶುಡ್ ರೀಡ್ ವೈಲ್ ಅಟ್ ಲೀಸ್ಟ್ ವೈಲ್ ದೇ ಆರ್ ಆನ್ ದ ಲಂಚ್ ಟೇಬಲ್ ಎಸ್
ಅಭ್ಯರ್ಥಿ ಸಲ್ಲಿಸಿರುವ ಆನ್ಲೈನ್ ಅರ್ಜಿ ಮತ್ತು ಪ್ರವೇಶ ಪತ್ರದೊಂದಿಗೆ
ಫೇಸ್ ರೆಕಾಗ್ನಿಷನ್ ಡಾಟಾ ಪರಿಶೀಲಿಸಿ ತಾಳೆ ಮಾಡಲಾಗಿರುತ್ತದೆ.
ಸಂಸ್ಥೆಯವರು ನೀಡಿರುವ ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಪೇಜ್ನಲ್ಲಿ ಸದರಿ ಅಭ್ಯರ್ಥಿಯು ಹಾಜರಾಗಿರುವ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದ ಕೊಠಡಿಯ ಸಿಸಿ ಕ್ಯಾಮೆರಾ
ಫುಟೇಜ್ ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಎಲ್ಲಿ ಹೋಯ್ತು ನೆಕ್ಸ್ಟ್?
ಆದರೆ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದಲ್ಲಿ ಹಾಜರಿದ್ದ ವಿಡಿಯೋಗ್ರಾಫರ್ ಪ್ರತಿ ಕೊಠಡಿಯನ್ನು ವಿಡಿಯೋ ಮಾಡಿರುವ ಸದರಿ
ಅಭ್ಯರ್ಥಿಯು ಪರೀಕ್ಷೆ ಹಾಜರಾಗಿರುವ ಕೆಲವು ಸೆಕೆಂಡುಗಳ ಫೂಟೇಜ್ ಲಭ್ಯವಾಗಿರುತ್ತದೆ. ಪ್ಲೀಸ್ ಗೋ ಟು ನೆಕ್ಸ್ಟ್ ಒನ್. ನೆಕ್ಸ್ಟ್ ಈಸ್ ಮೋಸ್ಟ್ ಡೇಂಜರಸ್.
ಅಭ್ಯರ್ಥಿ ಸಲ್ಲಿಸಿರುವ ಆನ್ಲೈನ್
ಪ್ರಕಾಶ್ ಹೋದ್ರಿ
ಅಭ್ಯರ್ಥಿ ಸಲ್ಲಿಸಿರುವ ಆನ್ಲೈನ್ ಅರ್ಜಿ ಮತ್ತು ಪ್ರವೇಶ ಪತ್ರದೊಂದಿಗೆ ಫೇಸ್ ರೆಕಗ್ನಿಷನ್ ಡಾಟಾ ಪರಿಶೀಲಿಸಿ ತಾಳೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಸಂಸ್ಥೆಯವರು ನೀಡಿರುವ ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಫುಟೇಜ್ ಅನ್ನು ಪರಿಶೀಲಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದ ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಫುಟೇಜ್ ಬದಲಿಗೆ
ಶಿವಮೊಗ್ಗದ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದ ಫುಟೇಜ್ ಅನ್ನು ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ದಿಸ್ ಥಿಂಗ್ಸ್ ಕ್ಯಾನ್ ಹ್ಯಾಪನ್ ಓನ್ಲಿ ಇನ್ ಎಲಿಸ್ ಇನ್ ವಂಡರ್ಲ್ಯಾಂಡ್ ಅಂತ ಒಂದು ಬುಕ್ ಇತ್ತು ನಾವು
ಲಿವಿಸ್ ಕ್ಯಾರನ್
ಅಂತಲ್ಲಿ ಆಗ್ತಿತ್ತು ಇದೆಲ್ಲ. ಹೌ ಪೀಪಲ್ ಶುಡ್ ಬಿಲೀವ್ KPSC. ಆಲ್ ರೈಟ್ ನೆಕ್ಸ್ಟ್ ತೊಳಿ.
ಅಭ್ಯರ್ಥಿ ಸಲ್ಲಿಸಿರುವ ಆನ್ಲೈನ್ ಅರ್ಜಿ ಮತ್ತು ಪ್ರವೇಶ ಪತ್ರದೊಂದಿಗೆ ಫೇಸ್ ರೆಕಗ್ನಿಷನ್ ಡಾಟಾ ಪರಿಶೀಲಿಸಿ ತಾಳೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಸಂಸ್ಥೆಯವರು ನೀಡಿರುವ ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಫುಟೇಜ್ ಅನ್ನು ಪರಿಶೀಲಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಪರೀಕ್ಷಾ ಕೇಂದ್ರದ ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಫುಟೇಜ್ ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಹಾಜರಿದ್ದ ಸಂಸ್ಥೆಯ ಪ್ರತಿನಿಧಿಯನ್ನು ವಿಚಾರಿಸಲಾಗಿ ಸದರಿ ಪರೀಕ್ಷಾ ಕೇಂದ್ರವು ಯಾವುದೇ ಸಿಸಿ ಕ್ಯಾಮೆರಾವನ್ನು ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿರುವುದಿಲ್ಲ, ಬದಲಿಗೆ ಕಾಲೇಜಿನ ಕ್ಯಾಮೆರಾಗಳನ್ನು ಇಂಟಿಗ್ರೇಷನ್ ಮಾಡಿಕೊಂಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ, ಆದರೆ ಫುಟೇಜ್ ನೀಡಿರುವುದಿಲ್ಲ.
Why when committee is so much working, why did you send final select list to the government?
Please, that is
when third rate things were happening.
Please, it should not have been sent.
More than 3 times we have said now third rate things. Based upon record.
Based upon record.
Maybe
right,
fourth rate also.
Please.
When third rate things were happening in the KPSC, in the park house. Why you sent final select list to the government? At whose instance?
Lord's paratotal subcommittee
is going on. You have appointed 3-member committee. Secretary has said no things. These things have happened. Which you have also. You on 3/10/2023, see you held the meeting. On 10/10/23, you had sought for second meeting. On 28/11/23, you asked for the report from the secretary.
Please.
Secretary sent this report and you constituted the committee on 8/12/2023. 3 members committee. It's looking into the matter.
Please.
Whether allegations are true or not.
Please, members.
Why did you send final select list government.
Para 13 to 16, kindly see, my lords. The above subcommittee had two meetings.
16.
Para 13 in the oath, para 13.
But
The above subcommittee.
you
had-
are for the state.
I'm for the Public Service Commission.
You are for
I'm
the
appearing as
KPSC.
senior counsel for the.
Who is
public
for the state?
State.
All right, we'll come to you. Be
Please.
prepared. Yes.
The above subcommittee had two meetings on 13/12/2023, 20/12/23 respectively. When the inquiry was in progress, the then secretary so and so started acting against the interest of the commission, leading to serious confrontation. In view of the indifferent attitude of the secretary, the members of the subcommittee informed the chairperson about their non-willingness to participate in the meetings till the secretary obeys, implements the decision of the commission. As such,
What was that decision? What was this confrontation?
no, it's further. As such, no further meetings of the subcommittee were held till so and so. On the said date, the chairperson convened the meeting of the subcommittee, but the members informed their non-willingness to participate in the meeting due to non-compliance of the decision of the commission by the then secretary. However, the chairperson, vide her letter dated so and so addressed to the secretary, has impliedly permitted the secretary to publish the final select list subject to the decision of the subcommittee. 16 may kindly be seen. So and so, the then secretary, taking undue advantage of the situation, arranged.
No, why chairperson?
Please, my
Who
lord.
is the chairperson?
Lords, ಇಲ್ಲಿ ಅವರು ಶಾಂತ ಹೊಸ್ಮನಿ ಅಂತ.
Shanta Hosman.
Okay.
Chairperson of the.
The then subcommittee. Subsequently, committee was reconstituted, but as on that day, the subcommittee was of 3 members.
Even when proceedings are going on by 3-member committee,
Please.
he said send the final list.
Please, ಅದು annexure D ಅಲ್ಲಿ ಇದೆ, letter ಇದೆ ಸುಮ್.
Who, chairperson of the committee or chairperson of the KPSC?
ಇಲ್ಲ, chairperson of the, this is chairperson, why her letter? ಅಂದ್ರೆ it is of the committee.
Committee.
I'll just point out, no, that letter is at page 103. It is by of the committee, not of the commission.
But why commission? It is the commission who sends the final list.
ಹೌದು ಸುಮ್.
Why it sent ಅಂತ ಅದಕ್ಕೆ ಉತ್ತರ
ಇಲ್ಲ,
ಸಿಗ್ತಾ
para
ಇಲ್ಲ.
16, next para 16. Srimati so and so, the then secretary, taking undue advantage of the situation, arranged an illegal meeting of the commission on 31/1/24 without required quorum and
For
got approved the
publication.
agenda for publication of the final select list. The said meeting of the commission was conducted by excluding the chairman. Srimati Lata Kumari acted in haste and forwarded the final select list to the government for further action without getting approval of the commission. The chairman of the commission, vide a letter dated so and so addressed to the chief secretary, informed about the illegal actions taken by the secretary and requested to withhold the select list.
The said letter is set annexure
Annexure
E.
E.
Where is that letter E?
Annexure E, my lords, page number
105.
105. Ade book letter.
This letter was sent to chief secretary
Please, my lords, this letter was sent to the chief secretary
by
by the chairman of the commission,
commission.
not of the committee. 109. No, it's 109 last para.
ಆದ್ದರಿಂದ ಆಯೋಗದ ಕಾರ್ಯದರ್ಶಿಯವರು ಸರ್ಕಾರವು ರೂಪಿಸಿರುವ ನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಪೂರ್ಣ ಆಯೋಗದ ಅನುಮೋದನೆ ಪಡೆಯದೆ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಮತ್ತು ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಿರುವುದು ಅಕ್ಷಮ್ಯವಾಗಿರುತ್ತದೆ. ತನ್ಮೂಲಕ ಸರ್ಕಾರವನ್ನು ಅಗೌರವಿಸಿದಂತಾಗಿದೆ ಮತ್ತು ಸಾಂವಿಧಾನಿಕವಾಗಿ ರಚನೆಯಾಗಿರುವ ಆಯೋಗದ ಕಾರ್ಯನಿರ್ವಹಣೆಯನ್ನು ನಿರ್ಲಕ್ಷಿಸಿರುವುದು ಕೂಡ ಆಯೋಗದ ಸಂವಿಧಾನಿಕ ಹಕ್ಕಿಗೆ ಚ್ಯುತಿಯಾಗಿರುತ್ತದೆಂದಲ್ಲದೆ ಕಾರ್ಯದರ್ಶಿಯವರ ಕರ್ತವ್ಯ ಲೋಪವಾಗಿರುತ್ತದೆ. ಈ ಎಲ್ಲಾ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಆಯೋಗದ ಕಾರ್ಯದರ್ಶಿಯವರಾದ ಸೋನ್ಸೋ ಅವರ ವಿರುದ್ಧ ಸೂಕ್ತ ಶಿಸ್ತು ಕ್ರಮವನ್ನು ಕೈಗೊಳ್ಳುವಂತೆ ಹಾಗೂ ಅವರ ನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಪ್ರಕಟಿಸಿರುವ ವಿವಿಧ ಆಯ್ಕೆ ಪಟ್ಟಿಗಳು ಸಾಂವಿಧಾನಿಕ ಮಾನ್ಯತೆ ಹೊಂದಿರದ ಕಾರಣ ಅವುಗಳನ್ನು ತಿರಸ್ಕರಿಸಿ ನಿಯಮ ಪ್ರಕಾರ ಪೂರ್ಣ.
It is the chairman of KPSC.
Please.
At least one person has guts to say what should be done, what should not be done.
Please.
What chief secretary said? What the chief secretary said about to this letter?
Then, my lords, at para 18, there was a transfer that took place of Lata Kumari got transferred from the post of secretary.
She was removed.
She was removed and was replaced by, my lords, Mr. Rakesh Kumar. And at para 19, my lords, in the 32nd meeting of the commission, at page 10, resolved to reconsider the decision taken by the commission in the meeting on 6/2. Further resolved that the secretary shall inform the government of the decision to the commission. Thereafter, my lords, formally, my lords, the secretary writes on 22/2/24 requesting to withhold the select list.
What chief secretary said? Chief secretary idnella ತಿಳಿಸಿದ್ರಲ್ಲ?
Please, my lords.
What he said? what he told the government.
Governor. That's not forthcoming in this report.
You have to produce
We-
that.
We'll produce, we'll get it, I'll get it.
At 2:30, bring that.
My lord, may, further submission. Lata Kumari also wrote a letter to the governor. How, my lord, the irregularity occurred among the members. That letter may be also produced. Immediately she is removed.
ಅದೆಲ್ಲ
When she
ಇದ್ದಿದ್ದು
complained.
ಏನೇನಿದೆ ಎಲ್ಲ ತಗೊಂಡು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 2:30.
And she complained, she is removed.
Why the final select list was sent? It remains as a riddle.
Please, my lord. And today we are-
mystery inside. It's very enigmatic. Number one.
The recital, all objections are considered and
Finally, it is published.
My lord, your lordship, I just put a small question to ask, sorry. What exactly the allegation in this case? OMR has been up more beyond the hero search. That is the allegation. The examination was held in July 2023. They are in the custody of OMR paper. After the appointment, my lord, the next merited candidate must have gone to the member, that is how, my lord, this whole things propped up. My lord, yesterday, the subject was placed before the assembly. The government felt this kind of public service commission functioning, selecting, again holding this kind of inquiry was totally criticized. I only appeal to a lordship, my lord.
We are finding justification for holding inquiry.
I'm grateful to a lord.
Yes.
But
What exactly the truth?
it's already one, my lords. It might be too short to get some information. Tomorrow, my lords.
Call tomorrow for further hearing.
Please, grateful. my lords.
Yes. ನೋಡಿ
I'll
KPSC, UPSC, ಅವು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಸ್ಟೇಟಸ್ ಅನ್ನು ಬಾಬಾ ಸಾಹೇಬ್ರು ಯಾಕೆ ಕೊಟ್ಟರು ಅನ್ನೋದು ಸ್ವಲ್ಪ ನೋಡ್ಕೊಳ್ಳಿ. ಅವರು ದೇ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ದ ಎಕ್ಸಿಕ್ಯೂಟಿವ್. ಅಲ್ಲಿ ಬರುವಂತವ್ರು ಕಾಂಪಿಟೆಂಟ್ ಜನ ಬರಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಅಂಬೇಡ್ಕರ್ ಜಿ ಸೆಡ್ ದೇ ಶುಡ್ ಬಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಬಾಡೀಸ್. ಅವ್ರು ಸೆಲೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ನಮ್ಮನ್ನು ಯಾರು ಆಳ್ಬೇಕು ಅನ್ನೋದು. ಬರೇ ನಮ್ಮ ಚುನಾಯಿತ ವ್ಯಕ್ತಿಗಳು ಅಥವಾ ಅಭ್ಯರ್ಥಿಗಳಲ್ಲ. ಅವ್ರ ಜೊತೆ ಎಷ್ಟಿರ್ತದೆ ನಮ್ಮ ಇಂಟ್ರಾಕ್ಷನ್. ಇಲೆಕ್ಷನ್ ಟೈಮ್ನಾಗ ವೋಟ್ ಹಾಕೋದು ಅಂದ್ಬಿಟ್ರೆ ಬೇರೆ ಆಮೇಲೆ ನಾವು ಎಷ್ಟು ಜನ ಮಾತಾಡ್ತೇವೆ ಅವ್ರ ಜೊತೆ. ಆನ್ ದ ಅದರ್ ಹ್ಯಾಂಡ್ ಯಾವುದೇ ಕಾಮನ್ ಮ್ಯಾನ್ ಅವ್ನಿಗೆ ಏನೇ ಗ್ರೀವನ್ಸ್ ಇದ್ರು ಆಫೀಸರ್ ಸತಿಗೆ ಹೋಗ್ತಾನ. ಇಂಥವ್ರು ನೀವು ಈ ರೀತಿ ಇಷ್ಟೆಲ್ಲ ಹೊಲಸಿದ್ದಾಗ ಆ ರೀತಿ ಮಾಡಿಬಿಟ್ರೆ ಜನರ ಕಾನ್ಫಿಡೆನ್ಸ್ ಹೆಂಗಾಗ್ತದೆ? ಯಾರಪ್ಪ ಹಂಗಾರೆ ನಮ್ಮ ನಾಳೋರು ಬ್ರಿಟಿಷ್ ರಾಜ್ ವಾಸ್ ಗುಡ್ ಬೆಟರ್ ಅನ್ನೋ ಫೀಲಿಂಗ್ ಬರಬಾರ್ದು ನಾವು.
And all these candidates are rank holders, they are distinguished in civil engineering.
ನೋಡೋಣ.
But kindly see, out of 27, 1 minute, out of 27 lot, only 11 OMR they quote.
ಒಂದೇನು ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ 3-member committee is looking into the complaint.
not have been sent. Totally. As an officer of the court, I can say that it could not have been sent.
ಹಂಗೆ ಈ
And
ರೀತಿ
send-
ಆಯ್ತು ಅಂದ್ರೆ
now you send
ಕಂಪ್ಲೇಂಟ್ ಇದ್ದಾಗ ನೋಡಿ ಅದು ನಿಜಾನೋ ಹೌದಲ್ಲ ಅಂತ. ಅದು ನಿಜ ಹೌದಾ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ವಿ ಡೋಂಟ್ ನೋ. ಈಗಿನ
But till it
ದಿವಸದಲ್ಲಿ
is
ಎಲ್ಲಾರ
decided-
ಮೇಲೆ ಎಲ್ಲ ನಮ್ನಿ ಕಂಪ್ಲೇಂಟ್ ಬರ್ತಾವ.
Please, but
ಹೌದಾ?
till it is
La
adjudicated.
complaint for
ಅದರ್ ಥಿಂಗ್. ಬಟ್ ಈ ರೀತಿ ಕಮಿಟಿ ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಡಿಸ್ಕಷನ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ. ಅದರ್ಥ ಪ್ರೈಮಾ ಫೇಸಿ ದೇರ್ ಇಸ್ ಸಮಥಿಂಗ್ ವಿಚ್ ಶುಡ್ ಬಿ ಲುಕ್ಡ್ ಇನ್ ಟು ಅನ್ನೋದಕ್ಕೆ ಕಮಿಟಿ ಮಾಡಿದ್ದು. 3-member committee is looking into all these things. ಏನು ಅಷ್ಟು ಅವಸರದಲ್ಲಿ ಹಂಗೆ ಅದನ್ನ ಕಳಿಸಿ ಮಾಡುವಂಥದ್ದು ಏನಿದೆ? ಹೇಸ್ಟ್ ಜನರೇಟ್ಸ್ ಡೌಟ್. ಹೇಟ್ಸ್ 2 judgments ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ. ತುಂಬಾ ಹೇಸ್ಟಿಯಾಗಿ ಯಾವ್ದಾದ್ರು ಗವರ್ಮೆಂಟಲ್ ಬಾಡಿ ಫಂಕ್ಷನ್ ಮಾಡ್ತು ಅಂದ್ರೆ ಎ ಸ್ಟ್ರಾಂಗ್ ಪ್ರಿಸಂಪ್ಷನ್ ಅರೈಸಸ್ ಆಫ್ ಕರಪ್ಷನ್ ಅಂತ ಹೇಳಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೆಡ್. ಹಂಗಾಗಿ ಇದನ್ನಿಷ್ಟಕ್ಕೆ ಬಿಡಲ್ಲ ನಾವು.
It's in fact, apart from what is put in black and white in this report, I'll also try to get other information to assist.
ಎಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್
ನಾನು ತಗೊಂಡ್ಬರ್ತೀನಿ. ಅಲ್ಲ ಔಟ್ ಆಫ್ 27 ಅಲ್ಲಿ 11 ಜನ ಮಾತ್ರ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ 21 ಜನ OMR ತರ್ತಾರೆ, FSL ರಿಪೋರ್ಟ್ ಅವ್ರು ಕನ್ವೀನಿಯಂಟ್ ತರ್ತಾರೆ. ಏನಂತ ಏನು ಇಲ್ಲ ಅಂತ ತರ್ಸ್ಬಿಟ್ಟು.
We don't know. We only feel bad. We feel bad. ನಾವು ಓವರ್ ಸ್ಟೆಪ್ ಮಾಡಬಾರ್ದು ಜುಡಿಷಿಯರಿ ಅವರು. ಆದ್ರೆ ಓವರ್ ಸ್ಟೆಪ್ ಮಾಡುವಂತ ಕಾಲ ಬಂದಿದೆ ಈಗ. ಬಂದಿದೆ. ಅದರ್ವೈಸ್ ಮಾಡು ನಾಳೆ ಹೆಂಗಿದೆ ಸೆಟ್ರೈಟ್ ಮಾಡೋದು. ಜನರಿಗೆ ಕಾನ್ಫಿಡೆನ್ಸ್ ಇರೋದು, ಅತಿ ಹೆಚ್ಚು ಕಾನ್ಫಿಡೆನ್ಸ್ ಇರೋದು ನಮ್ಮ ಮೇಲೆ ಈಗ. ಹಂಗಾಗಿ ನಮ್ಮ ಮೇಲೆ ಹೆಚ್ಚಿನ ಜವಾಬ್ದಾರಿ ಇದೆ. ನೀವು ಅದನ್ನ ಸರಿ ಆ ಹೌಸ್ ಅನ್ನು ಸರಿ ಮಾಡ್ತಿರೋ ಇಲ್ಲೋ ಅನ್ನೋದನ್ನ ನಾಳೆ ನಮ್ಗೆ ಹೇಳ್ಬೇಕು. ಈ ರೀತಿ ಆಗ್ಲಿಕ್ಕೆ ನಾವು ಬಿಡಲ್ಲ. ಅದೇ ಕಮ್ ವಾಟ್ ಮೇ we will pass we will write the judgment with a pen dipped in acid. Understand this first, please. If this is not the way things should go on, people are losing faith.
Entry model.
ಏನ್ ನಡೆದಿದೆ ಅಂತ ಅದು ಚರ್ಚಿಲ್ ಸೈಡ್. ಇಟ್ ರಿಮೈಂಡ್ಸ್ ಮೀ as a student of history, ನಮ್ಗೆ ಫ್ರೀಡಮ್ ಕೊಟ್ರೆ ಏನಾಗ್ತದೆ ಅನ್ಕೊಂಡು ಚರ್ಚಿಲ್ ಹ್ಯಾಡ್ ಸೆಡ್, if freedom is given to India, this was the opposition leader, he addressed Clement Attlee, the Prime Minister of England at that time. He said, the power will go into the hands of rascals, rogues and freebooters. ಯಾವ words ಹೇಳೋಣ?
This was my lord.
Elections and corruptions will make India a hell of a country. I'm just reproducing.
My lord was telling this as an advocate also, I heard.
ಹೌದು, ನಾಳೆ ಹೆಂಗೆ ಈ ರೀತಿ ಆಗ್ಬಿಟ್ರೆ ಮುಂದೆ ಜನ ನಂಬೋದು, ಜನರ ಗತಿ ಏನು? ಕಾಮನ್ ಮ್ಯಾನ್ ಗತಿ ಏನು? ಎಲ್ಲ ಸಬ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಜನರನ್ನ ನೀವು ಅಫಿಷಿಯಲ್ಸ್ ಮಾಡಿ ಇಟ್ಬಿಟ್ರೆ ಜನರ ಗತಿ ಏನು? ದೇ ಸ್ಟಾರ್ಟ್ ರೆಮಿನಿಸೆನ್ಸ್ ಆಫ್ ಬ್ರಿಟಿಷ್ ಎಂಪೈರ್, ಬ್ರಿಟಿಷ್ ರಾಜ್.
Entry model.
एक बार पता कर लो कि क्या क्लैरिफिकेशन का क्या मतलब है। बट एक बात बताओ, कैन दे डू दिस? ईडी ने तो अपने रिटन सबमिशंस फाइल ही नहीं करे होंगे मेरे हिसाब से। बिना ईडी को सुने, बिना बिना हमें सुने, हाउ कैन दे, मतलब मेरे हिसाब से दे कांट रिजर्व इट लाइक दैट। बट जस्ट आई मतलब क्लैरिफाई फ्रॉम द थिंग दैट प्लीज एक बार मुझे वो ऑर्डर बता दीजिए क्या एग्जैक्टली हुआ है, समझ नहीं आया हमें ऑर्डर में। आप बस पढ़ के सुना दीजिए क्या है ऑर्डर, ताकि वी कैन मेक सेंस ऑफ इट। ठीक है। हम्म।
फोटो मुझे विटनेस करती होगी, मेरे से छुट्टी आप हरकतें करती थी आफ्टर 1 ईयर। छुट्टी आप गलतियाँ मतलब कई की जगह पर तो मैं करती थी गलतियाँ पटाख। वो हावर्ड था उसमें वैसे भी मैं से छुट्टी आपकी तरह गलतियाँ करते थे।
अरे इसको तो आता ही नहीं, गलतियाँ की क्या बात कर रही है, मैं बेसिक चीजें नहीं आती इसको, मुझे कैसे
मैं अपनी बात कर रही हूँ। अगर मैं करती हूँ
देख सभी करते हैं गलतियां यार, मतलब सीखने के बाद तो फिर जब तो सीखता है इंसान। तो सबको
आगे है रात को तो नहीं जाना था मेरे को। वरना वॉक करते मुझे एहसास है चक्कर आ जाएंगे अब। यार कुछ ज्यादा ही गंदे खा रही हूँ, तू तो मेरे से भी ज्यादा खा रही है। चल मैं सिर्फ ऑफिस ऑफिस में खाती, घर नहीं खाती। सब जगह ही गंद गंद। मन कर रहा है कुछ वो करने का, ठंडा ठंडा खाने का। कुछ ये है, लोग है ना बहुत आजकल वो ले यूज कर रहे हैं दिस थिंग। आई नो क्या रोलर्स ऐसा, जैसे ये ऐसे रोलर यूज कर रहे हैं ना बिल्ली ऐसा।
हाँ ये अच्छा अच्छे चल रहा है, ब्रश मैंने भी देखा, वॉल्यूम वॉल्यूम
वॉल्यूम ऑफ कर रहा हूँ यार ऐसा।
बट मैंने कर्ली वाले हैं ब्रो, ये सब पता, कर्ली वालों के लिए कहाँ जाएगा ये।
मेरी लड़की मुझे बहुत सुंदर लगती है।
Took adjournment, but bench was not there. We took adjournment from the court. Like,
I was seeing it, I was walking through, I was seeing it immediately, they stood up to the left while and they left. This one, I was seeing it in the YouTube, right, because I didn't know if I was supposed to join through you and then.
if you want to argue or you're partying person or an advocate, then you can join.
Yeah, so those things, I was like, I just see it in this live, and I just took a break while they all left.
No, they took a break at that time.
I
Then they came back. Then they rose at 1:30.
So,
Also came, no?
to log in on this.
He only was logged in. No, we knew. We saw Ravi Raghavan's name, so we knew we should be normal.
That's what I'm saying. Why are you logged in?
Huh?
Why are you logged in? You're not doing it.
See, for adjournment, we have told the court clerk, not the bench. So the department counsel should come and ask for it. Waiting for them.
You want to vote for?
For this matter only. So there only they told the department counsel to come, we won't be able to do it. waited there, wasted time, unnecessarily wasted time. It's so much work. I was thinking I brought my laptop also. I was thinking I'll just start drafting there, but I couldn't find. I couldn't find any place.
But High Court doesn't have proper unlimited funds for even the signal as
Signal is there. Just drafting. So
Wait, what is it? A1.
ಆನ್ ಆಯ್ತಾ ಆನ್ ಮಾಡ್ರಿ ಬರೋ ಟೈಮ್ ಅಲ್ಲ ಅವ್ರು ಬಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ
ಬಂದ ತಕ್ಷಣ ಅಲ್ಲೇ ಅವರು
ಸರಿ ಹ್ಮ್ Yes. Namaste, brother. Namaste, brother. Yes, come. Huh. ಇದನ್ನ ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟ್ ಹೆಡ್ ಮಾಡಿ ಹೆಂಗಿದ್ರೆ ಎನಿವೇ bench headed by me, it will come before me only. Brother, we'll release it from part head because you are, Yes, ma'am. very difficult for you to come all the way. Yes, ma'am. ಮಾಡ್ಬೋದಾ? Yes, ma'am. Okay. Release from, since one of the benchmates is away in Dharwad bench, comma, and it is difficult for him to travel to Bangalore bench during the tenure in question, comma. All these cases are all these cases are released from part head so that they are posted before the roster bench. Okay. All right. Sorry, we wasted your time. Perhaps it happens. No. Please, brother. That's what. Okay. Yes. Yes.
Bylaws in item number 11.
Ah.
Is that being taken up?
Yes.
Bylaws appearing for the respondent.
Yes.
Arguing counsel Mr. Nageshwar Rao is arguing a stay granted matter. So requesting for a passover, my lords.
80 days delay.
Madam, allowed delay control.
My lords, request you to grant us some time so that we can file objections to the condonation application by the department.
Request for filing objections is rejected. Yes, next.
Right, ma'am.
My lords, 12.1, my lords, has been admitted. But 12, my lords, there's a delay of 353 days, my lords. Issue of transfer pricing. Transfer pricing. Yes, my lords. 12.1, my lords, has been admitted, my lords. Let's call it. The companion appeal in ITA 701 of 2023 is already admitted by the coordinate bench. Dated, my lord, 19th of 19 to 2025. First off, therefore, this appeal, that is ITA 499 of 2023, also needs to be. Delay ಇದೆಯಲ್ಲ 353 days. ಮತ್ತದ್ ಹೇಳ್ದಂಗೆನೆ. May I request you control, my lords? ಏನು 353 days ಏನು ಪುಕಟೆ ಕಂಡೋನ್ ಮಾಡಲ್ಲ. No, my lords, I'm not. ಹೇಳಿ ಏನು? Any books, my lord, my lordship will say, my lords. ಇದನ್ನ ಕೊಡಿ. Professor P. Ishwar Bhatt ಅವ್ರದ್ದು Law in a Changing Society. Yes, my lord. He has written it in contrast with the Wolfgang Friedman's Law and Social Change. ಅದನ್ನ ಕಣ್ ಮುಂದೆ ಇಟ್ಕೊಂಡು ಇಂಡಿಯನ್ ಸೊಸೈಟಿ ಬೇಕಂಗ್ ಬರೆದ. He was Vice Chancellor of Law University. All right? Yes, my lord. One book. No, delay. Condu. There is delay of format ಮಾಡ್ತೀರಾ? Okay. Condu. Yes, next. Appeal admitted. ಮೊದಲು ಮಾಡಿರ್ತಿತ್ತಲ್ಲ ಇದು ಮಾಡ್ಕೊಂಡು. Okay. Next. The delay of 132 days, my lords. Issue of transfer pricing, my lords. No, delay condoned. Format. Appeal admitted on the following substantial questions of law. I'll note. Kalagade. Okay. No, this matter, my lords, must be connected to for the three other matters, my lords. 107, 108, 109, my lords. I'll just give it. All this matter along with. Yes.
This matter, appellate has prepared a order also by the appellate tribunal, page number 15. Whoever this petitioner has filed appeal before the appellate tribunal. Appellate along with waiver of pre-deposit, the honorable appellate tribunal is reject my main appeal and along with waiver of pre-deposit, both application is rejected on the ground that mandatory requirement under section 129E of the Act.
Read.
Customs Act.
Read.
Please.
Buddy. Because it's covered by judgment of Dr. Vijay Mallya versus State Bank of India, right? Where we have taken the view, where appeal is conditioned. Unless condition is complied with, no right of appeal.
Malad, statutory appeal, it is a right of the appellants, Malad.
Correct.
But then.
Vijay Mallya is affirmed by the Supreme Court. Brother,
Please.
all through,
Please.
right of appeal is creature of law. It is created by law.
Please.
Except in two cases where Supreme Court created right of appeal by judgment is another thing. Where legislature creates right of appeal.
Please.
it can create it subject to conditions.
Yes, my lord.
Where conditions are stipulated for exercising the right, your right to appeal is contingent upon conditions being fulfilled. That's how we have held. That is affirmed by the apex court.
My lord, may I make insult? My lord, as this section is substituted in the year on 6/8/2014, my lord.
Our section, huh?
Please, my lord, 129E of the Customs Act, my lord.
Idu yav year idu?
That is occurrence in the year 2012, my lord. Lease, Honorable Apex Court says that. May I suggest?
Power is here to condone, without making payment, we will entertain.
Yes, my lord, in this case, Honorable Apex Court says the lease starts from the show cause notice when is occurrence. Kindly take para number 33, my lord.
33.
Please, my lord, last page, my lord. May I read?
Lists in the sense explained above arose before the date of amendment of section. Further, even if the list is to be taken as arising only on the date of assessment, there is a possibility of such a list arising as soon as proceedings started with the subsequent law amend admele enanta ide. Why are you reading this?
My lord, lease started from the date of, there's a container seized on 23/10/2012. Occurrence. Show cause notice issued on 9/4/2013, my lord. Prior to this amendment, there is substitution of this section.
You mean to say amendment is prospective in operation?
Prospective of operation.
Yenanta ide amendment?
My lord, as per Honorable Ernakulam
By
Court,
substitution adu.
a substitution.
Substitution either it goes to the date of incorporation.
Yes, my lord.
ಅದಕ್ಕೆ ನಿಮ್ದಕ್ಕೂ ಅಪ್ಲೈ ಆಗತ್ತೆ. ಡೇಟ್ ಆಫ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ ಗೆ ಹೋಗ್ತದೆ. ಅಟ್ ಲೀಸ್ಟ್ ಆ ಸೆಕ್ಷನ್ ಯಾವತ್ತಾಗಿತ್ತು ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ.
Honorable Ernakulam Court, Honorable High Court of Ernakulam and other court, Bombay Court consider
Identical question.
identical question.
Notice told.
Please, my lord.
Issue emergent notice. ಯಾರು ಬರ್ತಾರೆ ಅಪೋನೆಂಟ್?
My lord, Madhu and Rao, my lord.
Madhu M. Rahul.
Rao. Madhu and
M.
Rao.
Rao.
Madhu and Rao.
Issue emergent notice. Panel counsel Sri Madhu M. Rao is requested.
N, my lord.
Madhu N. Rao is requested to accept notice for official respondents. Petitioner to appellant to serve a copy of the appeal memo along with all the documents on the said panel counsel and file acknowledgement in the registry within 1 week, failing which appeal stands rejected.
Much obliged.
Yes.
Your Lordship, I'm appearing for the respondent in item
Yes.
16. Your Lordship, this is an appeal by the department arising out of the penalty proceedings. But Your Lordship, in this case, what had happened was that the Honorable ITAT had deleted the quantum addition, pursuant to which the department had filed an appeal before the Honorable Dharwar bench, and the Honorable Dharwar bench had allowed the department's appeal. Now, in this case, Your Lordship, the quantum addition was only deleted on a technical ground that the search was not valid.
You are
And
for
the
appellant?
Honorable No, Your
Yeah.
Lordship, I am
Then
for
you
the
have to wait.
respondent.
You should allow the appellant to argue.
I just have one submission to make, Your Lordship. My only submission is that since there are some review petitions which we had filed against the quantum addition proceedings, those are still pending, Your Lordship. So these penalty proceedings may be deferred till then, Your Lordship, these appeals. And in fact, Your Lordship had recorded in one order as well.
I think
Review
the
petition
review
pending.
petitions were also dismissed, my lord.
Review petition
Your-
dismissed.
No, Your Lordship, they were, Your Lordship, actually the counsel who had filed the review petitions, he was later designated as a senior standing counsel, because of which he could not pursue those review petitions. And then those review petitions were dismissed for non-prosecution. And we had then moved the recall application and all those review petitions. Those recall applications are pending, Your Lordship.
Restored now.
Not restored, Your Lordship.
But
It
IAS
has not yet been taken up. Those applications are pending.
All right. call this, we'll give you 3 weeks. Within that, you should have some order on restoration.
Yes, Your Lordship, we are pursuing those applications, Your Lordship.
All right. Call after 3 weeks.
Obliged, Your Lordship.
Wait for short time, Your Lordship.
All right, 2 weeks.
Any specific date will be given, Your Lordship?
Why specific date?
Council from outstation.
Outstation. Other one date. Good. Yes. Call on 25 at the request of. Yes.
My lord, the issue involves, my lord, whenever a depreciable asset is sold, my lord, the income, the difference in cost and improvement and the sale price has to be offered for tax.
ಸ್ವಲ್ಪ ಎಲಾಬರೇಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು.
An asset, my lord, which is depreciable or which is
ಕಾರ್ ಒಂದು illustration ಕಾರ್ ಇದೆಯಪ್ಪ.
car ಇದೆ. So if that is sold, my lord, and if there is a profit, income arising, that has to be offered for tax. The section says, my lord, special provision for computation of capital gains in respect of depreciable assets. Here in this case, land and buildings were sold. And my lord, they were not subjected to tax. That is the issue. The finding of the assessing officer is, it was shown as an asset in the block of assets in the balance sheet. And my lord, it should have been offered for when it was sold, it should have been offered for tax.
Yes.
And the contention of the SSC is no depreciation had been claimed. That is a finding of the tribunal also.
In other words, section which provides for charging is not attracted unless depreciation benefit is claimed.
The language
That's
used is,
the point.
the language used is, my lord, special provision for computation of capital gains
Padi.
in case of depreciable assets.
Padi. This is a depreciable asset ಆಗತ್ತಾ?
A building is a
ಅದಕ್ಕೆ
depreciable.
depreciable asset ಅಂದ್ರೆ ಏನು ಅಂತ? Kindly have mic. Many students, interns will be eager to hear you.
My lords,
We are also.
grateful, my lords. My lords, the income tax provides for taxation of capital gains on transfer of a capital asset.
Correct.
Typically, my lords, capital assets are not the ones which are held in business. They are held for captive use or in anticipation of appreciation. And they are subject to tax at concessional rates, particularly if the asset is a long-term capital asset. However, my lord, section 50 of the Income Tax Act, section 50 of the Income Tax Act provides an exception to it. What it says is, if an asset is forming part of a block of assets in respect of which depreciation is allowed, my lords may most kindly appreciate, it has to form part of a block of assets in which the depreciation is allowed, then, my lords, the normal computation as long-term capital gain, etc., would not happen. Instead,
Special provision
where, my lords, the resultant balance would be regarded as short-term capital gain and be charged to tax at a higher rate, or the normal rate.
ಒಂದು illustration ಕೊಡಿ.
I'll give, my lords. Take, my lords, the case of a car. My lords, car, if used in business, would be eligible for depreciation. And it will belong to a block of assets called plant and machinery, where, my lords, individual assets would not have identity. Several assets of the same
Together will have
same
common
block.
identity.
Section 2 brackets 11 of the Income Tax Act defines what a block of assets means, is that the assets being building, plant, machinery, furniture are intangible, in respect of which same rate of depreciation is prescribed, would be bunched into one block. And, my lords, the assessee would
Block is a basket.
It's a basket. It's a basket. And, my lords, assessee would be entitled to depreciation in respect of block as a whole, where individual assets identity is lost. It is more recognized as a
The
block.
basket itself is charged.
Exactly. Basket itself, no, basket itself would be subject to depreciation.
Correct.
Then, my lords, what would happen? What would section 50 provide is, if one or more of the assets in that block get sold, for example, in my business, let us say, my lords, I have 6 cars. All 6 cars are put into one block. If a car is added, it will get added. If a car is sold, then it will be, the sale value will be reduced from the block and the written down value will be determined at the end of the year. What is the written down value? Written down value at the beginning of the year. Any new cars added during the year, any old cars sold during the year, minus the depreciation allowed in respect of that would give rise to WDV for the next year. This is how it operates. Now, what section 50 provides is, if a car is sold, that would be reduced from the block. If the block still remains positive,
Suppose A, B, C, D, 4 items are there.
4 cars are there.
Yeah.
Car 1, car 2, car
A
3.
is sold.
My lords, I'll give an example.
Yeah.
There are 4 cars, car 1, car 2, car 3, car 4. Let us say, my lords, the WDV is 10 lakhs for all cars together.
Collective.
One car is sold, no other movement takes place. This car is sold for 3 lakhs. Then what would happen, my lords? From 10 lakhs minus 3 lakhs, balance will be 7 lakhs. There is still a positive balance in the WDV. They give me depreciation on that 7 lakhs at 15%. Now, at times it may so happen that, my lords, there may be 3 or 4 cars or 4 cars in my lord's example. Let us say I sell 2 or 3 or 1 car for a price which is more than 10 lakh, whereby my block will turn negative. Let us say I have sold 1 car for 12 lakhs. There are still 3 more cars, but the WDV is only 10 lakhs. I've sold 1 car for 12 lakhs. This turns my block into negative to the extent of 2 lakhs. That will be charged to tax as short-term capital gains.
Okay.
Is the scheme of section 50.
Okay.
In the instant case, my lords, the point for consideration is there is a land of 9,600 square feet on which no depreciation has been claimed at all. Land assets is not an asset eligible for depreciation. On that land, there
It is not a depreciable asset at all.
under
Is
the
your-
Income Tax Act.
And-
Economic depreciation, appreciation may be there.
There, but in the special provision, it does not
Under
have.
the Income Tax Act, in terms of section 2 within brackets 11, read with section 32(1), no depreciation is allowed on land. Only machinery, building, plant, furniture, and my lords, the intangible assets are the only assets which are eligible for the depreciation. The undisputed fact here is a large chunk of land of 9,600 square feet where there is a small dilapidated structure of 38 square feet, which is just, my lords, 38 square feet, on which depreciation has not been claimed at all. The learned tribunal returned a finding of fact, which has not been disturbed and disputed, that no depreciation has been claimed. When no depreciation has been claimed at all, the question of WDV and the block movements would not arise. The question of application of section 50 would not arise. This
So-
would require my lord to take a look at section 50 for a while, which my lords will find it at page 1.457.
1.457.
Page 1.457.
Ah,
Lords, it starts with the word special
Notwithstanding.
provision for computation of capital gains in the case of depreciable assets. My lords, most kindly notice this,
Correct.
depreciable assets.
yes.
Notwithstanding anything contained in clause 42F section 2, which will define what a long-term capital asset, what a short-term capital asset is concerned. Where the capital asset is an asset forming part of a block of assets in respect of which depreciation has been allowed. This is extremely important.
Unless this happens,
Unless this jurisdictional.
section is not attracted.
Exactly. That's all, my lords.
You-
Tribunal has
It did not, in other words, that no, you had not claimed depreciation in respect of this particular property
all.
at all.
at all. There is no.
Claim Allah. Not only not claiming, you should have claimed and granted.
Have been allowed. That has never been the case. Therefore, my lords, the learned tribunal
true?
rightly held,
Factually true. Then how are you invoking section 50?
it cannot be.
Section 50 has the building blocks. One of the building blocks is the depreciation has been allowed.
Exactly.
Unless that happens, section is not attracted.
But there is one judgment, my lord, which of the apex court, my lord, which says,
What it says.
if it forms part of the block assets, my lord,
Even
It's-
if depreciation is not allowed,
No,
if
Still-
it is not claimed.
no, no.
not claimed. No, that makes no sense.
I'll explain this.
Blame,
my lord.
see, apex court was going another extreme. Not allowed there. Adake I immediately I said, claimed, not claimed means in the light of this section, not allowed anta. ಅಷ್ಟೇ ಕ್ಲೇಮೇ ಮಾಡಿದಾಗ ಅಲೋ ಮಾಡೋ ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬಂತು? Not even claimed. Where is the question of allowing ಅನ್ನೋ ಅರ್ಥ? ಯಾವ paragraph? Let us, is it so construed? Section is so construed. Just show that.
My lord, para 2.
Para 2. In other words,
In other words, in a view, the building which was acquired by the SSC in 1974 and in respect of which
depreciation
was allowed to the business for 21 years, that is up to the assessment year 95-96, still continue to be the part of the business and depreciable asset. No matter the non-user disentitles the asset for depreciation for 2 years prior to the date of sale. So prior to the date of sale, no depreciation was claimed for 2 years.
Correct. Where is the depreciation? No, we are asking simple question to you. Apex court has not read down this section at all. In special fact matrix, it might have decided the case in this way or that way is another thing. Section is so clear. To invoke this section, I'm saddle a person with some liability. The building ingredients have to be satisfied.
My lord, further, my lord, down there, just, my lord, we do not know how a depreciable asset forming part of a block of assets within the meaning of section 211 of the Act can cease to be a part of block of assets. The depreciation of the asset by the SSC in the balance sheet,
As an investment
description
asset,
of the asset by the SSC in the balance sheet as an investment asset, in our view, is meaningless. And it is only to avoid payment of tax of short-term capital gains is on the sale of the building. That is the facts of that case, my lord. But so long as the SSC continued the business, the building forming part of the block of assets, it will retain its character as such, and no matter one of the two of the assets in 1 or 2 years, instead of selling the building, if the SSC started using the building after 2 years for the business purpose, the SSC can continue to claim the depreciation based on the written down value available as on the date of ending of the previous year in which depreciation has to be allowed last. That means, my lord, if it is in the character of a depreciable asset,
it should be in the character of depreciable asset is one thing. Depreciation should have been allowed is another thing. Question of allowing depreciation arises only when the asset is depreciable. Otherwise not. What he says is, when it is put into that block period, the kind of depreciation which you are speaking, it is alien to that tanta.
May I explain, my lord?
Yes.
In this decision, the factual matrix is totally different. In this decision, what happened was, assessee,
Bought the flat in 74.
assessee in this case.
In
had-
your case,
No,
or in this case.
I'll explain the
Yes.
decision.
He bought that flat in 1974.
May I explain this, my lord?
Yes.
In this case, the assessee used this building for the purpose of its business, claimed depreciation,
Therefore, section is attracted.
and thereafter, he stopped using it for the business, stopped claiming depreciation. Point before the Honorable Kerala High Court, against which assessee went before the Honorable Supreme Court, was whether once it would enter into block, in terms of what my lord said, depreciation was once allowed, would it stay eternally in the block or would it exit? Assessee was claiming that once I stop claiming depreciation, section 50 would not apply. What the apex court, upholding the decision of Honorable Kerala High Court, said is that once it enters the block on which the depreciation was once claimed, it would always, in the instant case, from day one, the depreciation are not claimed. Therefore, the decision would not apply.
Difference.
My lords may kindly read para 2 starting words. That would answer my lord's question. In other words, in our view, the building which was acquired by the SSC in 1974 and in respect of which the depreciation was allowed to it, that was never the case. If I had claimed the depreciation even 1 year, going
Sufficient.
by sufficient, I would have been stuck with this
It does
section.
not say perennially the claim should have been made for depreciation.
That's all.
Once it is subjected to
Which is
depreciation.
never the case in the instant.
Section 50 is attracted.
In the instant case, the asset was acquired in 2005, same value is being shown, no depreciation is ever claimed and allowed. Therefore,
But,
my lord, section 50 should not.
Appeal is dismissed on the ground that the subject asset never suffered depreciation, which is one of the requirements of section 50, as rightly contended by learned senior advocate Mr. Chaitanya. First, whether the asset was subjected to depreciation, comma, there is no dispute that it was not. First, this is how impugned order of the tribunal is structured. First, in view of the above, appeal is liable to be dismissed and accordingly it is. One sentence very big. The heavy reliance by the learned senior panel counsel appearing for the revenue on Sakti Metal Depot versus Commissioner of Income Tax 2021 130 taxman.com 238 SC does not come to his aid in as much as at paragraph 2 in the reproduction, comma, the first line itself says that in that case, the flat in question has undergone depreciation. First off, it hardly needs to be stated that there need not be perennial claim for depreciation. First off, one single incident of allowing depreciation makes a section attracted. Next one, that being the position, the ratio does not come to the aid of assessee. Okay. Next. Okay. In one case, customs in the. Yes. Revenue, sir. Does not come
This,
in the,
this,
to the aid of revenue. Okay.
my lord, this matter,
Ha.
the issue relates to, my lord, section 56 to 7B, which says, my lord, if the consideration for issue of shares, in simple words, my lord, if the shares are issued at a premium, certain companies, if the shares are issued, for example, if 10 rupees shares is issued for 100 rupees, that 90 rupee premium should be off, it would be subjected to tax. It should be that
Treated as
premium amount has to be offered for tax.
Okay.
My lord, in the present case, my lord,
How one will ascertain that? How to ascertain that actually?
There are two methods, my lord.
Ah.
The discounted cash flow method and the fair market value method. In terms of rule 111 AUA, we are entitled to choose the method. We have worked out the discounted cash flow method, given it to the officer. Based on that, there is no requirement. He has changed the method to another method, which is not permissible, is precisely the under which he cannot change it. The option is given to me to choose which method. If he wanted, he could have found fault with the method, but he cannot change the method and say, I'll apply the net market. That is how the reasoning of the tribunal to give relief.
Section ಸ್ವಲ್ಪ illustration ಹೇಳ್ಕೊಂಡು ಹೇಳಿ. We are, at least I am alien to tax law. Section 56.
Page 1.506.
Ha.
7B. On top, Lordship put it, Miller.
Ha.
Where a company not being a company.
Income from other sources.
Yes, ma'am. That is section 56 starting.
Correct.
The relevant 56 starts with page 1.500. Income of every kind. The actual invocation is 56(7)B in our case, which comes at 1506.
1506. Where a company,
Yes, my lord.
not
Where-
being a company.
Where a company not being a company in which the public are substantially interested, this is in any previous year from any person, any consideration for issue of said that exceed the face value of such shares, the aggregate consideration received for such shares has exceed the fair market value of the shares. Provided that in this clause shall not apply where the consideration for issue of shares is received by 1 and 2. We don't come under that.
Okay.
Proviso also is not applicable to our case, my lord.
Substantive provision alone is applicable to you.
Yeah. And now for
What the substantive provision says?
if
Where a company,
if 100 rupees is the face value of the shares,
correct,
the company received 200 rupees.
okay,
Then 100 rupees is not, excess is not taxable. 100 rupees is the face value of the shares.
correct, because it's, what is above that is taxable.
Not above that.
Huh?
What exceeds the fair market value of the shares. I may be having a share at 100 rupees, but taxable is what is at the fair market value of the shares. So you have to, now the question is how to determine the fair market of the shares. Rules have been made. Rule 110 UA. The Lordship may see that rules also, my lord. The point is the sections, to give an example, my lord. Face value of the shares is 100 rupees.
Correct.
I have collected 200 rupees from the party who subscribed to my company. But my fair market value is,
It need not be the premium value at all,
it can be 210, it can
or
be,
it may be less than that.
if it is less than that, the difference is taxable. If it is more than that, the difference is not taxable.
Fluctuation and hang address ಮಾಡ್ತೀರಿ?
Lordship?
Our value
Hmm.
keeps on changing
No, but on the date of subscription,
as on the date of
on the
subscription.
date of, it will not change. That is why the law has given us two methods. One method is the net asset value method. Another is the discount is given to the assessee to choose it. In this case,
Whichever method you want to.
we want to choose.
You can switch over to other method also.
There's only one
No,
incident.
out of the two.
Out of
For
the-
some years you will do this one, and for no, other block period you will go.
It is in respect of the transaction. Suppose this year I have done a, it is because
Method
subscript-
is transaction specific.
because basically, my lord, the issue is with reference to the premium is on account of subscription. I subscribe on a particular date in this year, in the assessment year 13-14. That means April 12 to March 13 I subscribed. That year, whether I can keep changing transaction wise is not so far decided by any court, because most of the time people will follow for that assessment year only one method. Suppose in the same year there have been two tranches, whether the assessee could follow one tranche or not is not. So far,
Anyway, that's not the
not
subject
the
matter of
subject.
case.
I'm only enlightening a lordship. A lordship put a very relevant point whether you can, because I told the lordship transaction wise. Normally in practice, it is the assessment year wise. On a particular assessment year, you have a choice to do it a net method, net value method, or the both methods have got a formula. Your lordship may say 100.
In other words, focal point of this is the market value of
Yes,
the share.
fair market value.
Fair market value.
How the fair market value is determined is by two processes, either of the two. And here we have followed a discounted cash flow. And the tribunal has said the discounted cash flow is 198. And you have charged only 165. So the question of 56(7)(b) does not attract.
Yes, sir. What do you say?
My lord, the assessing authority, my lord,
Hello, where
Yes,
is the
yes.
error with the, what is the question of law you have framed?
please.
Now I have understood the section, how it operates. What is the question of law you have framed? Let us see. You have structured your first question on the assumption that premium value is the basis, when the fair market value is the focal point of section. That's his question. Your first question of law is structured on the premise of the premium value, whereas section says fair market value. And to arrive at fair market value, there are two methods. One of them he has adopted. ನಿಮ್ ಕ್ವಶನ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಹೇಳ್ಬಿಟ್ಟಿದ್ರಿ, ಪ್ರೀಮಿಯಂ ಕಲೆಕ್ಟೆಡ್ ಫ್ರಮ್ ಕ್ಲೋಸ್ಲಿ ಹೆಲ್ಡ್ ಕಂಪನಿ ಅಂತ ನೀವು ಹಿಂಗೆಲ್ಲ ಹೇಳಿರಿ. ಹಾಗಾಗಿ ದಟ್ ಕ್ವಶನ್ ಡಸ್ ನಾಟ್ ಫಿಟ್ ಇನ್ ಟು ದಿ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಆಫ್ ಸೆಕ್ಷನ್ 56(2). Second question. The circumstance of the case that tribunal's order is perverse in nature in deleting the additional signs of pertinent to share premium collect. Again, that second is also same. Nodkalam. Revenue is in appeal. Kudgoli. Before this court. For laying a challenge to the tribunal's order dated 13/9/2022. With the following substantial questions of law. First off, learned panel counsel appearing for the assessee vehemently submits that the tribunal has wrongly construed section 56(2) of the
7B.
56(2) Roman 7 small b jategene of the IT Act, and thereby committed error of deleting addition made under section, under said section, in an amount of rupees 33 crore 71,77,500 towards share premium. First up.
May I intervene, my lord? The facts are in page 13, my lord. In
Yes.
page 13, para 4. In page 13, para 4. Last 3 lines. During the assessment year. In page 13.
In page 13, the order of the tribunal
Allala, that is the order of assessment.
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 Ha,
Annexure A,
page
Para
13, para 4.
is during the just simple narration of facts.
Okay. Nodama. Brief facts of the case ankondu. Page 13, paragraph 4 ಇದೆಯಲ್ಲ ಅದನ್ನ reproduce ಮಾಡಬೇಕು. Brief fact matrix of the case as succinctly stated by the assessing authority ತಾನೆ?
Please.
Authority is reflected in para 4 of his order dated 30 March 2016, correct? 2016. Next. Then question. Next paragraph. The tribunal has construed the subject provision of the act, keeping in view fair market value of the shares in question and not the premium amount, comma, since one of the statutorily designated methods have been adopted by the assessee. First off, the questions framed by the revenue do not fit into the building blocks of the subject section in as much as premium value as contradistinguished from fair market value to be arrived at by the designated method, one of the 2 designated methods. First off. Next one. In the above circumstances, these questions do not arise.
Page 56 may be necessary, my lord. The observation of the tribunal in para 18 may be.
We should reproduce that also.
It may be relevant.
Very
Page
simply, we are saying
56.
that you have.
Allah,
framed
that is
your
observation of the tribunal. 18.
question. Page?
Page 56
Page
para 18.
56 para 18, my lord.
First. Next paragraph. The tribunal at paragraph 18 of its order,
18 and 19.
18 and 19 of this order has observed as under. First off, we agree with the same. Next, in the above circumstances, appeal being devoid of merits is liable to be dismissed, and accordingly it is. Okay. Little changes the order will undergo. After again, we'll see that, but the operative portion remains intact.
Keep you applied.
Okay. ಅಲ್ಲಿ ಯಾವ ರೂಲ್ ಹೇಳಿದ್ರಿ ನೀವು? 2 methods ಹೇಳಿದ್ರಲ್ಲ, ರೂಲ್ 100 ಅಲ್ಲಿ ನೋಡಮ್ಮ, ರೆಫರ್ ಟು ರೂಲ್ 111
11 UA2.
U capital
U capital A capital.
UA2 of the rules. Okay.
Like your lordship, in the book, what will happen is, my lord, is that the rule, I mean, it must be, the option is there in the act also. It is down below in that, not in the main. It has got undergone a change last month. I'll give the correct
ಅದ್ರದ್ದೊಂದು xerox
copy ಇವಾಗಲೇ xerox ಮಾಡಿ ಕಳಿಸ್ಬಿಡಿ.
Xerox
In half an hour.
section ಮತ್ತು ರೂಲ್ ಎರಡನ್ನೂ
ಮಾಡಿ.
Okay. Yes.
Lordship, in this case, your lordship, the
When have you
respondent.
changed your name? Or ಅಪ್ರಮೇಯ delete ಮಾಡ್ಬೇಕೇನು? ಇಲ್ಲ.
Yes, some inconvenience, he is out of station, your lordship,
Okay.
that's why,
Okay.
only for today. your lordship.
All right. Next week.
In this case, your lordship, the short question is,
ಅಲ್ಲ ಅವ್ರು ಇಲ್ದಂಗೆನೆ
please, your lordship,
ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ.
ಆಯ್ತು, ಅವ್ರು,
ಹಾ. Next week ಹಾಕೋಣ.
please.
Okay.
Lordship, I pray for 2 weeks' time, your lordship. I have to give a detailed synopsis in this matter.
2 weeks at the request of.
Please, your lordship.
Ah.
Lord, here is a case. What is the meaning of concurrent jurisdiction, my lord? Your lordship, that side, sorry. Apologies. Your substantial question of law which I raised is at page 38. Out of which question of law raised at page 32 will not survive. Because they have issued, we have filed an MP and they have given a relief to us, my lord.
Substantial question of law.
In paragraph 32, we are not pressing, my lord.
32 you do not press.
Because we have already, it was not, our ground here is they have not adjudicated in this order. We also filed a MP. MP, they recalled the order and they say, given us some relief, which they are happy, so that doesn't survive anymore.
ಈಗ 30, 31, 33.
Lordship, all are rising to the same thing in as much as what is the difference between joint jurisdiction and concurrent jurisdiction? There are some various circulars, my lord. At the admission stage, I am taking a lordship briefly. What has happened is, my lord, in the scheme of the Income Tax Act, assessing officer, deputy commissioner, joint commissioner, commissioner, then the board. The board issues a direction to the commissioners to allocate the work between the officers. Now they have allocated the work to, in this case, to Officer Chitradurga, ITO Ward 1, Chitradurga. But he issues the notice, he starts a proceeding. Later it is continued by joint commissioners to complete the order. Now the whole issue, my lord, is can one officer start and another officer complete when admittedly concurrent jurisdiction is there. So the Delhi High Court in the case of Wolverine has said there's a difference between concurrent and joint. So a
difference.
Joint means, concurrent means once a person starts, he must terminate it. Concurrently they have. Joint means A can issue one notice, B can issue another notice. Both of them can parallelly proceed with the matter. That is how the Delhi High Court has evolved the issue. This matter, I'll file all the case compilation and then argue the matter whenever my friend is ready. This is a short point in this case is the difference between concurrent and joint jurisdiction. All these three questions attribute to that.
Okay. Judgments and ಮೊದಲೇ ಕೊಟ್ಟಿವಿ, so that we'll read and come back.
Yes, my lord.
After 2 weeks ಹಾಕೋಣ.
Lordship want admitted or?
Admit ಮಾಡ್ಬೋದಾ? ಬೇಕಲ್ಲಿ. Appeal is admitted on the following substantial questions of law. ನೋಡಪ್ಪ.
30, 31.
Para 30,
31 and
31, 33. Okay. ಅಲ್ಲಿ ಆ ಜಡ್ಮೆಂಟ್ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಸೈಟ್ ಮಾಡಿರಲ್ಲ ಅಂತ ಹೇಳಿ. In view of Delhi High Court judgment
Wolverine.
in decision, Delhi High Court decision.
Wolverine Cummins Limited, 307 ITR 103 Delhi.
ಬರೆದು ಕೊಟ್ಬಿಡಿ.
ಕಾಪಿನೇ ಕೊಟ್ಬಿಡ್ತೀನಿ.
Good.
You will come.
Right, good.
You take the copy and write one.
Yes. Yes.
My lords,
Ah,
the substantial question of law, my lords, are at page 51. The grounds relate to, the question of law relate to, my lords, limitation issue and transfer pricing, my lords. The first two questions, my lords, are with respect to interplay of section 153 and the issue that in the case of a draft assessment order, my lords, we had submitted before the honorable tribunal that the draft assessment order is barred by limitation under section 153 read with the provisions of TOLA. My lords, the tribunal has held that there is no time limit prescribed for draft assessment order under section 153, my lords. This honorable court in Tally's case, my lords, in this
ಯಾವುದೋ ಒಂದ್ ಕೇಸು ಹುಯಿಲ್ಗಳು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಲ್ಲಿ ಇಂಥದ ಪಾಯಿಂಟ್ ಇದೇ ರೀತಿ ರಿಲೇಟೆಡ್ ಪಾಯಿಂಟ್ ಇತ್ತ ಪೆನಲ್ಟಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅನ್ನೋದು ದಟ್ ವಾಸ್ ಎ ಪೆನಲ್ಟಿ ಪ್ರೊಸೀಡಿಂಗ್.
My lord, so the issue is, my lords, the section 153, whether it applies to draft assessment order, my lords. The honorable tribunal has held that the one provisions of section 153 do not apply to draft assessment order, my lords. This honorable court, my lords, in the case of Tally, has applying provisions of section 153 held that
limitation
draft assessment order is barred by limitation, my lords.
So tribunal's reasoning runs to counter the view of this court.
Yes, my lords.
But the second question ಏನದು?
Second
ಅದು
question,
ಸೇಮೆ.
my lords,
1 and 2 are connected with each
1
other.
and 2 are connected with each other, my lords.
The third one is
Third one is a slightly different issue, my lords.
144C.
144C, section 12 and subsection 12 and 13, my lords. The point here, my lords, was, if I can take my lords to finding on this of the tribunal, which is at page 123 of the appeal papers, my lords, and internal page 68, my lords. My lords, I can take my lords also to refer section 144C 12 and 144C 13. my
ಇಂಥದೇ ಒಂದು ಮ್ಯಾಟರ್ ಅನ್ನು ನಾವು we are admitted almost on similar questions. 2 matters. ತಿರುಮಲೇಶ್ admit ಮಾಡೋಣ.
Yes, sir.
ಬರ್ಕೊಳ್ಳಿ. Appeal admitted on the following substantial questions of law. ಯಾವ question of law question mark ಇಲ್ಲ.
My lords, 1, 2.
Question mark ಎಲ್ಲಿದೆ?
Oh, apology.
ನೋಡಲಿ page 51, 52. Okay. Question mark ಮಾಡ್ಕೊಡಿ. ಕೊಡಿ. Question mark ಹಾಕಿ ಕೊಡ್ಬೇಕು. ಎಲ್ಲ ಅಸರ್ಟಿವ್ ಸೆಂಟೆನ್ಸ್ ಇದಾವ.
Sales tax matter. Aditya is
not there today.
so your lordship may consider. I also
Next week ಹಾಕೊಂಡು you are ready in the matter?
week after a week.
Week after next.
We'll read Saturday.
Okay. Lordship, I am appearing on behalf of the respondent in this matter. Yes.
Lordship, for the sake, kindly pass over the matter, lords, senior appeal.
Pass over.
Your lordships.
Is he on his feet?
Yes, your lordships.
Pass. Then next week ಹಾಕೋಣ ಅಂತ ಏನು?
So, yes, your lordship.
Can you put this next week? Oblige, your lordship. I'm grateful.
Grateful, your lordships.
Let's, in this matter, I had mentioned in the morning, Millards may recall. Millards, we have approached under the Vivad Se Vishwas scheme. So Millards, we keep it up after 2-3
Why are you
weeks.
keeping those applications? To take a decision on that.
I don't know whether it's been filed or not.
It is filed. Madam is saying it is filed.
It is filed, Millards.
Learned counsel appearing for the assessee submits that the assessee has applied for the benefit under the Vivad Se
Vishwas scheme.
Vishwas
Vishwas scheme, my lords.
and decision needs to be taken by the revenue. First,
3 weeks.
the jurisdictional authority is directed to take a decision and communicate the same to the assessee within an outer limit of 4 weeks. Failing which, his personal presence may be required in the court. Okay. Call this
Grateful, my lords.
after 4 weeks.
One submission.
Ah.
Sorry,
Ah.
Lordship directed that the Vivad Se Vishwas scheme.
Ah.
1 minute. Just I thought your Lordship passed an order, I should assist.
Ah.
The scheme is they are supposed to pass an order within 15 days from the date on which we file.
Okay.
But the practical problem that the department is facing is, these are all very old appeals.
Ah.
And the credit for taxes are, can give it only what is lying in the portal. Even I have a few of the matters that they are working out a scheme by
So
which
simple illa.
it is not, ultimately they are supposed to give them 15 days. The moment they give the form 1, I will come and withdraw this appeal. That is I can't do that, but the form 1, we ourselves are telling them, don't give form 1. Because the form 1 means they will give only what is lying to my credit in the portal. But actually my TDS is much more than that. And if I get that lesser amount, I lose the refund or I have to pay taxes. So there is a practical problem. So department itself is taking.
6 weeks madana.
ಮಾಡಿ
ಅಥವಾ
ಬಿಡೋಣ,
8
then
weeks
it-
ಮಾಡ.
ಹಾ,
8 weeks.
And asking them to complete it because ultimately the portal,
ಅಲ್ಲೇ
CPC.
is requested to them, directed only. Okay.
Sorry, madam.
Correct.
Because
Otherwise ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ?
the
We are very
practical problem is-
alien to your taxation. ಈಗ ಗೊತ್ತಾಗ್ತಾ ಇದೆ tax how it operates.
To the department and asking them to correct our various things. Deeply obliged.
Thank you. Yes, Mr. Kulkarni.
A very short issue, my lord. I'll just give the background of the case. Here, the appellant is a Hindu unrelated family. The
HUF.
assessment, yes, HUF, and the assessment year is 2009-10. What happened, my lord? The appellant has various sources of income under different head. One of the sources, he is into money lending, so he earns interest on the money, whatever he has lent. And also, he has borrowed also money. On the borrowal,
He gives interest.
he gives interest. The short issue is, when I receive interest, when I give interest, whether the net has to be brought to tax or the whatever I received interest, the whole amount has to be brought to tax. That is business income. Section 5 is very clear. I will not trouble my lord with that. But there is some other facts which I have to place it before my lord. What happened, my lord? If the money is borrowed and if I am paying interest, and suppose if I give it to the relatives or sister concerns, and if I am not collecting interest from them, that I cannot claim it as a business expenditure. That means I cannot claim it as an expenditure. That's how the department disallowed in this particular case. I will take my lord through the orders and all that. About 93 lakhs of rupees, they said, this is the amount on which you are not entitled to claim as an expenditure because it is lent to the sister concerns or to the relations from whom you are not collecting the interest. So this interest will not be allowed as a business expenditure. But with the same person, one I will name now, that is B.V. Reddy and Sons HUF, I have given the money also. And I have borrowed also.
From the same person.
Same person. I will take my lord through that. It appears in the 42 of my paper book. And there I said, okay, you disallow, it's okay. But you disallow to the extent what I have already earned interest. You cannot only disallow here, you cannot bring. That figure has to be brought to tax. That is the only dispute here. If I may persuade my lord to see.
Which section governs this issue?
Section 28.
28.
28. But if it's a business income, what is to be done is the total income has to be brought to tax. And if it is not for the purpose of business, then it will be disallowed. I myself am agreeing for that. I am not saying no to that, to the extent. If I persuade my lord to see only one page.
May I persuade my lord to see page 42? So that when we go to the further this thing, order and all, it will be clearer. Yes. My lord may see expenditure side. This is the income and expenditure account for the year ending 31/3/2009, relevant for the assessment year 2009-10. And if my lord runs it eye down, interest, BVR and S, finance, 93 lakhs of rupees. My lord will get it. At the left-hand side, 93,63,712. My lord is. Then my lord may kindly see the income side. There, PV Reddy and Sons, that is BVR and S, finance only. That is 61 lakhs 20,000. 20,000. What happened, my lord? 61 lakhs 20,000 I earned. 93 lakhs I have claimed as a deduction. Since this is the related company and all that, they are not giving that expenditure as an allowance, deductible allowance. Then my case is the difference of the two. 93 minus 61. Which comes to around 23, something like that. 22. 20. That may be brought to tax. That's all my case. Now my lord may kindly see at page 50, that is my ledger account. Why tribunal did not favor your case? I will take my lord. Page 50, my lord. Just to drive home my point. Lord, may can you see? This is the name of the this thing, appellant and all. BV Reddy. This is ledger account in my books. BV Reddy and Sons Finance ledger account in my books. My lord may kindly see the last two items. Interest account. My lord will get it. 93,63,712. Same amount. In the credit, it appears in the credit, right? Okay. And then the next one, 61 lakhs 20,000. Correct. About 22 lakhs to be only disallowed, not 93. Now my lord asked me a question regarding the tribunal. How did they decide the matter? The tribunal at page 16, finding on para 6, page 18. The order starts at page 16. Finding, my lord will get it at page 18, para 6. That is the operative portion. There are other issues like rate of interest and all that. I am not before this court on that particular point. May I, my lord? Yes. Regarding the second claim of the second claim of the assessee, that the interest income earned by assessee of rupees 61.20 lakhs received from BV Reddy and Sons Finance should be reduced from interest expenditure to be considered for working out interest disallowance. In our considered, my lord, can you notice? In our considered opinion on this issue, the assessee has not made out any case because we find that this is undisputed that an amount of rupees 12,38,045,350 was given by the C as interest-free advance, and this is also not being disputed that this interest-free advance are financed by interest-bearing loan except rupees 5,32,000, 5 crores 32 lakhs 46,738, which has been borrowed by the C interest-free. Lordship may kindly recall, to the extent of interest-free borrowing. To that extent, allowance is already that's fine. That may not be relevant. That's why I paused here for a minute, my lord. To the extent of interest-free borrowing of rupees 5 crores 32 lakhs 46,738, relief has already been allowed by the CIT. I am not before this court. That's what I was trying to say. Now,
ఇందాక అక్కడికి వచ్చా అది అక్కడ కూర్చొని నువ్వు తీయట్లేదని నేను ఇక్కడ ఆఫీస్కి వచ్చాను ఫోన్.
yes. Now whether this interest-bearing loan advanced by the assessee to Mr. BV Reddy and Sons Finance advanced to the extent of 5.10 crores is out of interest-bearing borrowed funds or out of own funds available with the assessee of rupees 56.96 crores approximately is relevant for this purpose, and it has not been established. Lordship may kindly notice, it has not been established by the assessee by bringing direct excess of such loan of 5.10 crores advanced by the C to Messrs. BV Reddy and Sons Finance Division for earning interest income which the interest bearing borrowed funds borrowed by the C and in the absence of such direct nexus having been brought on record by the C, this claim of the C cannot be accepted. This is what it is. Rest of the things he has, it is not relevant, my lord. Rate of interest and all, we are not on that point. Now the short question, my lord, is when I earn interest and I give interest, whether the net amount, irrespective of the source from where it comes, this is the interest I have earned. It may be a fund which is not bearing interest. What happened, my lord? I have borrowed money from various sources. It is all pulled it. It is in the hot pot. We don't know which money has gone where. It is very difficult. Irrespective of that, when I earn something, when I under the same head I pay something, it is a net to be brought to tax. That's what the section 28 says. It is the Let us see income. section 28. Yes, my lord. It is the income of the C which has to be brought to tax.
Profits and gains of business or profession.
Yes, this is a business only. I am into money lending business. Let me kindly recall that I mentioned that. Profit and gains of business or profession.
ಅಲ್ಲ ಅವ್ರ ರೀಸನಿಂಗ್ ಏನು ಅಂತ ತಿಳಿಲಿಲ್ಲ ಅದೇನೋ ಕಾಂಪ್ಲೆಕ್ಸ್ ಇಂಗ್ಲಿಷ್ ಸೆಂಟೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ವಾಟ್ ಇಸ್ ದಿ
The issue, my lord, if an SSC borrows money
Correct.
and pays interest,
Ah.
my lord, for the purpose of his business, it is allowable. So
interest
if that interest bearing funds, if they are parted to others, let us say, my lord,
others ಅಲ್ಲ ಅದೇ ಅವನಿಗೆ
it is like this. I borrow money for 12% or 14%.
Yes.
I am running a business.
Correct.
Then if I part with that money, give a loan for no interest, I am taking an extreme example, or for a very small, less interest. To that extent, my lord, it will not be allowed. That is one thing. Another thing, what has to
suppose if I keep fixed deposit in Canara Bank, okay, and we earn X amount as interest. I take loan from Canara Bank, from the same bank, some amount. On that I pay interest.
that can,
While you are working out the net value, you have to minus the interest which I pay on the amount I have borrowed from the interest which I receive from the amount I have invested in the bank. That's correct?
the issue is if I part away with the money
Ah.
and if I see that interest is charged to my account, basically, I'm just not on this issue, my lord. I borrow money for a rate of interest and charge that interest to my business account. I mean, business, my lord, affairs
Purpose.
purpose. Then if I part away with that money without using it for business, that is one thing.
But that is not the case here.
Here, my lord, what they say is, my lord, that is what they say.
BV Reddy ಕಡೆಯಿಂದ
Now,
X money ಇವ್ರು ಕೊಟ್ಟಾರೆ, Y money ಇವ್ರು ತಗೊಂಡಾರೆ. X money ಮೇಲೆ ಕೊಟ್ಟ ಮನಿ ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಬರ್ತದೆ. Y money ಇವ್ರೇನ್ ತಗೊಂಡಾರೆ ಅದ್ರ ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತಾರೆ. ಬರುವಂತ ಟೋಟಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಏನಿದೆ ನೀವು ಟ್ಯಾಕ್ಸ್ ಮಾಡೋದು ನೆಟ್ ಇಂಟ್ರೆಸ್ಟ್ ವ್ಯಾಲ್ಯೂ ಮೇಲೆ. ಅದನ್ನ ನೀವು ಅರೈವೇಟ್ ಮಾಡ್ಬೇಕು. ಏನು ಇವ್ರು ತಗೊಳ್ಳುವಂತ ಇಂಟ್ರೆಸ್ಟ್ ಮೈನಸ್ ಇವ್ರು ಕೊಡುವಂತ ಇಂಟ್ರೆಸ್ಟ್ ಒಂದು ಫಿಗರ್ ಬರ್ತದೆ. ಅದು ಇನ್ಕಮ್ ಮಾಡಿ.
that is it is purely a question of fact. Now, while appreciating that fact,
principle on what basis?
Perverse finding. It's a perverse finding.
Not only perverse finding, on principle. Taxability is on the income earned by way of interest.
please.
Okay. That necessarily has to be worked out by minusing the money which I give to the same borrower or entity, because I have also borrowed from. ಈಗ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಕೆನರಾ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಒಂದು ಲೋನ್ ನಮ್ಮ ಅಮೌಂಟ್ ಇದೆಯಪ್ಪ, 5 ವರ್ಷ ನಾವು ಫಿಕ್ಸ್ ಇಟ್ಟೇವಿ, ಅದನ್ನ ನಾವು ಮುಟ್ಟಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು ಇಂಟ್ರೆಸ್ಟ್ ಬರ್ತಿರ್ತದೆ. ನಾವು ನಮ್ಮ ಅಮೌಂಟ್ ಇಟ್ಟಿದ್ದನ್ನು ಮುಟ್ಟಂಗೆ ನಾ ಲೋನ್ ತಗೊಳ್ತೀನಿ ಅದೇ ಬ್ಯಾಂಕ್ನಿಂದ, ಅದಕ್ಕೆ ನಾ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತೇನೆ. ಅವಾಗ ಈ ಇಂಟ್ರೆಸ್ಟ್ ನಾ ತಗೊಳ್ಳೋದಕ್ಕೆ ಟ್ಯಾಕ್ಸ್ ಹಾಕ್ತೀರಿ, ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
But the interest I pay, should it not be deducted from that amount? It sounds common sense.
May I just
That
elaborate
little-
slightly,
little-
same example, my lord, please, if you permit. My lord, it's like this. Suppose instead of this BV Reddy,
Ah.
I have given money to BV Reddy, that means I earn interest.
Correct.
And I given to XYZ.
To whom?
Yes. Is it
No,
not
you
they
have taken from
I
XYZ.
have taken from him.
To
Is
him
it
you
not
will
at that
pay the
time?
interest.
If it is to be assessed as a business income, my
It should
source
be
being
minus
interest,
from that.
they would have done that.
Regardless
Because-
of whether the same person or
Absolutely.
not.
Yes, just to buttress my submission, my lord, if it would have been two different persons, then they would have said, yes, one has to be set off against the other, it's only the net has to be brought. Here it is the same person, that's why they are saying, we don't know from where it is, money is brought, and whether it is to be allowed as a deduction. It is like two different persons, from one I borrow, the other one I pay.
Question is not plurality of the persons.
Absolutely, man. I'm grateful.
Question is what is earned as interest, what is paid by way of interest. It may be from the same Arabian Sea. If I should pay interest because I have borrowed money from him.
Lordship,
In another transaction, I might have lent money to him.
lordship,
That is not prohibited by law.
Lordship.
Then no law says
lordship.
you cannot lend money to your borrower. Or you cannot borrow money from your borrower. Either way. It is open to them. Simple ನಾವು ಕೇಳ್ತಾ ಇದ್ದೇವೆ ಈಗ. ಇದು ಕಾಮನ್ ಸೆನ್ಸಿಗೆ ಅಫೆಂಡ್ ಆಗ್ತಾ ಇದೆ. Sometimes legal sense is much different from common sense is also we understand. Okay. ಇದನ್ನ ಇವರು ಕೊಡೋ ಇಂಟ್ರೆಸ್ಟ್ ಅದನ್ನ ಮೈನಸ್ ಮಾಡಲ್ವಾ? ಇವ್ರಿಗೆ ಬರೋ ಇಂಟ್ರೆಸ್ಟ್ ಮೇಲೆ ಯು ಆರ್ ಎಂಟ್ರಿಟಲ್ ಟು ಲೆವಿ ಟ್ಯಾಕ್ಸ್, ಆಲ್ ರೈಟ್. ಇವ್ರು ಕೊಡೋ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆಯಲ್ಲ ಅದನ್ನ ಮೈನಸ್ ಮಾಡಲ್ವಾ? Kindly come to page 18, para 8, 6. ಏನ್ ರೀಸನಿಂಗ್ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ಅಥವಾ ನಮಗೆ ತಿಳಿತಾ ಇಲ್ಲೋ ಟ್ಯಾಕ್ಸ್ ಲಾ ಏನಂತ ಗೊತ್ತಾಗಲ್ಲ. ಈಗ ಅವರು BV ರೆಡ್ಡಿ ಬದ್ಲಿ BV ರೆಡ್ಡಿ ಹತ್ತಿಗೆ ಅಮೌಂಟ್ ಅನ್ನು ಅವ್ರಿಗೆ ಲೆಂಡ್ ಮಾಡ್ಯಾರೆ, ಇನ್ನೊಬ್ಬ RM ರೆಡ್ಡಿ ಹತ್ರ ಬಾರೋ ಮಾಡ್ತಾರೆ. ಅವಾಗ ನೀವು ಕೊಡ್ತಿದ್ರೆ ಇಲ್ಲ? ಇಬ್ರು ಎಂಟಿಟಿ ಇದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಅದನ್ನ ಕೊಡದಂಗೆ ಇರ್ಲಿಕ್ಕೆ ಬರ್ತದ?
Let the tribunal give a speaking order, proper.
ಇದಕ್ಕಿಂತ ಎಂತ ಸ್ಪೀಕಿಂಗ್?
Such as
ಅಲ್ಲ,
this
ಇದರಲ್ಲಿ
thing.
this is,
ಇನ್ನು ಉಳಿದಿದ್ದಕ್ಕೆ ರಿಮ್ಯಾಂಡ್ ಮಾಡ್ಬಿಟ್ಟಾರ ಅವರು. ಇದ್ರ ಮೇಲೆ ಇದು ಹಿಂಗ್
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ
My lord, the appellant is
Now,
not
Mr.
there,
Is-
LRs are on the record, this is 9-10 year, there is no point in sending back. My lords may take any view.
because even I am finding it.
May I, my lord, I have prepared a
Makkali.
short this thing as a aid memory,
ಹಾ, ಏನದು?
Yes. If
My lordship may refer to page 50.
ಶಾರ್ಟ್
Yes,
ಡಿಕ್ಟೇಷನ್
yes,
ಕೊಡ್ಬೇಕು.
yes.
ಇರಿ ಬರ್ಕೊಳ್ಳೋದು. Assessee is in appeal against the order of the tribunal. Kindly be seated.
Lordship.
You should appreciate his fairness also.
Yes, yes, yes.
He will not speak one word extra.
No, he's.
But
we
he
have
has
known him for more
difficulty.
than 20, 25
We,
years.
if we say that, tomorrow he will not be on the panel.
No, no. Absolutely fair. I have seen him from the Harvard days.
Assessee is an appeal against the order of the tribunal. First up, he has framed the following substantial questions of law for consideration. Page 13 ನಲ್ಲಿದೆ ನೋಡಿ. 1, 2, 3. Next paragraph. Learned counsel appearing for the assessee in a very lucid and simple way submits that if income from interest earned on the money lent is to be taxed, as a matter of corollary, the interest paid by the assessee on the amount borrowed has to be minus And only thereafter, net interest amount can be subject matter of taxation. First, learned counsel appearing for the revenue vehemently opposes this submission, contending that the submission essentially involves a question of fact and therefore cannot be subject matter of adjudication at the hands of this court when the requirement is the substantial question of law. First, he also makes submission in justification of the impugned order of the tribunal and the reasons on which it has been constructed. Next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered view that when income by way of interest is taxable, comma, it goes without saying that while arriving at that income, comma, the amount which the assessee gives by way of interest on the money borrowed necessarily has to be deducted. First, contra legal position or ruling is not notified to us. First, this view accords with the provisions of section 28, 28 of the IT Act 1961 and also the common sense. Common sense. First, the observations of the tribunal at para 6 of its order runs counter to the impediment to the above reasoning. Above reasoning. First up, for ease of reference, we have reproduced the same, though we do not agree with that. First up, next paragraph. In the above circumstances, this appeal only to the extent of disallowing of interest payable by the assessee to his borrower is allowed. First, ordered accordingly.
Lordship may kindly make a reference to page 50, my lord, where the statement is given,
50.
50, which could be relevant to counter the observations of the tribunal. 50, Inc. 50. Ledger account.
Ale, refer to ledger account at page 50. Separate on paragraph, my brother.
Where both interest paid and received are noted, last two.
Correct. 93 lakh 63,000 so and so and 61 lakh 20,000 so and so. Thank you.
Lordship would
Is
like
on
to
paragraph.
mention that 61 lakh 20,000 will be allowable. as
61
deduction.
lakh 20,000.
You should be allowed as a deduction.
First off, Burkhardt, it is made clear that a deduction of rupees 61 lakh 20,000 to be granted in favor of the SSC.
Deeply obliged.
Okay. Correct. Yes. Correct. ದೊಡ್ಡ ಮನಿ ಯಾವ್ದಕ್ಕೆ ಏನಂತ
Time for you to forward and you take up forward next week.
38 is regarding the transfer where posting was contributed.
ಹಾ ಅದ ಪೋಸ್ಟಿಂಗ್ ಯಾವ ಡೇಟಿಗೆ ಕೊಡ್ತಾ ಇದೆ ಹಾ
ಅಲ್ಲೇ ಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆ.
ಹಾ
ಅವರು ಪೋಸ್ಟಿಂಗ್ ಜಾಗ ಬೇಕು ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ದಾರೆ.
ಹಾ
ಜಾಗ ಇದೆ ಸ್ವಾಮಿಗೆ.
ಹಾ.
ಅಲ್ಲೇ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ PAT ಆದೇಶ ಇರೋದ್ರಿಂದ ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿಲ್ಲ. ಅದರಿಂದ ಅಲ್ಲೇ ಕೊಟ್ರೆ ಈಗ ಅವ್ರನ್ನ ಡಿಸ್ಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಎಸ್
ತಾವು ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ನಾವು ಬೆಂಗಳೂರಲ್ಲಿ ಸುಮಾರು ಜಾಗ ಖಾಲಿ ಇರೋದು. ಬೆಂಗಳೂರಲ್ಲಿ ಇಲ್ಲಾಂದ್ರೆ ಬೇರೆ ಎಲ್ಲಾದ್ರೂ
ನಿಮ್ ಕ್ಲೈಂಟ್ ಕೇಳಿ ಈಸ್ ಎ ವೆರಿ ಗುಡ್ ಆಫೀಸರ್ ಸ್ವಾಮಿ Mr. Jayavibhav Swami, what is the matter? ಯಾಕೆ ಇವನ್ನೆಲ್ಲ ನೀವು ಕೋರ್ಟಿಗೆ ತಳ್ಳಂಗ್ ಮಾಡ್ತೀರಿ? ನಿಮ್ಮಲ್ಲೇ ನೀವು ಯಾಕೆ ಡಿಸಿಷನ್ ತಗೊಳ್ಳಲ್ಲ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳೇನು? ಹೇಳಿ. We'll call this matter tomorrow. We have many matters today. So we'll come, we have meeting also. We will complete this and then we will.
36, my lord, 36, any date convenient to us?
May I make one?
36, my lord, it's a matter pertaining to recruitment of my lord, agriculture, my lord, officers, my lord.
Nodi.
Matter requires
ಯಾವ್ದು ಒಂದು date ಕೊಡಿ.
36.
36, my lord, they have secured less marks.
Noted. I will make my,
Date.
I will make possible any date.
17.
17.
37 also.
37 also 17. Lords, may I make one submission? Yes. B group ಅಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತೆ. Hearing on IA list, it can. ಸೇಮ್ ಬರ್ತದೆ ನಾಳೆ. ಪ್ರೋಟೋಕಾಲ್ ಬರ್ತದೆ.
53 CST Act.
We have already.
I'm not saying take the opinion, I'm only saying that whether it will, I'm sticking to your lordship's judgment, I'm not persuading your lordship to change it. And whether it should be remanded to verify the.
No, sir, ವೆಬ್ ಹೋಸ್ಟ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ ಆರ್ಡರ್.
Lord, sir. Wanted the judgment.
ಬಡಿ ನಾವು ಬೇರೆದಕ್ಕೆ ಕೋದ್ಕೋತೇವಿ ಬಟ್ ಆಲ್ರೆಡಿ ವೆಬ್ ಹೋಸ್ಟೆಡ್. ಎಲ್ಲ ಆರ್ಡರ್ಸ್ ಸೈನ್ ಮಾಡಿ ಹೊಟ್ಬಿಟ್ಟೇವೆ ನಾವು. Before that, we don't get down from the chamber at all.
One is Orissa High Court, another is the Constitution Bench. Supreme Court, which is.
Madras High Court, we did not follow because it does not lay down any law at all.
Division Bench has
Correct.
strictly said on this.
Saldana ಸಾಹೇಬ್ರು ಮಾಡಿದ್ದು, ಅದು ನಜೀರ್ ಸಾಹೇಬ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು.
No, even
That
the
appears to be.
Division Bench has says the same thing. But only thing is the mention of the order, agreement order and the purchase order in the format is sufficient of the answer.
ಬಟ್ ನಿಮ್ದ್ರಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನಿದೆ ಅಂದ್ರೆ ಜನವರಿ ಫೆಬ್ರವರಿ ಮಾರ್ಚ್ 2004ಗೆ ನೀವು ಮಾಡಿರಿ ಡೀಲ್, ಅದ 2006ಗೆ. ಬಟ್ ಅಂಟೀರಿಯರ್ ಇಲ್ಲ, ಅವರು ಎಕ್ಸ್ಪೋರ್ಟ್ ಯಾವಾಗಾರ ಮಾಡ್ಲಿ ಈ ಅಗ್ರಿಮೆಂಟ್ ಬದಲಿ ಬರಬೇಕು, ಯಾಕಂದ್ರೆ ಕಾಮಾ ಅಂಡ್ ಅಂತ ಇದೆ ಆ ಸೆಕ್ಷನ್ ದಲ್ಲಿ.
That date has to be mentioned in the format to verify that whether it could be remanded.
One submission. Serial number 7, morning, my lords were pleased to nominate that committee.
Correct.
My lords, we have got the details. Apart, my lords, we have also representative of the finance department, DPR and law department also. We have just,
ಅದು ಅವನ್ನೆಲ್ಲ ಹಾಕೊಳ್ಬೇಕು, ಆರ್ಡರ್ ಕೊಟ್ಟೋಗ್ಬೇಕು.
I've just given the details. And the room number also. Sir, ಅದು ತೋರಿಸ್ತೀನಿ. ಅದರಲ್ಲಿ ಬೆಳಗ್ಗೆ ಸೆಕ್ರೆಟರಿ ಕಮಿಷನರ್ ಆಗಿತ್ತು. ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, DPR ಮತ್ತೆ ಇವರು ಲಾ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಫ್ರಮ್ ದ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಾಮಿನೇಟೆಡ್ ಬೈ ಬರಬೇಕು. ಇವರಿಬ್ರು ಬರ್ತಾರೆ, ಇವರಿಬ್ರು. ಆಮೇಲೆ ರೂಮ್ ನಂಬರ್ ಇದೆ. ಇವರೆಲ್ಲರೂ ಬರ್ಬೇಕು. ಅದೇ ಆ ತರನೇ ಬರ್ಬೇಕು, ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಅಂತಾನೆ ಬರ್ಬೇಕು.
Sir, Court Master sir. Court Master sir. Court Master sir. Sir, item 31 में क्या डेट है? Court Master sir. Sir, item 31 में प्लीज डेट बता दीजिए. Sir, item 31 में डेट. Court Master sir. Court Master sir.
After 4 weeks, madam. Serial number 31.
Yes, ma'am. Serial number 31 में date बता
All
दीजिए.
after 4 weeks, madam.
Thank you, ma'am.